The House will come to order. Today, the Pledge of Allegiance will be led by Casey Dana and Jackson Dana from Murphy Creek School, Aurora, Colorado, guests of Representative Carter, House District 20.
Please join us for the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Mr. Schiebel, please call the roll.
Representatives Bacon. AML
Excused.
Bacon is excused. Barone. Basenecker. Speaker Pro Tem Basenecker.
Excused.
Bottoms is excused. Bradfield. Bradley. Brooks. Brown. Rep. Brown.
Excused.
Caldwell. Camacho. Carter. Rep. Carter is excused. Clifford. DeGraff. Duran. English. I'll just tell you the first. Yeah, Rep. English is excused. Espinoza. Representative Espinoza is excused. Foray. Rep. Foray.
Excused.
Flanell. Froelich. Garcia. Garcia Sander. Gilchrist. Representative Gilchrist.
Excused.
Goldstein. Gonzalez. Hamrick. Hartsook. Jackson. Johnson. Joseph. Representative Joseph.
Excused.
Kelty is here. Leader on the wall. Lindsay. Representative Lindsay.
Excused.
Luck. Lukens. Mabry. Marshall. Martinez. Morrow. Representative Morrow's here. McCormick. Rep. McCormick.
Excused.
Wynn. Pascal. Phillips. Representative Phillips.
Excused.
Richardson. Ricks. Representative Ricks.
Excused.
Rootnell. Ryden. Representative Ryden.
Excused.
Sirota. Just walked in. Rep. Sirota. Is excused. Slaw. It's on the wall. Smith. Soper. Rep. Soper. Excused. Stewart K. Stewart R. Story. Sukla. Taggart. Titone. Valdez A. Velasco. Weinberg. Wilford. Winter. Yeah. AML Winter. Where'd he go? Oh, there's Soper. Got him. Woodrow. Woog. Zokai. And Madam Speaker.
Here. With 54 present, 11 excused, we do have a quorum. Representative Barone, it is your final funny. Your final funny.
Thank you, Madam Speaker. Members, good morning.
Good morning, everyone. Representative Barone, please proceed.
Members, I got in a fight with the elevator this morning, I took it to another level. So today's going to be pretty good. I used to be addicted to soap as well, but I'm clean now.
Oh, no.
I was thinking yesterday when we were on seconds that, parallel lines have a lot in common. It's too bad they'll never meet.
All right, 2 more, Rep. Barone. We gotta bring it.
All right, sounds good. Madam Speaker, I move that the Journal of Thursday, April 30th, 2026 be approved as corrected by the Chief Clerk.
Members, you have heard the motion that the journal be approved as corrected by the Chief Clerk. All those in favor say aye. Aye. All those opposed, no. The ayes have it. The motion is adopted. Members, announcements and introductions. Representative Stewart.
Thank you, Madam Speaker. Members, today's the day you've all been waiting for. It is Concrete Day. Woo! Yes. All right, yeah. Barbecue, 11 to 1 p.m., East Lawn. See you there.
Thank you, Rep. Stewart. Madam Majority Leader.
Thank you, Madam Speaker. So, we know in many of our cultures, food is where the heart is, and that's what brings people together. So I made it a tradition in the time I've been in the legislature.
One moment, Madam Majority Leader. Thank you, members. If you could keep your voices down. Appreciate it. Madam
Thank you.
Majority Leader.
Thank you, Madam Speaker. Let me start over. Members, I know that food is where the heart is, and that's what really bonds our relationships. Every year, once a session, I try to provide a meal for all of us. It's a bipartisan thing, and today we are going to have lunch provided by Illegal Pete's. It'll be set up in the space back here with Kathy's office down this way around noon. So we would love all of you to partake and enjoy.
Representative Hartsock.
Thank you, Madam Speaker, and thank you, members. And happy Mighty Fine Friday. It's a gorgeous day out there. So y'all get 2 options today for lunch. It's a gorgeous day outside, but I'm willing to bet we're going to be in here a fair amount. So you might want to be able to steal a moment outside to go get some concrete barbecue. You might want to come back in here and grab some of the great chow that we're going to be serving up. So you get 2 choices today. If you're extra hungry, we're here extra late, you get lots of food. So yeah, there in the back, go, go, go. All right, thank you so much.
I love it. And Representative Gonzalez, maybe talk about more food.
How'd you know, Madam Speaker? Am I that predictable now? I like to eat. No, thank you, Madam Speaker. Members, Cinco de Mayo is coming up again. Last year we did a potluck, and this year we are asking all of you guys to do the same. You can bring something, or if you want to pitch for carne, we're going to grill some carne asada outside. So please bring a plate, and like my colleague from Denver says, if you can't cook, don't cook. So bring something, but we would love all you guys to participate as we celebrate the end of session, and it should be a good turnout. If you guys want to participate, I encourage you to do so.
Madam Majority Leader.
Thank you, Madam Speaker. We will have a sign-up sheet right up here at the front desk, so you can sign up for the potluck dish you want to bring, and we want lots of goodies. Thank you.
That sounds
Okay.
great.
All right.
And May 5th is which date? Tuesday of next week. Tuesday, folks.
Taco Tuesday.
Announcements and introductions. Representative Velasco.
Thank you so much, Madam Speaker and members. Today is International Workers' Day and May Day, and it started as a commemoration of the Haymarket Affair when workers in Chicago were gunned down fighting for the 8-hour workday. It became International Workers' Day, a day to remember that our labor has value, that we deserve dignity, and that solidarity crosses borders.
Thank you. Representative Bradley.
Thank you, Madam Chair. Members, It is official. I am a mom to 4 teenage boys as of today. Happy 13th, Tyler Bradley.
Aw, happy birthday. Any additional announcements? Representative Carter.
Thank you, Madam Speaker. I have guests from the greatest school district in the Colorado. If you could welcome my guests from Aurora Public Schools and Murphy Creek. They are, if they could rise, stand. Thank you. These are classmates of my daughter who sang the national anthem about a couple of months ago, so thank you.
Thank you, Rep. Carter. Representative Espinoza.
Thank you, Madam Speaker. In addition to being May Day for celebrating labor, in the United States on May 1st, we also celebrate Law Day. And Law Day was established to reflect on the role and the foundation of the country of law and to recognize its importance for society. As you know, my fellow lawyers and I often get up here to remind us of the critical role we play in writing law so that lawyers can affect the rules that we do. Happy Law Day, everybody.
Thank you, Rep. Representative Morrow.
Thank you, Madam Speaker and members. I would like to let you know I have some special guests on their way up to the Capitol today. They'll be seated up here on the side. When they get here, the Latino Chamber of Commerce from Pueblo's leadership group will be here. So when you see them, please say hello.
Great, thank you, Reps. Seeing no further announcements, Madam Majority Leader.
Thank you, Madam Speaker. I move to proceed out of order for consideration of resolutions.
Members, please take your seats. We are proceeding to business. Seeing no objection, we will proceed out of order for consideration of resolutions. Madam Majority Leader, I still need you. Sorry.
You can stay. Thank you, Madam Speaker. I move for the immediate consideration of House Joint Resolution 1030.
Seeing no objection, we will proceed to the immediate consideration of House Joint Resolution 1030. Mr. Schiebel, please read the title to House Joint Resolution 1030.
House Joint Resolution 1030 by Representatives Gonzalez and Joseph, also Senator Bright, concerning designating a portion of Colorado Highway 14 in Weld County as Mono and Matt Road.
Representative Gonzalez.
Thank you, Madam Speaker. I move House Joint Resolution 1030 and ask that it be read at length.
Members, thank you. Mr. Schiebel, please read our resolution.
Whereas on June 1st, 2014, the Greeley community was deeply saddened by the tragic loss of 2 vibrant young student athletes, Eduardo Mono Hernandez and Matthew Garcia, following a traffic accident on County Road 90 and Colorado Highway 14. And whereas both Mono and Matt were cherished members of the Greeley Central High School basketball team, recognized by their teammates and coaches for their exceptional character, sportsmanship, and infectious spirits. And whereas Mono and Matt were more than just teammates, they were symbols of the dedication and the heart that defined the Greeley Central High School spirit, leaving an empty chair on the court that the community still feels today. And whereas the tragic accident on County Road 90 on June 1st, 2014, serves as a poignant reminder of the fragility of life and sparked a renewed commitment to road safety and community support within Weld County. And whereas, in the wake of their loss, the Greeley Central family and the city at large demonstrated extraordinary resilience, coming together in candlelight vigils and memorial games to ensure that the light these 2 young men brought into the world would never be extinguished. And whereas Mono and Matt are remembered by their coaches and peers for their infectious smiles and unwavering positive energy, qualities that made them natural leaders and a friend to all who knew them. And whereas they were recognized for their tenacity and sportsmanship, embodying the grit and determination of a true student athlete both on and off the basketball court. And whereas in the years following their passing, the community has continued to honor their memory through tributes and memorials, demonstrating the enduring impact that these young men had on the lives of those around them. And whereas it is fitting and proper that we preserve the legacy of these 2 sons of Weld County by designating the site of their memory as a place of lasting honor. And whereas it is the intent of the Colorado General Assembly to ensure that the names of Eduardo Mano Hernandez and Matthew Garcia remain etched into the geography of the state they called home, serving as a permanent tribute to their youth, their friendship, and their legacy. Now, therefore, be it resolved by the House of Representatives of the 75th General Assembly of the State of Colorado, the Senate concurring herein, that the portion of Colorado Highway 14 between mile marker 165 and mile marker 167 be designated as Mono and Matt Road, that the Colorado Department of Transportation may accept and expend gifts, grants, and donations for the purpose of initial placement of signs to mark the portion of Colorado Highway 14 between mile marker 165 and mile marker 167 as Mono and Matt Road, and that the Colorado Department of Transportation may explore a cooperative agreement with Weld County for the maintenance of the signs marking Mono and Matt Road.
Representative Gonzalez.
Thank you, Madam Speaker. I want to thank you specifically and the Majority Leader for approving this resolution. This is something that is long overdue. Matt and Mono were significant people in my community, and while it's been years, they still are remembered in our community. We do some vigils and memorials for them every year. I also want to thank my aide who actually wrote the resolution because he personally knew them, he went to school with them, and I would hear such great things about them, and I think this is something that is the least that we can do. It's an honor to present this with my co-prime, to present House Bill 1030, because while they were young men whose lives were tragically cut short, they left an incredible mark in the Greeley community. And our lives are not just measured in years, they're measured in the lives of people we touch around us. On June 1st, 2014, we lost Matt Garcia and Eduardo Mono, we call them Mono Hernandez, two standout student athletes from Greeley Central High School in an accident on Highway 14. But to their teammates, their coaches, and their families, Matt and Mono were far more than just names in a headline. They were leaders on the basketball court, role models in their hallways, known for their unwavering sportsmanship and infectious spirits. For over a decade, the Greeley community has continued to gather, mourn, and celebrate the legacy of these two young men. And this resolution seeks to officially designate that stretch of the county road and the Highway 14 mark to the Mono and Matt Memorial Road. By doing so, we ensure that as people travel this road, they are reminded not just of the tragedy, but of the vibrant lives and the enduring community bond that Matt and Mono inspired. It is a small but permanent way for the state to say that their lives mattered and their memory will not be forgotten. I ask all of you to support this resolution, and I will pass it now on to my co-prime.
Representative Joseph.
Thank you, Madam Speaker. Thank you, members. I want to start by thanking Representative Gonzalez for the opportunity to be on this joint resolution with him. He's told me about this resolution since last year, and he's worked tirelessly in order to be able to bring it forth today. By naming this portion of Highway 14 as Mono and Matt Road, we're doing more than placing a sign. We're creating a permanent tribute, a reminder to every person who travels that road that two young men once lived, laughed, and inspired those around them. A reminder of the fragility of life and the importance of community. And a reminder that even in tragedy, something lasting and meaningful can be built. This designation ensures that their names are etched into the landscape of Colorado, just as they are etched into the hearts of Weld County. It transforms a place of lust into a place of remembrance, reflection, and honor. Members, today we stand with the families of Eduardo Hernandez and Matthew Garcia. We stand with their teammates, their coaches, and their entire Greeley community. And we affirm that their lives mattered, that their stories will continue to be told, and that their legacy will live on for generations to come. And today I ask you for a yes vote on House Joint Resolution 1030. Thank you.
Representative Gonzalez, this is your second time to speak. You have 8 minutes and 8 seconds remaining.
Thank you, Madam Speaker. And I just want to make a note to my community. This resolution obviously will not bring them back, but to the people back home who wanted to be here and who are watching, this is something that I believe is long overdue. And to the families of Matt and Mono, they are not forgotten. And I'm here to obviously honor their legacy because they were good people. And I hear so much about them to this day. So this is the least I think that we can do, that I can do as a representative for the community And I just want you guys to know that my heart still goes out to you, friends, family, colleagues, athletes, all of that who knew these people. And so long live the memory of Matt and Mono.
Seeing no further discussion, the motion before us is the adoption of House Joint Resolution 1030. Mr. Schiebel, please open the machine and members proceed to vote. Representative Leader, how do you vote? Representative Leader, we could not hear you. Could you try again? Can't hear you. Could you give me a thumbs up or a thumbs up? Representative Leader votes yes. Representative Lindsay, how do you vote? Representative Lindsay, I can't hear you either. Could you give me yes, thumbs up. Thank you. And Representative Slaw, how do you vote? Representative Slaw votes yes. Please close the machine. With 62 ayes, 0 no, and 3 excused, House Joint Resolution 1030 is adopted. Co-sponsors. Representative Leader, co-sponsors. Representative Lindsay, co-sponsors. Representative Slaw, co-sponsors. Please close the machine. Members, we are going to proceed to third reading. The House will stand in a brief recess. Members, we are on third reading. Madam Majority Leader.
Thank you, Madam Speaker. I move to lay over Senate Bill 43 until Monday.
One moment. The House will come back to order. Thank you, Madam Majority Leader.
Thank you, Madam Speaker. I move to lay over Senate Bill 43 until Monday.
Senate Bill 43 will be laid over until Monday, May 4th. Mr. Schiebel, please read the title to Senate Bill 143.
Senate Bill 143 by Senators Coleman and Wallace, also Representatives Wilford and Garcia, concerning updating the name of the Colorado Youth Advisory Council Review Committee.
Madam Majority Leader.
Madam Speaker, I move Senate Bill 143 on third reading and final passage.
The motion before us is the adoption of Senate Bill 143 on third reading, final passage. Mr. Schiebel, please open the machine and members proceed to vote. Representative Leader, how do you vote?
Yes.
Representative Leader votes yes. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Slaw, how do you vote?
No.
Representative Slaw votes no. Clifford. Please close the machine. With 43 aye, 19 no, and 3 excused, Senate Bill 143 is adopted. Co-sponsors. Representative Lindsay, co-sponsors. Representative Leader, co-sponsors. Please close the machine. Mr. Shebel, please read the title to Senate Bill 124.
Senate Bill 124 by Senator Wallace, also Representative Stewart R., concerning information related to the Automated Protection Order Notification System.
Madam Majority Leader.
Madam Speaker, I move Senate Bill 124 on third reading and final passage.
The motion before us is the adoption of Senate Bill 124 on third reading, final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Leader, how do you vote?
Yes.
Representative Leader votes yes. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Slaw, how do you vote?
No, ma'am.
Representative Slaw votes no. Please close the machine. With 43 aye, 19 no, and 3 excused, Senate Bill 124 is adopted. Co-sponsors. Representative Lindsay, co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1421.
House Bill 1421 by Representatives Mabry and Caldwell, also Senators Doherty and Frizzell, concerning prohibiting certain compensation arrangements in the legal profession and in connection therewith, creating the Colorado Legal Practice Integrity and Fee Sharing Prohibition Act.
Madam Majority Leader.
Madam Speaker, I move House Bill 1421 on third reading and final passage.
Representative Soper.
Thank you, Madam Speaker. Members, I'm going to be a no vote on this bill, but I do want to explain just a little bit in brief for the reasons why. I tried to on second reading. There was only about a third of the chamber present, and there was a lot of noise at that. It's important when you are looking at the legal profession. Already in the Rules of Professional Conduct, Rule 5.4, it prohibits fee sharing with non-lawyers. And then there are exceptions. For example, an office administrator, a secretary, a janitor, those people are listed as exceptions. What was enumerated in committee for the reason why we have this bill before us is two of our sister states, Arizona and Utah, have been experimenting within the sandbox, as they call it, with different models of obtaining capital. And the comment was made that in Arizona, they allow equity partners to be able to share with private equity, and that you could also affiliate with a Colorado law firm, and that's a backdoor to Rule 5.4. We further asked in committee, has the Supreme Court weighed in on this? Because law is a self-regulating profession under the Supreme Court. Every attorney is an officer of the court. We are not regulated by the legislature. We're on the judiciary side of the equation. And so there's concerns that it infringes on the separation of powers. But on the side of the equation when it comes to fee sharing, it's important to be able to give these small businesses, because law firms are small businesses, but law firms are also big businesses, the ability to find other ways of capital. And that's where Arizona and Utah have been experimenting. We certainly should support that. I look at my hometown of Delta. We're now down to 3 attorneys, actually within the county. I worry about legal deserts being created within our state. One of the individuals who testified in favor of the bill also made an offhand comment that their firm was acquiring firms on the Eastern Plains and in Grand Junction, and its legal consolidation. As you know, I'm chair of a hospital board, and our greatest fear has been healthcare consolidation and the driving up of costs for consumers. We're now seeing the same thing in the legal profession, the consolidation of law firms and the driving up of legal costs. We heard from the Colorado Chamber of Commerce that it's just the opposite. The Chamber and Big Law got together to try to prevent more lawsuits coming into play because more money equals more lawsuits. That may be one fear at the big law side, but I can tell you on the small law side, I have an even greater fear. Because if you come to rural Colorado and you take away every ability to be creative, to survive in these hard financial, economic times, what ends up happening is the only means of survival is consolidation. Because our lawyers in rural Colorado aren't getting any younger, new attorneys are not moving to rural Colorado, and it means that if the firm is sold to a big Denver firm or a big national firm and it's just their satellite location, they will give you national fees. They will drive up those costs of doing business. And we challenged some of the people who were in support. The only people we heard testify in support from the legal community were the trial lawyers. We never heard from judicial, we never heard from the Bar Association, we never heard from the Women's Bar Association. We never heard from those other bar associations that represent, by and large, the majority of Colorado lawyers. We only heard from this subset, which was the trial lawyers in support of this. And that was concerning to me, because there's a lot more to the legal community in Colorado than just the trial lawyers. And when you need someone to help you write a contract or a will or a real estate transaction, those are the lawyers that I care about, but you may have issues where you do have to go to court, and it may be a small claim issue. Not all of us are engaged in big law. Not all of us are looking at multi-million-dollar lawsuits. We may have a dispute with our neighbor over water, which is probably likely to come this year. And I worry about what this will do to driving up the costs of legal services within rural Colorado. I also worry about the separation of powers between judicial and the legislative side of the equation. This has not been an area where we've delved into. I will say in closing with these comments, I have talked to both of the sponsors. And I do appreciate that they put on a 3-year repeal date. We need the Supreme Court to interpret Rule 5.4 in light of what's being called the Arizona backdoor. And we're trying to find a means for compelling the Supreme Court over the next 3 years when the stopgap is in place, because they'll probably pass, even though I'd like to stop it here. But knowing where the writing is on the wall, that we have some provision that does compel the Supreme Court to look at Rule 5.4 in light of this fact pattern. And we're currently exploring how that looks. That's obviously major substantive, so I'm not going to offer an amendment here. There'll be something offered in the Senate. But I do want to let everyone know that I'm not just coming down here to object without a possibility of another idea. I'm coming down here, and yes, I'm objecting to this policy, but I'm also saying that if the legislature is going to encroach and we're starting down this slippery slope, I also need to come to the table and offer a reasonable idea for, during this limited time, what can we do to compel the Supreme Court to look at Rule 5.4, while at the same time back off on infringing on the self-regulation of the legal profession. And we need the Supreme Court to regulate attorneys, not the General Assembly. So I'll be a no vote. Thank you.
Representative Espinoza.
Thank you, Madam Speaker. I also rise in opposition to this bill as it is currently drafted for much of the same reasons as my colleague from Delta. However, for me, this issue is much more a question of judicial responsibility and the issue of the judiciary to come and answer this question as a matter of first impression. Yesterday, what I talked about on seconds was the responsibility of the people coming to the legislature to say, fix this and fix this now, even for a temporary basis, because we haven't gotten a decision from the Supreme Court. Well, there's two reasons we haven't gotten a decision from the Supreme Court. My understanding is that nobody's brought a complaint because there's been no issue raised with regard to the problem that we're trying to solve. And that was the most compelling testimony I heard, and I will just fill out the record a little bit more. I believe that the proponents listened to any bar people that did, lawyers that came forward, and tried to create carve-outs for them. So we heard from nonprofit organizations who run law firms, essentially, or legal practices out of law schools, and they got, and Legal Services Corporation, and they got an exemption out of this bill. We heard from the creditors bar, and they got an exemption out of this bill. So that's what concerns me is, A, there's no complaint been brought, and we didn't have a full hearing from all the other subcomponents of the bar, who might also have gotten exemptions had they been able to hear and fully participate in this process. Because remember, this is also coming to us at a very late time in the session, and so there's an issue. But going back to the exhaustion question, in the legal profession, generally things are not ripe for consideration until you've pursued certain avenues first. And under the biggest concern I have here is we did not have any lawyers pursue with the Supreme Court a determination under the rule. And I appreciate that we as a legislature can ask the Supreme Court to do so, and that's the mechanism and amendment that's being proposed to be pursued in the Senate. But I am concerned that we're acting out of line by us as a legislature putting a stamp on a measure right now without that exhaustion happening. And I just want to go a little bit further. In the committee testimony, we also heard about, well, this is like private equity coming in and buying up veterinary hospitals or other businesses, which are now creating the fear that we have that it'll increase the prices because you have that private equity driving the cost of services. We also heard that law firms, especially big law firms, are profit centers. So they already drive up the cost of litigation, which you know, if you've ever had to go to a lawyer and seek help, that's existing. But the regulation that the court puts around that is this ethical fee sharing that you can't be influenced by outside people when you're creating your profit and your structure. So the concern that I had was, and I asked the last question of the night was, isn't it true that all of the other equivalent circumstances that you cited are regulated by the state? And lawyers are regulated by a separate branch of government? And the simple answer was yes. So we have to tread carefully whenever we infringe into another branch of government's authority. And I don't believe that we've had a sufficient time to get an answer from that branch of government. And so I am encouraged by the opportunity for us to ask for that answer at the court. But that is not on the bill today. That is not what we're passing as legislation, and we're not delaying implementation of this bill subject to a time specific for the Supreme Court to say, we don't care, there is a difference between the business regulation, which is what Big Law and the Chamber of Commerce is arguing, and the regulation of lawyer practice. They can make that choice. They can say, nope, we're fine with the legislation, but we need to give them the opportunity to do that first before we impose this statute, because once we impose this statute, they themselves are in a different position in terms of answering the question. Because then the legislature has told them how to act, and it becomes very difficult in terms of them being able to exercise the true independence that they need to have as a separate branch of government. I do believe this may be a problem in the future. The lack of evidence or the lack of an ability to even bring a complaint to the Supreme Court indicates that it's not a problem right now. So I would encourage a no vote at this time and let the process work itself out, and I will be a no today.
Representative Camacho.
Thank you, Madam Speaker and colleagues. The subject of this bill, 1421, is the sharing of fees between lawyers and non-lawyers. Like many of you, we have private lives, and in my private life, I'm a partner at a large international law firm that some of my colleagues have referred to as Big Law. I am unaware of any conflict. I am unaware if this bill would affect me personally, but I recognize that each of us as elected officials have a duty to identify bills that could have a direct impact on our lives and act accordingly. Therefore, I request to be excused from this vote under Rule 21C.
So excused. Representative Mabry.
Thank you, Madam Speaker. So members, I want to be clear about what we're talking about before I get into the details. By the way, welcome to the Judiciary Committee. We meet twice a week. You all are welcome to join us anytime. So what this bill is about private equity in the legal space. Private equity in the legal space. We are trying to make sure that when you hire a lawyer, that lawyer works for you and not an investor, not a private equity firm that bought into a law practice for you. I agree with my colleagues from Denver and Delta that the courts regulate the practice of law and that Rule 5.4 prohibits non-lawyers from owning firms or shares or sharing in legal fees. And that prohibition exists for a good reason. It protects the independence of legal judgment. It makes sure that the client-attorney relationship is what is driving case management and not long-term profit motives. That is why Rule 5.4 exists. I also want to recognize that we regulate businesses here. The legislature regulates businesses. The Supreme Court regulates the practice of law, what individual attorneys do. That is regulated through actions on somebody's license, sanctions. They're regulated by being registered with the bar as attorneys. People who are not attorneys, who are investing in the legal space, will not be regulated by the Supreme Court. We need to make sure that there's an avenue to regulate these business structures, and I believe that is appropriate. I also recognize the concerns of my colleagues from Denver and Delta of the legislature encroaching on the traditional practice of lawyers regulating themselves. I also believe deeply in that, which is why yesterday, after our colleague from Delta came up and made his remarks about that, and also, by the way, in committee, I texted him after committee and said that I really appreciated his closing remarks. And we are talking about bringing an amendment asking the courts to make a ruling on this. This is actually interesting and novel. We have the ability to ask the courts to issue opinions. And we're still trying to figure out the parameters on that. I think we can do it 2 or 3 times a year, but we want to use it in this instance to ask them to weigh in on this, to say that these sorts of structures where private equity is managing law firms is not allowed. That combined with the automatic repeal, I think, should make us less concerned about us encroaching on the tradition of lawyers regulating themselves. I also want to note, my colleague from Delta talked about novel ways of law firms setting up interesting fee structures. We brought many amendments in committee, to the annoyance of committee members, which was fair, to carve out and make sure that we were preserving novel ways to structure your business and to make sure that the bill was as targeted as possible at just this one idea: private equity should not be driving case strategy. And so with that, members, encourage a yes vote. I also want to acknowledge it has been great to work with my co-prime sponsor, the minority leader. Maybe we'll be on a bill together next year. Who knows?
Minority Leader Caldwell.
Thank you, Madam Speaker. And members, like I said in committee, know the the water that the sergeants put out is not tainted. You are not seeing things. We are sitting up here together to present this bill. And some of you, probably including some of my own members, is going, what in the world is Minority Leader Caldwell, a non-lawyer, doing up there in the well with a bunch of lawyers fighting it out on the floor about a lot of legal stuff? And that's a great question. So what I'm doing on this bill is I'd like to think that I'm representing, because I'm not a lawyer and there's a lot of things that I don't understand, the business side of this, and that's Colorado businesses. There's a reason that the largest organization in the state of Colorado, as far as representing businesses, has made this bill a huge priority for them, as well as trial lawyers here in Colorado, and that's because of the issue that we've seen here and across other states. So there's been a lot of talk about Arizona and Utah with similar legislation and the back and forth that's went on there, but there are other states out there. And some of the states I'm familiar with is Florida, Texas, and Georgia as well, has either are addressing these issues or has already addressed these issues. And what it comes down to, and the reason the business community has gotten so involved in this, is because of the perverse incentive structure that we've seen with private equity firms funding law firms here in Colorado, and the perverse incentive structure of bringing forward lawsuits and actions against Colorado businesses that hurts those businesses, and the system of this incentive structure of, filing more lawsuits per year in order to hit quotas, getting certain percentages with settlements, dragging out lawsuits against Colorado businesses. That's the perverse incentive structure we're talking about, and that's why the business community has gotten so involved in this. The example that I gave in committee and I gave here yesterday was when we're talking about the law profession. When a person or entity, whoever it may be, sues whoever over something, sues a business over an issue, that is to right a wrong. That is to get justice, right? And the example that I keep giving is, would we be okay in this chamber if we said, you know what, law enforcement officers, you get a percentage of the tickets that you write? Do we think that would create a perverse incentive structure? Do we think that would cause injustice? If you told an officer, you know what, you get 40% of the fines that you write, do we think that the fines would go up? Do you think that there would be more tickets written? Do you think the tickets would be larger? Do you think you'd get as many warnings? And I think the obvious answer to that is no, right? Because there's a perverse incentive structure there in the pursuit of justice. And that's what we're talking about here with law firms. The law firms are pursuing justice. They are righting a wrong. It is about access to justice. And when you have private equities taking a stake in the number of lawsuits being filed, how much they get from those lawsuits, whether they benefit more from dragging out or filing very large lawsuits and then settling very quickly to get a quick payout, that is a perverse incentive structure. And what we heard from the business community when the chamber came and testified, they talked about the business climate here in Colorado, and they talked about that it is a very litigious state, and that this is just adding a whole new layer to it that is something that is becoming more and more prevalent across the country, which is why you're seeing Utah and Arizona and Florida and Georgia and Texas all starting to address this. And this is a large enough issue that it is getting national attention. And my co-prime and I just had an interview with a national news outlet yesterday who saw this bill and are very interested in it because this is a thing we're seeing all over the country. So again, for me, it comes back to the perverse incentive structure. And is this how we should be doing law and lawsuits in the state of Colorado? And do we want to continue putting that burden on our businesses? Because again, it was businesses that showed up in committee and said that this is hurting us. And it's only going to get worse. It is only growing. And that's why I'm on this bill. Thank you very much.
Representative Soper, this is your second time to speak. You have 3 minutes and 16 seconds remaining.
Thank you, Madam Speaker, and I'll be brief. I just want to say one thing that I had heard mentioned down here about the profit side of law firms. Law firms are incredibly profitable enterprises, especially big law firms. That's why Big law firms, and I know some know this in this chamber, you have billable hour requirements. The average is 1,800 hours a year that you have to bill to your firm. A third goes to you, a third goes to the overhead, a third goes to the partnership as a typical breakdown. There's also a motivation to settle early, to get that quick payout, regardless of if you have any other form of capital involved in the law firm at all. Because if you can get that quick settlement, all of a sudden you do less work as an attorney, you get your fee and your percent, or even a contingency of whatever that settlement is, and then you move on to the next case. So already, the way law works, it's set up to be a profit motivator. I know I mentioned in committee that since the time of Rome, we have been justifying fees in the profession of law. It was Gaius was probably the last person who was under this situation where in ancient Rome, the aristocracy worked for free. They believed that that was their duty to society, was to give legal service out because the plebs couldn't read, the aristocracy could argue, the plebs couldn't before a praetor. And then Gaius came along, he was poor, he came up with the idea of fees, and we have developed that ever since. From Great Britain to the United States, we have been refining this. Even in Great Britain, I want to say this to all the trial lawyers listening. You are self-employed in Great Britain as a trial lawyer. You cannot affiliate with a firm. Imagine that in the United States. If we really want to cut off the perverse incentive for making a profit, tell all of the trial lawyers, be self-employed. You no longer get to affiliate with a firm.
Representative Soper, you have 50 seconds remaining.
Thank you, Madam Speaker. This bill, in my opinion, is too ripe for adjudication. We need to go back and tell the trial lawyers, file their complaint with the Supreme Court, let the Supreme Court weigh in under Rule 5.4. If we don't like the decision, then we can take it up. But the fact that they didn't file any sort of a complaint with the Supreme Court under the current structure should give rise to pause and a no vote. Thank you.
Representative DeGraff.
Thank you, Madam Speaker. I just want to thank the sponsors for the clarification in the elimination of the perverse incentive in justice. Because at first I thought you were talking about civil asset forfeiture, but that's finance on Tuesday, and it hasn't reached the floor yet. So I appreciate the clarification.
Representative Mabry, this is your second time to speak. You have 5 minutes, 56 seconds.
Thank you, Madam Speaker. I'm not going to take hardly any time. Again, members, welcome to the Judiciary Committee. I just wanted to respond to my colleague from Delta and say the distinction that's important here is, yes, of course, there's a profit incentive for attorneys who are working on cases, but they have a duty, an ethical duty to their client. The distinction that we're drawing here is when people who do not have an ethical duty that is regulated by the Supreme Court to their clients have a say in how case management is going. That's the important distinction in this bill.
Representative Garcia.
Thank you, Madam Speaker. Members, I also serve on the Judiciary Committee. I want to first acknowledge, I know that there's a lot of conversation really quick about lawyers and stuff, and I want to just say, I think we tend to dehumanize lawyers a little bit, and what I just want to say that what I've seen in committee is that's actually far from the truth. I think that our members show up with both their hearts and minds. With that aside, as one that's not an attorney on the Judiciary Committee, the only perspective I can bring is really just my heart and experience. And when I am presented with a bill that is saying, hey, should we allow an entity that has nothing to do with the field of practice purchase and direct the field of practice, my initial reaction is, what? Absolutely not. Because if you have an entity that is not directly related to the field of practice, non-lawyer entities purchasing law firms that then end up directing the course of law, the course of the direction in which the lawyers take a case. The only thing that does for me as a non-lawyer when I will eventually need one, because I guarantee every single person on the planet eventually needs a lawyer at one point in their life, I will not be able to trust that lawyer. I will not be able to trust the lawyer that works under an entity that is held by private equity to have my best interest at heart. By making sure that we are protecting the integrity of the practice of law, whether it's the business of law, as I heard the great AML say, or the practice of law, protecting the integrity of the practice of law means that we cannot let it be corrupted by profiteering, non-related entities. So that we can all, when we need an attorney, so that we can all trust that that person will have our best interest at heart, I ask for an aye vote.
Representative Espinoza, this is your second time to speak. You have 4 minutes, 49 seconds.
Thank you, Madam Speaker. And I just want to rise again to this last point in terms of why this is an issue that needs to go to the Supreme Court and not be decided by this legislation. My good colleague from Adams County is explaining the exact reason why I believe the Supreme Court is the person to answer the question. Because the question for me is that fee sharing? If what she's talking about, and what the bill is talking about, private equity, if private equity is engaging in any formula which requires a fee sharing between the lawyer's work and that private equity, that clearly falls under the 5.4 rules of professional conduct, which is precluded. And as an attorney, if I were to engage in that contractual relationship with private equity, I believe my law license could be suspended and/or I would be punished because of the professional responsibility rule. That's the question we're asking the Supreme Court, or believe that the Supreme Court should have jurisdiction to answer before we as a legislature work, because we are unique from other businesses and we are regulated by the Supreme Court. So I just wanted to clarify that, because I think my good colleague from Adams County is trying to explain to you the concern from a clear business standpoint, but this is important to understand the distinction between our profession, which our license is on the line if we were to engage in these contracts. I'm not licensed in Arizona, so I don't have the authority to do that in Arizona. And my personal situation is I'm licensed in Utah, Texas, and Colorado, which requires me to meet the obligation of all of those ethical states. And I have to take in terms of meeting that ethical responsibility and not losing my license, I have to look at which of the licenses have the most restrictive regulations for me. And currently, that is Colorado, which is, even though it's been silent on this question, which is saying there is no fee sharing allowed. If there's no fee sharing allowed and I as a lawyer enter into an agreement with a private equity firm out of Arizona or a law firm that is engaging in and sharing profits with private equity, I believe my license would be on the line, but that is a question the Supreme Court needs to answer.
Representative Luck.
Thank you, Madam Speaker. 2 points that were just raised just now I think are important to respond to. The first is as relates to the idea that private equity shouldn't influence the care for folks, shouldn't speak into these particular conversations because the service that the lawyers provide may be diminished by their voice. I think it stands as a good analogy that we allow that in the healthcare space. We allow that kind of investment when it comes to those determinations, and those interests aren't always aligned with what's in the best interest of the patient. So that's an analogy there. The second thing that I would just point out is, let's say you have two folks who want to start a partnership law firm and need to take out a mortgage in order to purchase the building that they want to purchase where this is housed. I think the question stands as to whether or not that would be prohibited under this bill, whether they would be able to invite a bank into that in this way, because is that then an outside investment interest that their fee sharing would be paying? It is a question that, frankly, I haven't dived into, but I think is worthy of consideration as we have this conversation.
Representative Kelty.
Thank you, Madam Speaker. Yesterday I came up, this bill has been perplexing me for a while, because though I do not come to this with a lawyer mind, but I come to it with a business mind. And so I've been going back and forth, like, is it going to hurt small businesses? What is it going to do? And I was in strong opposition, but after doing a lot more research, more conversations, basically, in the law, as one of the non-lawyers in judiciary, in plain person speak, what's happening is outside entities, outside the state entities, are basically reaching into Colorado. They're using a loophole to sue our businesses, our small businesses here in Colorado, and they're just getting fed up with it. So they are actually in support with the State Chamber of Commerce, who is, of course, very business supporting. And they are like, please help us. And the Chamber of Commerce is standing behind this legislation because so many of our businesses are being harmed by these outside entities. And so these outside non-lawyer companies are then, when they reach in, working with the law firms here in Colorado, they're like, okay, well, we're going to partner up, but we're going to require you to have so many lawsuits of different types, and pressuring them, in a sense, to sue even more. And of course, that is making our businesses, small or large, medium, whatever size, suffer. Basically turning them into what I would call an ambulance chaser, which we usually say most lawyers do, but we know that's not true. But we assume that because that's what we see on TV all the time. But that's not true. And so I was a no yesterday. I am a yes today, because when our businesses speak in Colorado and they're saying we're being harmed, even though it's not our realm in these law firms, I think we should listen. So I will be a yes today.
Minority Leader Caldwell, this is your second time to speak. You have 5 minutes, 31 seconds remaining.
Thank you, Madam Speaker. And thank you to my colleague from Colorado Springs. I really appreciate that. Members, I'm just going to simplify this one last time before I leave and we take this vote. And this is making sure that lawyers are managing your case and not investors. It really boils down to that simple. Thank you.
Seeing no further discussion, the motion before us is the adoption of House Bill 1421 on third reading, final passage. Mr. Schiebel, please open the machine and members proceed to vote. Representative Leader, how do you vote?
Yes.
Representative Leader votes yes. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Slaw, how do you vote?
No, ma'am.
Representative Slaw votes no. Members, we are on thirds. It's not funny. Please close the machine. With 51 aye, 10 no, 4 excused, House Bill 1421 is adopted. Co-sponsors. Please. Oh, Representative Lindsay and Leader are co-sponsors. Please close the machine. Madam Majority Leader. Madam Majority Leader.
Thank you, Madam Speaker. I move to lay over Senate Bill 12 until Monday.
Senate Bill 12 will be laid over until Monday, May 4th. Mr. Schiebel, could you please read our reports of committees of reference?
Committee on Appropriations, after consideration of the merits, the committee recommends the following. House Bills 1004, 1014, 1043, 1054 is amended, 1059 is amended, 1065 is amended, 1111 is amended, 1117 is amended, 1230, 1289 is amended, 1327 is amended, 1328 is amended, and 1423 and Senate Bill 6 is amended, 35 is amended, 48, 141, and 147 be referred to the Committee of the Whole with favorable recommendation. Committee on Education, after consideration of the merits, the committee recommends the following. Senate Bills 23 and 78 is amended, be referred to the Committee on Appropriations. Senate Bill 80 be referred to the Committee on Finance. Senate Bill 145 be referred to the Committee of the Whole with favorable recommendation, and House Bill 1292 be postponed indefinitely. Committee on Energy and Environment, after consideration of the merits, the committee recommends the following. House Bill 1337 be amended as followed, and also amended be referred to the Committee on Appropriations. And Senate Bills 2 and 142 as amended be referred to the Committee of the Whole with favorable recommendation. House Bill 1246 be postponed indefinitely.
Thank you. A well-deserved woo-hoo. Introduction of bill.
House Bill 1429 by Representatives Brown and Sirota, also Senators Bridges and Kirkmeyer, concerning the consolidated administration of public assistance programs.
House Bill 1429 will be assigned to the Committee on Appropriations. Introduction of resolutions.
House Joint Resolution 1031 by Representatives McCluskey and Duran, also Senators Coleman and Rodriguez, concerning the designation of the convening date for the first regular session of the 76th General Assembly and the addition of a joint rule establishing deadlines that apply to the Senate and House of Representatives for the session based on the convening date.
House Joint Resolution 1031 will be laid over one day under House rule. Members, we are moving into seconds. Madam Majority Leader.
Thank you, Madam Speaker. I move that the following bills be added to the special orders calendar on Friday, May 1st, 2026 at 10:52 a.m. Get ready. House Bill 1222, House Bill 1289, House Bill 1223, House Bill 1221, House Bill 1065, House Bill 1004, Senate Bill 141, House Bill 1111, House Bill 1117, House Bill 1230, Senate Bill 160, Senate Bill 151, House Bill 1328, Senate Bill 142, House Bill 1423, House Bill 1014, House Bill 1059, and House Bill 1255.
Seeing no objection, the bills listed by the Majority Leader will be made special orders today, May 1st at 10:52 a.m. Representative Mabry. Members, you have heard the motion. Seeing no objection, Representative Mabry will take the chair.
The committee will come to order. With your unanimous consent, the bills will be read by title unless there is a request for a reading of a bill at length. Committee reports are printed and in your bill folders. Floor amendments will be shown on the screen. Bills will be laid over upon motion of the majority leader, and the coat rule is relaxed.
Do we need the
Madam Majority Leader? Madam Majority Leader.
Thank you, Mr. Chair. I move to lay over Senate Bill 150 until after House Bill 1054.
Okay, seeing no objection, Senate Bill 1050 will be laid over until after House Bill 1054. Mr. Shebo, please read the title to House Bill 1222.
House Bill 1222 by Representatives Garcia and McCormick, also Senator Kipp, concerning the modification of tax expenditures and in connection therewith, making additions to the definition of federal taxable income for tax years commencing on or after January 1st, 2027, and creating the Family Affordability Credit.
Rep. McCormick.
Thank you, Mr. Chair. I move House Bill 1222 and the Finance Committee report.
To the Finance Committee report. Rep. McCormick.
Thank you, Mr. Chair. In Finance Committee, we passed 2 amendments that clarified some language around joint filer adjusted base income and single filer adjusted base income, and also an amendment that fixed all the numbers and letters in the bill. We asked for an aye vote.
Any discussion on the Finance Committee report? Seeing none, the motion before us on the Finance Committee report. Rep. Hartsook.
Okay.
Rep. Hartsook.
Thank you, Mr. Chair, and good morning and happy Friday.
Happy Friday.
So in finance, we heard this bill. We had a great discussion on it. It is Friday morning. We're still in the morning.
We are still in the morning. Would you like me to? I'm sorry, Rep. Hartsook. No. To the committee report.
Yes. So, got sidetracked here. So anyway, what I was saying is, we had a discussion here and going through the Finance Committee report, and to my colleague here from Douglas County, and in view of that, it is baseball season. It is Friday. We're going to have a little bit of fun today. We're probably going to extra innings this afternoon. We are, I think everybody's busy, but we're going to have a little bit of fun here because we're going to get started. I move L011 to 1222 and request that properly be displayed.
Members, it's too loud to hear the conversation we're having down here in the well. Please keep it down. Okay, that is properly displayed. To the amendment. Rep. Hartsook.
Thank you, Mr. Chair. So in honor of baseball, the great Babe Ruth, here we go. Calling our shot. We are swinging for the bleachers. We are kicking off this season here on Friday with this amendment. And what this amendment's going to drive at is in the deductions here in the committee report. We took out the interest. Now everybody's going to say, what does interest matter? Well, if you're in a business or if you're buying a home, interest matters a lot. When HR 1 was passed and it passed down a lot of these direct cuts to the businesses, this took effect immediately. Businesses now have that ability where they can deduct it. Yet what we're trying to do here is reverse that. Now let's ask ourselves, what happens when we reverse interest cuts. What does that do to a business? If a business is allowed to deduct that, what does that usually spur? It usually spurs investment. What are the critical sectors that we're looking at? We have energy, transportation, manufacturing, and real estate. Because businesses, unless they're working virtually, they usually have a brick and mortar. They get out there, they need to buy something, they need to invest, they need to market. We've had a lot of debate over energy. There's huge sectors in that where this comes into play. Yet we are going to, in the committee report, talking about not doing that. This amendment is saying, let's strike that. And we want to strike it because we want to give businesses the opportunity to continue to write off that interest immediately. That spurs their growth. It spurs their ability to raise capital and get out there and do more things with that capital. The number one reason businesses fail is because of lack of capital. Capital has to be spent on many things: payroll, taxes, and interest. Interest, if you look at your mortgage statement, if you own a home, is probably the biggest chunk of it. If you buy a car, your interest payment is a significant chunk on that. If you have student loans, interest is a significant chunk of that. Business is no different. Businesses, when they buy equipment, when they have things that they need to do their job, to serve the community or build whatever it is they're building, they need to write off that interest. That is what we are trying to achieve here. We have passed so many regulations that are anti-business. 1222 is another one of them. We urge an aye vote on this amendment to strike that, to give the businesses some more breathing room and continuing to be able to write off their interest. We urge an aye vote. Thank you.
Any further discussion on L11? Rep. Garcia.
Thank you, Mr. Chair. The reason why that amendment was brought in finance in the first place is because we needed to give DOR the ability to adjust or to calculate for inflation in the future that was based on AGI. And if we were to amend this, it's not actually amending what they're hoping to amend, which is the decoupling entire section. It's really just amending an opportunity for the DOR to be able to be a little bit better in their calculations. I ask for a no vote.
Seeing no further discussion, the motion before us is the adoption of L11. All those in favor say aye. Aye. All those opposed say no. No. The amendment fails. Is there any further discussion on the committee report? Rep. Brooks.
Chair, thank you. I will not necessarily call a shot, because if for some reason it gets a little air underneath it and it lands in the left fielder's glove, it's just a bad look, man. I move L009 to the Finance Committee report as to be displayed. Good morning.
That is properly displayed. To the amendment, Rep. Brooks.
Chair, thank you. This amendment essentially strikes the provision requiring that production property investments be depreciated over a longer timeline than what currently federal policy allows. Now, if I were to use the word incentive, I would think that that is a word that produces generally a favorable thought process behind it. Incentive, right? We're providing something to try to produce a behavior that we want, that is productive, that we appreciate. We're willing to give an incentive in order to affect a positive outcome. There exists an elective 100% first-year depreciation allowance for qualified production property, buildings and other assets used as an integral part of domestic manufacturing, production, or refining. Previously, these facilities were generally depreciated over a period of 39 years. This bill, HB 26-1222, requires then the Colorado taxpayers to add back that extra deduction in the first year, then subtract, and this is when I'm going to get a little mathy. I'm actually going to channel my inner colleague from El Paso County, mathy. I'm past, yes. Thank you for the clarification. It subtracts 1/38 of that amount in each of the next 38 years when computing taxable income. This amendment strikes this add back and that slow depreciation rule so that Colorado simply follows the federal guideline 168N. Now, what we're trying to avoid is yet kind of what I believe that we've seen over the course of the last several years here, with essentially the incentive being to show Colorado businesses the door. That's not the incentive that helps our economy. It's not the incentive that helps our workers, not the incentive that stabilizes the state. It's antithesis of that. So what we're trying to do is reverse that, removing full expensing on production property in Colorado will have a predictable outcome. Research shows, data shows, previous experience shows that accelerated depreciation materially affects where multinational firms will place their plants. Very large, long horizon manufacturing and industrial projects where cash flow and tax timing make or break site selection will more likely that decision be to now avoid Colorado. Again, the incentive is to keep business here. The incentive is to keep production here. The incentive is to keep jobs here, not to kick them out the door. Colorado should not undo a pro-manufacturing incentive that Congress created. This is what this bill would do, is to, again, undo a pro-manufacturing incentive. This was created specifically to jumpstart domestic manufacturing, production, and refining by allowing immediately expensing of qualifying facilities previously got a 39-year straight-line depreciation. If Colorado decouples that provision, it effectively wipes out that federal incentive now at the state level. Converting immediate expensing into a 1/38 per year deduction does not change the nominal total deduction, sharply reduces its present value, and front loads taxes on already capital intensive projects. So for many manufacturers and refiners, what that equates to, what that means, what the end result is, it means less cash for hiring, less cash for equipment, less cash on follow-up investments, ultimately less interest in business in Colorado. Folks, this is what we need and we should want to avoid. This amendment avoids showing that negative incentive of showing Colorado businesses the door, supports the production facilities. That incentive, let's keep it here. I ask for an aye vote.
Rep. McCormick.
Thank you, Mr. Chair, and I love that we're into the meat of the bill through the Finance Committee report. Though I will ask for a no on this particular amendment, realizing that those businesses will still be able to, on their federal tax return, do all the things that H.R. 1 put into effect, which would more than offset what we are doing here to protect Colorado's budget. So I ask for a no vote on this amendment.
Seeing no further discussion, the question before us is the adoption of L9. All those in favor say aye. Aye. All those opposed say no. The amendment fails. To the committee report. Rep. DeGraff. Rep. DeGraff.
Thank you, Chair. All right. To start talking about House Bill 26-1221, I'd like to talk about House Bill, or 1222, to the bill. Thank you.
We're on the committee report, Rep.
To the
DeGraff.
committee report, I would like to start talking about, by starting in 1221. And the reason for it is because of the EFAC that we're talking about here. The bill requires the amount of revenue generated from the modifications of the two current state
Rep.
expenditures.
DeGraff, are you talking about the correct bill?
I am.
1222, the committee
Absolutely.
report? Okay.
Absolutely. That's why I said.
Just making sure. I think you said the number wrong. Go ahead.
Well, this is like the prequel. So in order to understand, and I don't know the full analogy. So in order to understand the actual movie, we have to understand the prequel a little bit here, and that would be 1221, and then which directly addresses my amendment to 1220, the committee report for 1222, because in 1221. And then we also would have 1223, the revenue generated from the modifications of the two current state expenditures and the creation of the new corporate income tax to be reduced by the expanded child income tax credit. So weird, we're talking about the EFAC, this new EFAC in 1222 in the Finance Committee report. But then we're also talking about the same one that happens to be in 1221. And then I think we'll find it again in 1223. And so what it looks like is what we've created, you have created is a brand new expenditure of the tax revenue that is created in 1221, 22, and 23, I think is how that works. And then spending it down through a spending program that's not related to any of those. So you're putting a new business tax on, a new tax, and Mr. Chair, you might be aware that we have a taxpayer bill of rights that requires any new tax to be approved by the taxpayers. Seriously, we have a taxpayer bill of rights that requires any new tax to be approved by the Colorado taxpayer. And here we have in 1221, we have from the creation of a new corporate income tax. So we're introducing a new tax, but in order to keep it secret, the sponsors here in short order, 1221, 1222, 1223, are creating a new spending program in order to hide that revenue. So that doesn't negate the fact that this is a new tax, and this new tax is required to go to the taxpayers because the taxpayer bill of rights, despite the weeping and gnashing of teeth in the darkness, requires that new taxes be approved by the citizens of Colorado. No matter, and then you could take that really good intention and you could explain it to them that what you're doing with this new tax on the business community, what's left of the business community, because they keep leaving. And you keep saying, well, what we want to do is instead of just like say lowering taxes, you want to create a new tax, you want to create a new tax structure, and then somehow diverting it into another program to hide it from the taxpayers, to keep it from having to go before the taxpayers in the Blue Book, because only the Taxpayer Bill of Rights requires it to go before the taxpayers in the Blue Book. What you're doing is simultaneously creating a spending program to spend that gain down. So let's look at, I move L012 to House Bill 26-1222 and ask that it be displayed to the Finance Committee report. Whatever I said, that was what I meant.
Okay, that's proper motion, properly displayed to the amendment.
So the purpose of this is to unpack this issue, because what we have is we really have multiple ideas here. We have multiple concerning the modification of tax expenditures and connection thereof, making additions to the definition of federal taxable income, and, there's that weird word again, and creating the family affordability credit. Now, some of you out there would think that this is actually two bills. that this would be two separate bills because it's concerning the modification of tax expenditures and once upon a time there was this creative process that was required to say if you have to use an and, it's two separate bills. So when I said it was two separate bills, now I have to correct myself because concerning the modification of tax expenditures and in connection therewith making additions to the definition of federal income tax for tax years commencing after January 1, 2027 and creating the Family Affordability Credit. So you'll note with two ands, what you're actually doing is you're joining three bills. You're joining three bills into one bill and definitely violating the idea of a single subject bill. And perhaps we'll deal with that at a different point. But we're talking about the committee report, Mr. Chair, so if you're okay with that, I'll get back to the committee report.
We're talking about the amendment, actually.
Well, the amendment to the committee report, but thank you.
Anything further on the amendment?
Yeah. So
Okay.
let's talk about the amendment. The amendment description is to strike the new Family Affordability Credit, the EFAC, completely and allowing any revenue gains to go to the general fund. Right? Because what we have is that's a separate bill. The EFAC, the creation of the EFAC is a separate bill, should be a separate bill, if we were to be, say, I don't know, following the rules of the chamber in single subject bills. And again, like I said, this is not two bills, this is three. This is three bills. So strike the new expanded Family Affordability Credit, EFAC, completely, allowing the revenue gains to go to the general fund. If you're going to raise taxes, if the majority party wants to raise taxes, they shouldn't subsequently hide it. Now, I get it. This creates is a end around to try to create the progressive tax code, the means of getting rid of the middle class. I get that. But the rules of the game that we play by are that this money should go to the general fund and add voter approval because this is a tax increase. This bill is a tax increase. It doesn't matter that you spend all the money cleverly in the bill while simultaneously raising the taxes. This is a tax increase, and per the Taxpayer Bill of Rights, this needs to go before the voter. So description of the tax code item. The bill creates a new EFAC, a refundable child tax credit layered on top of existing state credit, child tax credit. So we're gonna take this EFAC and stack it on top of the CTC, the child tax credit, earned income tax credit, EITC, and the family affordability tax credit. So we're gonna put this EFAC and build it on top of the CTC, the EITC, and the Family Affordable Tax Credit, the FATC.
And that's what this amendment does?
I'm just explaining why the amendment.
Okay.
So the bill, what I'm saying is the bill creates a new EFAC, a refundable child tax credit, layered on top of the CTC, EITC, and FATC. Legislative council staff must set a per-child dollar amount each December so that the total EFAC credits in the next tax year are projected exactly equal to the extra revenue raised from the tax increase provisions in the bill. The what? The tax increase provisions of the bill. So the bill creates a spending program, so it creates a tax program, which is a new tax, which needs by the voter approval, have voter approval under the Taxpayer Bill of Rights. So hopefully, like the Chamber of Commerce is paying attention to this new tax increase that is just essentially zeroed out by creating a new spending program. And it's a new spending program that definitely does not benefit the businesses that are being taxed. So it can't even be can't even be conjured up into being a fee for service. This is a tax to give to a special interest group. The bill was engineered to appear revenue neutral, specifically to dodge the Taxpayer Bill of Rights, specifically to avoid the vote, to dodge the vote required by the Taxpayer Bill of Rights. The bill is deliberately designed so that its total cost exactly matches the extra revenue raised from the AMT change, executive pay add back, and tighter NOL rules, producing a net general fund impact of 0. So citizens of Colorado, the reason the majority party wants to get rid of the Taxpayer Bill of Rights is so they no longer have to come up with these creative programs like fees and enterprises and things like spending programs on top of new taxes so that they zero out, so that they can say they don't need to go before the voters for their new tax because they already created a new spending program to go with it. You can understand how exhausting that is. The machinations that must go on continuously to extract more dollars from the tax widgets of Colorado. Absolutely incredible. And I feel for the majority party because that does have to be exhausting. Under the Taxpayer Bill of Rights, broad tax policy changes that increase revenue are supposed to go to the ballot, and this amendment simply restores that principle by requiring voter approval before these tax hikes take effect. These tax hikes take effect. In a tight budget, new revenue should go to core obligations, not pre-committed to a new entitlement formula. And what is that formula? We add a new tax, and then whatever's there, we spend it down to 0 so it doesn't look like we've increased spending. The EFAC will hardwire every dollar of new revenue from the executive compensation add back, the AMT change, and the the NOL tightening into yet another ongoing credit instead of letting the General Assembly weigh those dollars against other pressing needs of the general fund every year. So this is a tax. Admittedly, this is a tax, but unlike a fee where a fee normally goes to actually say, I don't know, paying for the service, a tax generally goes into the general fund and that general fund. So this is a no-kidding tax that the sponsors are treating as a fee because it has a predetermined destination from the general fund. So again, you can understand why this is so exhausting and why the majority party wants to get rid of the Taxpayer Bill of Rights, because they are tired of having to come up with these creative mechanisms to extract more of your money. So Colorado's tax credit stack has already exploded. EFAC is a 4th layer. So again, what happens when the General Assembly wants more money? Come on, you can say it with me. It's for the children. It's always for the children.
Rep. DeGraff.
Since 2020,
to the
state
amendment.
Sorry, I'm still explaining the amendment.
Are you?
To the bill, to the Finance Committee report. Absolutely.
Okay.
This is a really in-depth, and I think the citizens of Colorado deserve a really detailed explanation as to how the General Assembly is so creatively circumventing their Taxpayer Bill of Rights, because I think it is truly inspiring level of creativity. I mean, it's completely duplicitous, but it is inspiring in its duplicity. Since 2020, the state child-related tax credits have grown from about $72 million a year to as much as...
I understand you're eager to speak about the bill. You will have an opportunity to speak about the bill.
Well, Mr. Chair,
Can we bring it to the amendment?
I am talking to the amendment to the bill, to the amendment to the Finance Committee report to the bill, because I'm talking about striking the EFAC, and the EFAC is layered on top of 3 other child tax credits, which have grown from $72 million from just the EITC to as much as $1.24 billion a year under current law. With the EITC, state CTC, FATC, and expanded EITC in all places, search from the Independence Institute. If HB 1221, 1222, 1223 all pass, which we have every reason to expect that they will, because the citizens of Colorado still have money, and that really causes consternation. The annual revenue hit from these tax credits alone could reach about $1.833 billion in higher revenue years. This is about $500 per filer and lost refunds. So for the citizens of Colorado, if the General Assembly does not spend your taxpayer Bill of Rights down to zero, which is their intent,
Rep DeGraff to the amendment.
you will lose another $500 out of your refund. Even in low-income years like 25, 26 will be, the state still loses about $303 million per year from EITC and CTC. Adding expanded FATC pushes that floor to $892.5 million per year as a minimum. Even in deficit years, this is up from $72 million. Now, this is probably why the state is so eager to avert so many births, because that's a lot of money. Stacked refundable credits weaken incentives to move up the income ladder. When families receive multiple income-tested benefits at once, SNAP, Medicaid, CHIP, EITC, CTC, FATC, and now the expanded EFAC, which is created in this bill to zero out any gains from the new taxes. The effective marginal tax rate on each extra dollar earnings can exceed 40 to 50%. And that's the purpose of the progressive tax code, so that as you earn money, it's taxed at a higher rate to disincentivize you earning higher wages. And if you read Uncle Carl's manifesto, you'll see the progressive income tax is number 2, right behind the other goal of the majority party, which is the abolition of private property. Mr. Chair, I want to get back to the committee report.
That's crazy, but can you get to the amendment?
I haven't left.
Okay.
That means
I'm
a modest
lost
raise.
here.
And so this, Mr. Chair, this is how this applies the EFAC. The EFAC ties back into the overall tax code. And the EFAC, if you'll remember, is part of the amendment that I want to strike out from the committee report, because the EFAC is calculated to zero out the new taxes that should go to the taxpayers for approval, but is not because of the creativity of whoever drafted this. So, or even worse off, after losing benefits, reducing the incentive to seek higher paying work or longer hours, or making it harder to transition off assistance forever. So citizens of Colorado who think that they're doing you a favor by layering on this, just know that the entire purpose of the EFAC and the other programs is to trap you into a level of poverty by making it, by actively disincentivizing you moving up the corporate ladder. They'll say it's not, it's for the children. I get it, that's the game. EFAC makes it already complicated child tax credit landscape even more confusing. Families in DOR already have to navigate CTC, EITC, FATC, and the expanded EITC, not just the expanded EFAC, each with different income thresholds, phase-outs, and triggers, because that's how you create a progressive tax code when you have a fair tax code like a straight tax rate. EFAC adds a highly volatile and technical tax credit whose per child amounts change every year. Why does it change every year? Because the entire purpose is to zero out the new taxes that are brought in by the bills that were not voted on by the taxpayers, per the Taxpayer Bill of Rights. Based on the Legislative Council's forecast on how much revenue is raised from 3 unrelated corporate tax changes. So again, it's taking 3 unrelated tax changes, making a change, putting it in something completely different, so you can say, it's for the children. Put a little tear down the side of your face, have some special music in the background, and say how heartless everybody is. But this violates the Taxpayer Bill of Rights.
Can you please not impugn the motives of your colleagues and speak to the amendment?
Got it. But just for clarity, I was commenting on tactics, not motives. Making communication and administration harder for both families and the department. Conditions on voter approval, $329.2 million. So, Mr. Chair, do you understand the amendment? Do you understand why it's important to remove the EFAC and return this to only 2 bills instead of 3 bills? And send this bill, send these 2 bills instead of sending 3 bills to the taxpayers for approval as required by our Colorado Constitution? Or do I need to explain it again?
No, I think we got it.
Okay. Okay. Well, good. So let's take this bill from 3 bills down to 2 bills. Let's stop violating the Colorado Constitution. Let's stop trying to drive the businesses of Colorado out of Colorado. Let's have an honest conversation about that. The fact is that the citizens, that the General Assembly, the majority party, will not be happy until the tax widgets of Colorado have nothing.
Rep. Richardson.
Thank you, Mr. Chair. My colleague from El Paso did neglect to make a baseball reference, but he did take us around the bases. He may have spent some time out in left field. But I want to bring us home with a short quote from the late, great Yogi Berra. It is deja vu all over again. It's a good amendment. Our government rests on the consent of the governed. This amendment allows those that we govern to consent to this. It gets a little awkward, I know, at times when committee reports come up before there's really any discussion of the bill. Our sponsor was kind enough to step up briefly and make the claim that this bill is needed because of a hole that H.R. 1 blew in our budget. We just passed a budget that we've claimed to be balanced, so it really can't be about that. It is, in effect, about raising revenues to the state. Whether we spend them immediately or not, this bill clarifies the fact that we wouldn't be spending them immediately. We would just be doing plainly what we are doing, which is increasing revenue to the state. And tax policy changes that increase revenue to the state require a vote of the people. That's what this amendment does. I would urge a yes vote. If we're going to do this, let's do it openly, transparently, honestly, and give the people an opportunity to speak on this. I urge a yes vote.
Rep. McCormick.
Thank you, Mr. Chair. I just want the House to know that in order to make sure
Hold
that
on,
we're
Rep. McCormick. Members, there's some loud conversations going on. We cannot hear the conversation happening in the well. Please take your conversations to the side. Rep. McCormick.
So in order to not run afoul of Tabor, 4 conditions need to be met. The primary purpose of a policy is to not raise revenue. Any revenue increase is unintended or unavoidable. The revenue impact is incidental to the law's main purpose, and the state's authority to collect or retain revenue is not expanded, which is what this bill does. This bill is revenue neutral. It is not a tax increase. Therefore, we ask for a no vote on this amendment to the Finance Committee report.
Rep. Brooks.
Chair, thank you. Actually, that is exactly, that's exactly the point, that the bill was engineered to appear revenue neutral and specifically to dodge a vote that would be required by the good taxpayers of Colorado under the Taxpayers' Bill of Rights. This is a 4th layer, an unnecessary layer that you can also argue starts to produce some diminishing returns when you start to stack these things up. When families are receiving multiple income-tested benefits at once, SNAP, Medicaid, EITC, CTC, FATC, and now potentially the 4th layer of ETAC, the effective marginal rate on each extra dollar earnings, then it can exceed 40 to 50% as benefits phase down. That means a modest raise or promotion can leave a family only slightly better off. All of these also mean pretty much families, hardworking families of Colorado can expect, when all of this is combined, about $500 less each year in Taxpayer Bill of Rights refunds. Now, I know that we've already kind of rated from the future to pay for the now. But in a world where we were honoring truly the Taxpayers' Bill of Rights, that's what families could expect. This is engineered to appear revenue neutral. It is engineered essentially to be deceptive. And repealing the ETAC that this amendment does at least inject some more truth and some clarity into the conversation. I ask for an aye vote.
Rep. DeGraff.
Thank you, Chair. I think the sponsor made my point as to why we need this amendment. This bill was engineered to circumnavigate the Taxpayer Bill of Rights. So this bill is not just about this bill. This is about the precedent of every subsequent tax increase. Because if we say that this is because we have simultaneously created a spending program with a new tax, and a tax generally goes to the general fund. And how is it done? Well, because these things are unrelated, there's an and and an and. 3 bills turned into one to create and make it revenue neutral. So it is raising revenue and it is spending revenue by violating the single subject rule. So citizens of Colorado, tax widgets of Colorado, the tax-paying widgets of Colorado, you can expect this bill, these 3 bills, in similar fashion until you have no money. So businesses of Colorado, you can expect these 3 bills over and over until you flee Colorado, because it has become the most taxed and most regulatory state. Because that is clearly the goal. It is clearly the goal. Now, I understand the sponsor has some place to be, but this is the bill they chose to run. This is the 3 bills they chose to run. And this will continue to violate the citizens of Colorado.
Rep. DeGraff, we're still on the amendment.
I'm sorry, what?
Can you please bring your comments back to the amendment?
The reason that we need this amendment is because we need to strip the spending portion from the revenue generation portions, the 2 new taxes, the multiple taxes that are in this bill. We need to strip those from the spending program because it violates the single subject rule. And we need to send the bill to the citizens of Colorado, the tax-paying widgets of Colorado, to ask them if they would like to further punish the business community to the point of driving them out of Colorado. Is that really what the citizens of Colorado want? The General Assembly, the majority party of the General Assembly, clearly wants that. Do the citizens of Colorado want that? We have headquarters leaving. We talked about a couple of them yesterday. We have businesses entirely leaving.
Rep. DeGraff, that was impugning motives. Can you please keep it to the amendment?
So this needs to be accepted so that we can get back to honoring the Taxpayer Bill of Rights, accept the fact that maybe the citizens of Colorado would do better by having some more money in their own pockets. Maybe the businesses of Colorado would do better, because again, the money that's taken out and the money that's spent through government, this is money that is going to be taken out for the children, is going to be processed through nonprofits. It's going to be processed through all kinds of ways to launder that money. But what it's not going to do is it's not going to benefit the economy. And the other purpose of these type of programs is to lock families into poverty. We need to separate these things. We need to separate these things and talk about them and have them approved by the taxpayers per the Taxpayer Bill of Rights and stop insulting the citizens of Colorado by trickery. I ask for an aye vote.
Rep. Richardson.
Thank you, Mr. Chair. The sponsor was kind enough to rattle off a list of items that have to be true in order to meet the requirements of Tabor, one of which was that the revenue generated be incidental to the purpose of the bill. The revenue generated is actually the purpose of the bill. It is in the title of the bill. This is not incidental. Also claim that it would not be required if there was no revenue, and then redefined revenue as net zero. This bill starts a new program. It's a program that provides tax credits, refundable tax credits. That costs money. That is an expense to the state. If there is an expense to the state and the net is zero, you need to have revenue to the state increase in order to cover that. This is, in fact, a bill that increases revenue, and it is not incidental to the purpose of this bill. It's not de minimis either, but we'll probably talk about that later today. This is a good amendment. Pass the amendment. Let's be honest. Let the people decide whether they want to consent to these changes. Vote yes.
Seeing no further discussion, the motion before us is the adoption of L12. All those in favor say aye. Aye. All those opposed say no. The amendment fails. Any further discussion on the committee report? The motion before us is the adoption of the Finance Committee report. All those in favor say aye. All those opposed say no. The committee report is adopted. To the bill. Rep. McCormick.
Thank you, Mr. Chair. House Bill 1222 is being brought before you to make sure that our state tax code is written by us. Last summer, H.R. 1 made major changes to the federal tax code, and because of the way we are tied to the federal taxes, it made big changes to our own tax code without any of us voting for it or on it. It reduced taxes for businesses in Colorado to the tune of $1 billion last year, and at the same time blew a $1 billion hole in our budget. And because of that close tie to the federal code, tax code in Colorado, deductions that businesses make federally can also be used to reduce Colorado's taxable income, even if they are not investments made in Colorado. The bill ensures that our tax base is not reduced from out-of-state investments. Additionally, H.R. 1 caused the Colorado Family Affordability Tax Credit, otherwise known as FATC, to trigger off. Only after 1 year of impact, and in that short year, Colorado had become the lowest state in the country in child poverty. That's a lot to be proud of. We do not want to reverse that progress. This bill only decouples from 4 brand new expanded tax breaks under H.R. 1, meaning that businesses will still be able to claim most of those provisions at their pre-H.R. 1 levels. And in a bit, we'll go into the 4 different, or I'll just start. There's 4 different provisions. The first one is bonus depreciation deduction, otherwise known as 168K. This is the bonus depreciation deduction for qualified property. And this deduction is a tax rule that lets businesses write off the cost of certain equipment or property much faster than normal. For instance, if a business buys something very expensive like a piece of equipment, the IRS usually makes you spread that deduction over several years, which is regular depreciation. Bonus depreciation allows you to take a bigger chunk of that deduction right away. And in H.R. 1, it actually allows you to take 100% of that purchase cost as deduction in the same year you buy it. And after H.R. 1, making that 100% bonus depreciation permanent, that's what it did. It made it permanent. And so that particular one is for things that businesses buy. And our bill would require businesses to add back that deduction for state tax purposes, meaning they could still take the federal tax deduction. Second one is depreciation for qualified property deduction, 168N. This one is the qualified production property deduction aimed at manufacturing facilities. This provision allows businesses to immediately deduct 100% of the cost of certain manufacturing buildings in the year that they're placed in service. HR 1 created this new deduction that did not exist before. So our bill would require businesses to add back this deduction for state tax purposes. And realize that we're not the only state that is doing this sort of decoupling from the federal tax code. Already 13 other states have decoupled from this particular provision. And I'll turn it over to my glorious co-prime sponsor to continue.
Thank you.
Rep. Garcia.
Thank you, Mr. Chair. Thank you, Representative. It is an honor to do this bill with you. The other two pieces that we are adjusting in this bill is the research and experimental expenditures deduction. So this is the Section 174A deduction that lets businesses deduct research and development costs. Under the TCJA, those costs had to be spread out over 5 years. And what HR 1 did was reverse the Tax Cuts and Jobs Act requirement to amortize research costs, allowing immediate expensing for domestic R&D expenditures rather than amortizing over 5 years. This bill would require businesses to add back this deduction for state tax purposes. The deduction allows businesses to deduct the research and experimental expenses to reduce their tax liability, and HR 1 allows businesses to now immediately deduct the cost of R&E expenses. So decoupling from this protects Colorado and it protects our tax base. And it ensures investments outside of Colorado don't shrink state revenue. 13 other states have already decoupled or modified this particular provision. And the last thing that we're adjusting in this is the business expense deduction limitation 163J. This is an important piece that we need to address because business interest expenses are generally deductible, but there's a limit on how much businesses can decrease their tax liability with business interest. The TCJA limited this deduction to the sum of its business interest income, 30% of its adjusted taxable income, and floor plan financing interest. HR 1 expanded this limitation. They expanded this limitation by the calculation for allowable deductible interest. So the law says that you have to multiply your adjusted taxable income by the limit of 30%. Basically, your deductible interest cannot be worth more than 30% of your ATI to ensure debt finance companies are incentivized to have a lot of interest. Now, before HR 1, you calculated your ATI without depreciation expenses. HR 1 allows companies to add depreciation expenses to their ATI, making it higher, and therefore making your allowed deductible interest, which should be 30% of your ATI, actually higher. 16 other states have decoupled or modified this provision. And that's what that is. I want to just address really quick. I know that my sponsor, or my co-prime sponsor, talked a little bit about throughout the amendment phase around Tabor compliance in this bill. The reality and the fact is that this bill does not increase net revenue. It offsets revenue gains from expenditure reductions with the family affordability credit. Besides that, tax policy changes that are incidental and de minimis are still allowed under Tabor case law, both in RTD versus Tabor Foundation and now under Lakewood versus Metro PCS, the new tax issues. Under Tabor, Colorado cannot enact a tax rate increase, new tax, or tax policy change that raises net new revenue without voter approval. And this bill is not a net increase or a new tax. It is a tax policy change. The businesses who will no longer be able to be able to take advantage of these HR 1 increased or new deductions have not yet even had the opportunity yet. So we are not taking away any savings that these businesses would have already had. Because all revenue is raised, it goes directly to fund the FAC, and it doesn't go to increasing revenue or to the general fund. It goes from one tax policy to another tax policy. And so, Okay, and so now I will turn it to my co-prime to talk about specifically the family affordability credit.
Rep. McCormick.
Thank you, Mr. Chair. Yes, and the reason why this is an important part of this bill is, as I mentioned in my opening, that H.R. 1 turned off the family affordability tax credit. And so in this bill, we want to make sure that that great progress that we have made in our state continues, and the de minimis changes that this bill will see will go into the family affordability credit. And this is a permanent version of this credit, so it won't have that trigger mechanism that was in the original credit. So this newly created FAC will mirror the FATC in terms of the same eligibility and the same kind of distribution. And the benefits will be based on how much is raised by the changes to the decoupling changes in this bill. This, in effect, will create a bridge between now and when the FATC turns back on, which is really important for the families and the kids that we have supported with the FATC. I think that's it. We urge an aye vote on the bill.
Rep. Richardson.
Thank you, Mr. Chair. Thank you, colleagues. Sponsors have a very interesting view of their own bill and the basis of it and what preceded it. H.R. 1 did not turn off a state tax credit. That state tax credit was turned off because we passed a law that said it would be paid out of Tabor excess. We didn't have Tabor excess, not solely because of any changes in H.R. 1, but because of a plethora of bills that have damaged the economic engine of this state. A few years back, we were generating $3 to $4 billion in excess. H.R. 1 may have taken $600 to $800 million off the table, but if we had not been sitting here sowing the seeds of our own destruction, that smaller loss of revenue still wouldn't have made much of an impact. We would have had, 24 to 3.5 billion dollars to still work with to still pay that tax credit. To stand here repeatedly and blame a decision of the federal government for our current economic problems is easy, but it is wrong. Sponsor began by lamenting that we didn't even get a chance to vote on H.R. 1. Well, voting on tax change policy is a good thing, and we should have afforded that to our citizens with the amendment that did not pass earlier. But that's not why I'm up here right now to talk. I have a lot of concerns about the bill, but I'm very, very concerned about the changes to the deductions surrounding research and development. As I said earlier, we have continuously passed laws here that damage our economy, that damage our ability to create future revenue in this state. R&D is incredibly important. The social returns of R&D far exceed the commercial returns on it. There is so much that turning off this tax credit harms that I could go on for a long time, but I'm not going to. I just want to kind of summarize a little bit here that cutting back R&D incentives is incredibly short-sighted. We pride ourselves in this state as having a high-tech economy. And that wasn't built by accident. It was built by innovators, engineers, manufacturers, energy tech companies, and startups that decided that Colorado was a great place to come and take a risk, to hire talent, to test ideas. to commercialize and profit off their discoveries. When they profit, we tax, we get revenue. We're taking that future revenue away. Research and development isn't a loophole. It's the front end of economic growth. It should be incentivized. It should not be punished. When we punish basic research and development, we do not just reduce a tax credit. We tell high-tech employers that we see them only as a current cash cow. We signal we don't care about their future. And if we don't care about their future, I don't think they need to be caring about the future of this state. Why should they participate in our future? Why don't they leave? We've seen them leaving because of current tax policy. Now we're going to pile on more. In the short term, this means fewer projects, fewer hires, fewer expansions, and more pressure to move investment to states that are actively competing for the jobs that are currently here in Colorado.
Oh, I told my aide to.
These changes don't just hurt faceless companies, they hurt the workforce in Colorado. They hurt the people in Colorado. In the long term, that's even worse. Today's R&D becomes tomorrow's patents, tomorrow's products, tomorrow's new spin-off companies. It's future payroll, it's future property investment, it's future income tax that those workers earn as well as those companies earn that come back to the state that we can use for programs that we need. This change is very short-sighted, and I move L008 to 1222 and ask that it be displayed.
That's properly displayed. To the amendment.
Thank you very much. If you read the amendment and you're not following along in your bill, this amendment doesn't mean much to you. But I will tell you that it strikes the provision in this bill that eliminates the research and development Section 174A expenses that HR 1 had made changes to. But I just want to repeat at the end here that R&D investments create higher social returns than private returns. The public, on average, realizes more gains from R&D through better projects, better products, higher productivity, and quality of life improvements than the investing firm actually brings in profit. Firms typically earn around 10 to 20% return on R&D, while the social return is roughly double that or more. That gap is why economists say markets tend to underinvest in R&D and why tax incentives or public support are usually justified to correct that underinvestment. Removing this incentive apparently is de minimis. It's a mere $60.8 million, and if that's de minimis, I'll pick up that check any day. De minimis changes in this bill is what we heard. So I think it would be wise to waive this de minimis $60.8 million and allow these companies to innovate, to improve our quality of life, to hire people in this state, to expand our tax base, and get us back to where we could afford to provide to the people of this state without first tearing money out of the pockets of people that have been working so hard to earn it. Please support this amendment.
Rep. McCormick.
Thank you, Mr. Chair. I want to just make it clear to all the great research and development companies that are in our state doing wonderful things that this deduction does not go away. You can keep doing your deduction as you have been. That's what our bill does. It just keeps it the way it is right now. It's not taking it away. It's just you can't do it all in 1 year. You can do it over the 5 years like you've always been doing. So it does not have any kind of chilling effect to our research and development communities. Just keep doing your good work. Keep taking the deductions as you have been previous to now.
Rep. Brooks.
Chair, thank you. Naturally, I suppose you probably would assume that I'm going to push back on that a little bit, as far as particularly the not having a chilling effect. Increasing taxes on R&D punishes the highest return investments. Of course, it's going to have a chilling effect on R&D. It does have an impact, and if anything, if we want more of the higher end wage jobs in Colorado, we should be, again, I'm going to use the word, providing an incentive, not decentivizing the R&D. We should provide the incentive. If we want more R&D and high wage jobs in Colorado, we should not be singling out domestic research costs to be treated in a worse manner or a more unfair manner. The chilling effect is indeed that. It's not okay taking away, but there's a vast difference in the scope of whether we're going to take it away, whether or not we're going to increase taxes and make it more difficult between, it creates a chilling effect. We can't say that the only chilling effect is to schwack something. What we're doing here is indeed creating a chilling effect. What this amendment does is to try to address that, to try to reverse that, to try to recognize the impact that we're having and try to say, you know what, let's not do that. Let's not shoot ourselves in the foot when it comes to R&D and what that brings to Colorado. I ask for an aye vote.
Rep. Hartsock.
Thank you, Mr. Chair. So let's do a little bit of math here. Yes, it currently sits at, well, right now it's at 12 months, 1 year. You want to say, let's go back to 5 months or 5 years, which is 60 months. If you're a business and you're doing research and development, you have to spend the money now. You don't get the luxury of going, I need you to do my R&D work, but I'll pay you 5 years later when I can deduct this off of my taxes. That's not how businesses operate. So it's absolutely ludicrous to say it doesn't hurt the businesses, because it does. If you're a business and you're pouring money into research and development, which is what we want to do to spur growth, which is the whole point of how we get more revenue into the state, you want to do that now, not spread it over a 5-year time frame. So if you invest in your R&D right now, then you should be able to deduct it right now, all in that same year, versus spreading it out over 5 years. That costs more to the business because it allows them to deduct less. Therefore, they either need more capital, as I spoke about earlier, or they have to delay things. To sit here and think that you can spread something out over 5 years versus doing it within 1 year and think that it doesn't have any kind of negative impact simply doesn't work in the math world. It just, from an accounting perspective, you have to do it now. If you're spending the money, be allowed to deduct it. That was the whole point of writing the deductions, to be able to do the R&D in that year. Businesses need the capital. So if they're going to spend it on R&D, they need to be able to write it off when they spend it versus waiting over 5 years to spend it and then recouping it. The point of doing that is so they can not only get it back in that year as a tax deduction, but also look at what's going to go later on for the growth. Because then the state wins. If all we cared about was the revenue, we'd still want to support this amendment and do it right now, because then the business is out there making more money. And that brings in more tax revenue. And then its employees have more payroll taxes. It's a win-win. Vote yes on this amendment.
Rep. DeGraff.
Thank you, Chair. The idea that these new taxes, this new tax revenue program, which is, of course, handled by the Taxpayer Bill of Rights completely separate from new spending programs. The Taxpayer Bill of Rights only deals with the revenue generation side. The spending part is part of the cap. But these businesses, when you say that they have not realized these businesses have already planned on these. These businesses have planned their R&D budgets, and their R&D budgets are based on this. So they might have put more money into research and development, and research and development is where you get all of the benefits that create new businesses, create business growth in Colorado. And then along come the sponsors and say, we're going to take that away for the children. Not necessarily for the children of Coloradans, but for the children. So it is disingenuous to say that they have not realized these tax things, these tax provisions, because they have been budgeting on these tax provisions. So linking a program increase, Colorado linking its program tax increases to every federal tax increase, that was pretty convenient. Then it was out of their hands. We have to raise taxes, the feds raise taxes, we get more taxes. That was going to go on forever. Then it changed. And now the majority party is upset because the tax widgets of Colorado still have money. The businesses of Colorado still have money. The businesses have not been regulated into oblivion, into other states yet. I'm not questioning motive, I'm just presenting facts.
Thanks for that clarification.
Thank you. I thought you would appreciate that. So they have budgeted for these. So I ask for an aye vote on this amendment and stop trying to destroy the business community in Colorado.
Rep. Richardson.
Thank you, Mr. Chair. We can't have it every way we want to have it. Every time we come to the podium, we have a different story on why something is not what it is, or something is nothing, or nothing has become something. This is something. We are essentially, by amortizing over the 4 years, removing that ability to expense in the first year, removing cash flow that so many small startups need when they are innovating, and stretching it out over that 4-year period, pretty much demanding that these businesses give the state a tax-free loan so we can embark on some other new process, new tax credit that we want to do. This is, frankly, a little frustrating. We argue that things are de minimis. We argue that they're only incidental to what we're doing. But then we have to have it now. It's de minimis, but we got to have that de minimis amount right now. You can't have it. You can't use it to build your business. You can't use it to innovate. You can't use it to create things for the good of our society, actually creating things, not just taking things and giving them back and claiming it's good for society. This amendment at least preserves a little bit of seed corn for the future rather than the state eating it now. Let our companies build their future. We depend on them to employ people, except for the vast number of people that now work for government, but we depend on them to employ the majority of Coloradans. In order to do that, they need to thrive and grow. This R&D money is incredibly important to small, innovating startup companies. That cash flow that it provides is so much more important to them and the future of this state than establishing another new tax credit that we likely won't be able to afford. Please vote yes on this amendment.
Seeing no further discussion, the motion before us is the adoption of L8. All those in favor say aye. Aye. All those opposed say no. The amendment fails. To the bill. Rep. Flannel.
Thank you, Mr. Chair. I move Amendment L10 and ask that it properly be displayed.
That is properly displayed. To the amendment.
This amendment strikes the provisions requiring equipment 168K expenses to be expensed over a longer timeline than federal tax policy allows. Let's just state what this bill actually does. It punishes businesses for investing in Colorado. When a manufacturer buys new equipment, they're not just making a purchase. They're making a commitment. They're expanding capacity. They're preparing to hire workers. They're betting on a state's future. Instead, this bill forces businesses to pay Colorado taxes on money they've already spent, money invested in equipment, facilities, and growing the benefits of Colorado. Money that won't be recovered for probably 10, 20, maybe even 30 years. A small manufacturer invests $500,000 in new machinery. Under this bill, they pay Colorado taxes on the full amount immediately, then recover the deduction at $50,000 per year for the next 10 years. You know what that is? It's a penalty for investing here. This bill kills innovation. Colorado has spent years recruiting biotech companies, aerospace firms, and technology startups. These industries invest millions in research and development. This bill taxes companies for doing that research. The biotech firm spends $2 million developing a new treatment. Under this bill, they'll owe Colorado tax on a big share of that investment in year one. Income they never actually put in the bank. They're literally punishing companies for innovating in Colorado. Why would they stay? Why would they choose over 29 other states that don't impose this burden? This bill also creates a compliance nightmare. Every business that invests in equipment or conducts research must now maintain 2 separate depreciation schedules, one for federal taxes and one for Colorado. For some assets, that means 38 years of separate record keeping. More accountants, software, time, and a higher risk of being penalized. A lot of businesses don't have armies of tax lawyers. They have one accountant trying to keep up with regulations that change every session. Why make the system more complex? Businesses are leaving Colorado, and we have the data to prove that. The Colorado Chamber Foundation just released a report showing that since 2019, 98 companies have left Colorado or choose to expand elsewhere. 27 of those left just this year, 27 of those just left this year alone. Those relocations cost Colorado over 13,600 jobs. This bill is just another reason for companies to leave. Why must we pass another bill that screams, Colorado doesn't value the business that creates jobs and invests in our communities? The bill's own language admits that it goes after, quote, large and capital-intensive businesses, manufacturers, builders, major employers who invest billions and provide thousands of good-paying jobs here in Colorado. These are the companies our communities depend on. These are the employers our workers need, and we're driving them away. You don't help families by taxing away the jobs they depend on. You don't make Colorado more affordable by making it more expensive to do business here. When companies leave, families lose their paychecks, their health insurance, and their stability. This bill tells every business in America, don't invest in Colorado, don't expand here, don't innovate here, we'll make you pay for it. When a company is deciding where to build their next facility, where to locate their research operations, where to create their next 100 jobs, this bill prices Colorado out of consideration. Our workers deserve better. Our communities deserve better. For this, I ask for a no vote, because of this, I ask for a no vote on this bill and ask that you adopt this amendment. Thank you.
Rep. Richardson.
Thank you, Mr. Chair. And I rise in support of this amendment. It's a good amendment because without it, we are further crippling our businesses and distorting what good business practices are. There is a tremendous draw to immediate gratification. You can see it right now in this room. There's something free available right outside, and everybody is left to go partake. That is what this bill does. The state is looking for immediate gratification. They want some free lunch. when you're running a business, I'll talk about some of the businesses in my district. Farm equipment's incredibly expensive. Some of the equipment used, tractors, harvesters, etc., can run into the hundreds of thousands of dollars. If you drive around outside the metro area, you'll see some shiny new equipment, but you'll see an incredible amount of very old equipment that is held together with spit and baling wire. When you have to amortize a capital purchase over a 20-year period and you're faced with, do I lay out 200 grand and be able to expense 10,000 of that or credit 10,000 of that as a deduction against my taxes versus can I scrape together the money to put out $200,000 and be able to expense $200,000 in that year? The way you go about your business changes dramatically. When you buy that new piece of equipment from a distributor, that distributor is making money. He is paying his employees. Those employees are feeding their families. They're paying their mortgage. They might take a little bit of that money and splurge and put it back into the economy. But those local dollars that become available to circulate within our local communities generally generate $6 to $7 more. You take that $1 and you pull it up here to the state, it's less than $1 when it gets returned to those communities. This whole bill is looking for just immediate gratification. We don't like the changes that were made, the long-term changes, the changes that actually set up an economy that will grow and sustain itself. We're looking very short-sightedly at changes we can make to just grab cash so we can take credit for helping families, when what we're doing with this bill is damaging families and Coloradans and their businesses for the long term. This is another change that needs to be made to this bill. Vote yes on this amendment. If it passes and we amend it further, maybe it'll be worthwhile, but I don't know how we get there. But please support this amendment.
Representative Brooks.
Chair, thank you. I also rise to support this amendment. And just a brief recap. This will strike the provision that requires business expenses to be expensed over a longer timeline than what federal tax policy allows. I was chatting with my colleague over here about equipment. I remember reading something very recently that a 250 or 350 level truck actually it's not a regular vehicle at that point. Don't know if you realize this, but actually that is in a luxury class. That is one of the most popular luxury vehicles in the country. It's a work vehicle, but it's a luxury vehicle by classification, virtue of the price of that vehicle. It's expensive. News reports, you can blame whoever you want to blame, whatever is what it is, but the news reports that I've seen show that vehicle costs are probably going to increase even more. So why would we force that deduction spread over a number of years when a lot of these vehicles, and I'm just talking about one vehicle specifically, but just equipment in general, has to be spread over such a long period of time. Full expensing for equipment, widely described as a major cash flow and competitiveness boost for manufacturers, contractors, logistical firms, farmers, small businesses that regularly buy machinery, that equipment, those vehicles. It's important for them to be able to have that expense. It's important for them to be able to take that deduction immediately, not amortized over an agonizingly long period of time, especially with the cost of what everything is running these days. Replacing immediate expensing with a 10-year over an immediate amortization program at the state level raises that effective Colorado tax cost of investing in equipment, which Again, I ask repeatedly, and I'll continue to do so, that we look at the long-term impacts, that we consider the long-term effects of the policy that we are considering, most likely passing. I ask for a consideration of that because what we're doing is pushing marginal projects towards states that will mirror the federal tax code. There is no obligation for these companies to either come to Colorado. There's no obligation for these companies to stay and continue to operate their businesses in Colorado. Folks, we are going to continue to lose businesses through these death by 1,000 tax cuts. May seem simple, but these add up. Even this alone is something that I believe is impactful in a very negative way. When the businesses go, so do the jobs. Can't have it both ways. You have to look at the long-term impacts of what we're considering. This can very likely, and I'm not being hyperbolic, this can very likely push businesses from the state, and when the businesses leave the state, so do the jobs. So goes the ability for the hardworking families of Colorado to be able to put food on the table. I ask for a yes on this amendment.
Is there any further discussion on Amendment L10? Rep. Garcia.
Thank you, Madam Chair. We talked about why this was necessary in the opening, and I just asked for a no vote. Thank you.
Is there any further discussion on Amendment L10? Seeing none, the question before us is the passage of Amendment L10. All those in favor say aye. Aye. All those opposed, nay. No. L10 fails. Back to the bill. Representative Graff.
Thank you, Chair. Just to avoid belaboring the point here, there's a lot to unpack about these three bills, if not three bills, two bills, because concerning the modification of tax expenditures and in connection therewith. And I would just like to look at what we're talking about. The Taxpayer Bill of Rights, Article 10, Section 20 of the Colorado Constitution, something that we've all taken an oath to support, directly addresses new tax programs. This is a new tax program and a new spending program. It requires advance voter approval for any new tax rate increase, or a tax policy change directly causing a net revenue gain to any district. Now, we've already talked about the creativity of the sponsors, or whoever drafted this bill, whoever brought it to the sponsors. Probably has a logo that looks like a bell. This covers new taxes or new tax-related programs, initiatives that would increase net tax revenue. Introducing a new tax, broadening the tax base, closing loopholes that result in higher collections. Tax cuts, credits, or policies that reduce net revenue do not trigger this requirement. Tax cuts, credits, or policies that reduce net revenue do not trigger this requirement. The provision is designed to give voters a direct say, crazy, that whole taxation with representation, I know, anathema, weeping and gnashing of teeth. The provision is designed to give voters a direct say before governor expands its taxing authority. Weird. Weird, because this expands the government's taxing authority. What about if a tax program, one of net revenue gain, is offset by spending increase? That does not remove the voter approval requirement. The voter approval rule in the Taxpayer Bill of Rights, subsection The voter approval rule in the Taxpayer Bill of Rights, subsection 4A, looks only at the revenue impact of the tax policy change itself. It is independent of how the money is later spent or subsequently spent. And in this case, it is later spent. You have 1221, you have that bill, you have 1223, you have that bill, and then you have 1222, those three bills, these three bills before us right now. It is independent of how the money is later spent on whether overall spending rises, spending increases are governed by the Taxpayer Bill of Rights, separate fiscal year spending limits, inflation plus population over local growth with adjustments. If new tax revenue pushes total collections above the spending limit, then the excess must normally be refunded to the taxpayers as the following year unless voters separately approve retaining it as an offset. But you still need voter approval first to enact the new tax or revenue gaining policy change. Spending the new revenue or pairing it with higher spending does not create an exemption or a net zero workaround in the tax approval side. In short, the Taxpayer Bill of Rights, the bane of the majority party in tax-extracting citizens into poverty, the Taxpayer Bill of Rights treats the tax revenue side of the spending side as distinct hurdles. A new revenue-raising tax program still needs its own voter referendum, regardless of spending plans. Local governments and the state have used this process for decades on measures ranging from sales taxes to marijuana taxes. The exact wording of the tax policy change and its projected net revenue impact would determine whether a ballot measure is required. But let's go to the beginning. This covers new tax programs, initiatives that would increase revenue. New tax, broadening the tax base, or closing loopholes that result in higher collections. This bill does that. What about the spending? And that requires taxpayer approval. What about the spending? The voter approval in the Taxpayer Bill of Rights, Section 4A, looks only at the revenue impact itself. Doesn't really address the spending. It is independent of how the money is later spent and whether overall spending rises. Spending increase. Of course, if the General Assembly increases taxes, it's going to spend that money. Duh. That's what the General Assembly does. Spending increases are governed by Taxpayer Bill of Rights, separate fiscal year spending limits. This is 2 bills. This is really 3 bills. This is really more like 4 bills because you have 221, 223. You also have 1289 that are all designed to circumvent the Taxpayer Bill of Rights, to circumvent the tax widgets of Colorado, to try to get, and if you say, well, it's coming out of businesses that have budgeted for these, what you're saying is you're taking it out of the wages of Coloradans. You're taking it out of the bonuses of Coloradans. You're taking it out of the jobs of Coloradans. Because eventually these jobs leave. 1, because they can't afford to be here, and 2, they can't afford to keep jumping through hoops as the rules of the tax program change halfway through the tax year. So I asked for a ruling of the chair. This is multiple bills, and it should go back. Well, it should be set on fire and returned to from whence it came. But I asked for a ruling of the chair on this being multiple bills.
Brief recess. We'll take a brief recess. come back to order. The request is out of order, so to the bill. Representative DeGraff.
Okay, citizens of Colorado, your tax policy has just been majorly changed by these bills, by this multiple bills. So in order to explain that to the citizens of Colorado, because we're talking about 1222, it has been ruled that whatever is said on this title is in fact a single subject, and the only way to challenge a single subject, whether this is a single subject or not, is to take it to court. So the ruling on the circumvention of the Taxpayer Bill of Rights to negate your Taxpayer Bill of Rights, which in itself is a significant tax policy change, has been decided today. So what you've created for the children is the death of the Taxpayer Bill of Rights, because I can guarantee you that every single bill coming forward, it will be a tax increase with a commensurate spending increase to make sure that you do not get a say in the tax policy of Colorado per the Taxpayer Bill of Rights. So this is a historic day for the Bell Policy Center. So, citizens of Colorado, that clanging bell, that ringing bell is not liberty. That bell tolls for thee. Oh, okay. It's a big day for them anyways. So the government taketh, and then the government giveth away. That is the rule now of the Colorado General Assembly of the gold-domed cesspool. Okay, so Colorado, what else did you sign up for today? What else did you vote for today? Because the sponsors said people didn't vote for those tax decreases. They didn't vote for that $300 million to be reinfused into the economy of Colorado. So they took it away.
Representative DeGraff, are you to the bill?
Absolutely. They didn't vote on the taxes, so they took them away with they took away those taxes, overtime tips, and had them reimposed. Now they're taking the taxes that were changed.
Representative DeGraff, I don't believe that those tax changes are in this bill. Can you please stick to the policies in this bill?
Absolutely, Madam Chair. I understand why that would be a personal subject for you. But
Representative DeGraff, we will stand in a brief recess. The committee will come to order. To the bill, Representative DeGraff.
thank you, Madam Chair. These are major policy tax changes. And once upon a time, we took these major policy tax changes to the citizens of Colorado because we have something called Title 10, Article 20, the Taxpayer Bill of Rights. Today, you saw the death from the people who swore an oath to support that. Linking the tax program to a tax increase was convenient when it was a federal tax increase. And now, so what we've done is the sponsors of this bill have said, because those definitions changed at the federal level, those tax levels change, then they're going to change the definitions here in Colorado, decoupling them from the federal tax definitions, which is in itself a significant tax change. But because they came up with a special spending program for the children, so you can say that with music and tears, it's because they have a special program for spending that down to zero. So once again, the purpose of spending is taxation. I often say that a little bit cynically, but here it's proof. The purpose of spending is taxation. The purpose of increasing the spending for ESFAC is to justify more taxation. The purpose of this spending is taxation. Proof positive. Multiple states have modified these provisions. Yeah, multiple states are also unable to constrain their spending. Absolutely unable to constrain their spending. And where do they take it out on? Do they rein in their spending? Do they find that $285 million worth of fraud, the 40 million, the other 40 million? Nope. They take it out of the pockets of the citizens of Colorado or their own respective states and tax them more with celebration. It's de minimis. I can guarantee you the next one won't be. It's a tax policy change. As the sponsor said, it's one tax policy offset by another tax policy. Both of them require going before the taxpayer to taxpayers, and yet suddenly, with a wave of the magic wand, they don't. Why? Because, why did this one? Well, as my colleague explained, this one went down to zero because that tax credit was taken out of the surplus that was once upon a time $3 to $4 billion. But because of the success of the majority party of the Colorado, the Gold Dome cesspool, that excess was spent down to zero. And then suddenly all of the things that they used that they based on that excess went down to zero as well. So because they spent, now if you take that $4 billion and you divide that under 4 million voters, that would be roughly $1,000 per voter. For a family filing jointly, that'd be roughly $2,000 per year. And the General Assembly said, you don't need it, we do. And when they ran out of that money, they said, we're coming back for more, we're going to take it out of your job. Now, I suppose this can be sued, this can be challenged in a court of law. I hope it is. I hope there's a lawsuit that has to do with this and that there's because I think then the penalties are the damage plus 10%. But I want to also look at what else this does. Because we're just going to look at some rough back of the envelope math. That on the order of, and probably what the overall purpose of this is another that $20,000 to $30,000 non-citizens family in Colorado could end up claiming this new EFAC each year. By the way it's structured, intentionally structured, to take it out of the pockets of the citizens of Colorado, with a total EFAC outlays of these in the ballpark of $10 to $20 million annually. So we'll roughly call it $15 million as a midpoint, but let's look at why. Recent profiling shows that there are about 300,000 non-citizens living in Colorado, 245,400 children, roughly. In the state with at least one immigrant parent, about 92% of those children are U.S. born, so these are rough numbers. About 20,000 are non-citizen children. We certainly do not So those are citizens of another country. The citizens of another country, probably a socialist country, that has driven them out. If we assume an average of two children per immigrant family, and we do all the math, there are around 60,000 non-citizen families with children. Median non-citizen household income in Colorado is about $70,900. And about $90,000 for U.S.-born households. That's median, not average, not mean. Non-citizens have a higher poverty rate and near poverty rate. So yes, that is a problem. But what that does when you put people and you lock them into a status where they are permanently exploitable and expendable by the lack of documentation, you create a permanent poverty situation. So if you do the math, with incomes low enough, we say that's about 60%. Only about 70% will file EFAC. 60,000, that turns into roughly $25,000. It's not going to all be the highest end because some of these jobs are actually decent paying jobs that would otherwise go to citizens of Colorado. plausible average would be around $500 to $700 per year. So really on the low end, we're looking at subsidizing with the taxes of the citizens of Colorado, an additional $15 to $20 million for non-citizens. Why? This is the Colorado Fees for Feels program. It makes people feel good, and so they don't care if they take your money. They don't care if you are impoverished by their Fees for Feels program. The only thing that matters to the legislators in the General Assembly is the feels. And they will fee you to death, in this case tax you to death, because we know it's a revenue increase that has no specific spending, because they had to invent a program on which to spend it in order to give a large chunk of it to non-citizens of Colorado. Colorado, I hope you feel good about your fees, because the Gold Dome cesspool feels good about its feels.
Is there any further discussion? Representative Taggart.
Thank you, Madam Chair. It's an honor to serve with you.
It is an honor to serve with you.
If you would bear with me for a few moments, I'd like to explain how this bill affects us when we establish criteria as corporations for either business expansion or business relocation. And this bill is going to have a very significant impact on that situation. For those of us that have or have had medium to large-sized businesses, we in fact employ experts in this field. And those experts basically have a scorecard comparing state to state, a scorecard comparing it to local folks. And you will see this in advertising from time to time when states are out there competing for companies like mine to either relocate or expand. And I'll give you the 5 major criteria that those scorecards look at. And then I will put that in relationship to this bill and how we would score as a state. I'll give you 5, but I'm not trying to say one's more important than another. They're all important. But the first one is, if we were to consider expanding or relocating, how is that change going to affect our stakeholders? And our stakeholders are our employees, our customers, and potentially our investors. That is a very serious situation. And when we're thinking about it for our employees or our potential new employees, what's the cost of living going to be like for those individuals? How close are we to our customers? How is this going to impact our net profitability and our ROI as it relates to our investors? The second criteria that we look at is, in particular, if we're a manufacturing facility, how close is the proximity to the resources that we're going to need? Again, resources could be labor. Do we have skilled labor that's available to us? Are the raw materials close to us? Are there industry clusters that can support our business? That would be a second criteria. The third criteria would be, what is the cost of doing business in that state? And this gets to the situation of what are the rules and regulations of that state. The fourth criteria would be, and this one is a direct to this particular bill, what is the tax environment? Is it a positive tax environment in comparison to other regions or other states or other localities, or is it not? And the fifth one would be, what is the business culture like? Is that state or that region business friendly, or is that questionable? And when I started this, I said, these experts that we work with, because we've got to run a business that we employ as consultants, then give us a scorecard of various areas we might be considering, and let's say Colorado might be one. And I would be here to tell you, unfortunately, that we wouldn't, as a state, even get by the first round. We wouldn't get to the point where that consultant would say to me, Rick, you should go visit and look around with your team. Why? Well, the cost of doing business in this state has gotten too high. And the cost of living for our employees, potentially, is too high. Secondly, our tax environment is not advantageous whatsoever. And this adds to that problem. When you add those two things up, that scorecard would also say the business culture of this state is not conducive to us expanding in the state of Colorado or moving to the state of Colorado. You might ask, Rick, well, how do you know something about this? Well, I seriously considered moving the North American headquarters of Swiss Army all the years that I led it to come to Colorado because I wanted to come home. At that time, the only reason I didn't consider, in the long run, bringing the business here to Colorado was for one thing. I would lose employees, and I didn't want to lose employees. Today, if the scorecard was put in front of me, the cost of doing business, the tax environment, and the business culture would have ruled out Colorado before anything else. I would have never gotten to the situation of was it good for my employees? Folks, I understand we want to fund very important topics, but we are killing business to get there. And that's our revenue source. And we can't make up for that revenue source. We as a state need to be competitive with states all across the country. And we are no longer competitive. And it's getting worse and worse by bills of this nature. Please, folks, we have to stop. We have to vote no on a bill of this nature. Thank you.
Representative DeGraff.
Thank you, Chair. I move L014 to House Bill 1222, A, B, C, and D, and ask that it be displayed.
The amendment is before us. Please proceed.
Thank you. I just wanted to clarify this and put it on the record that for the ruling, that it was okay that House Bill 261222 represents multiple subjects for the purpose of our Section 21, Article 5 of the state constitution. I ask for an aye vote.
Representative Garcia.
Thank you, Madam Chair. I ask for a no vote.
Seeing no further discussion, the question before us is the passage of Amendment L14. All those in favor say aye. Aye. All those opposed, no. The noes have it. L14 is lost. To the bill, Representative Brooks.
Chair, thank you. I believe that probably, I'm sorry, it would be a discussion worthy on thirds to ensure that everybody has the opportunity to hear, hopefully, the words of our good colleague from Joint Budget Committee, an individual that has run a couple of businesses and just said on record, said on this microphone, that he wanted to move a business here to Colorado. Take into consideration, this was not last week. I don't know how long ago it was. It wasn't last year. And the business climate continues to become less and less friendly. And I guarantee you the business climate, the tax incentives, the erosion of support that we're giving to businesses to stay in Colorado has not improved, even marginally. I believe it's exponentially eroded since the time that he had considered bringing a business to Colorado but decided not to because he knew that he would lose employees. That's a real world example. That's real world proof of what our business environment is doing and how we are making it worse. I get the math in this building, in this chamber. 43 to 22 means it gets through. It doesn't mean it's right. The math doesn't mean that you're right about these things. And if you're wrong, and if it is having the kind of impact, the long-term impact that we're already seeing by businesses leaving the state of Colorado. I just read yet another article of another business that is leaving Colorado for Florida. This is not Palantir, yet another one. It's happening right before our eyes. It's happening as we stand here and debate a bill that further erodes the confidence of businesses to remain in Colorado and certainly come here. As my colleague said, and it was very fair, because I've seen him personally wrangle with decisions that have been very, very difficult for him to make, been very emotional decisions for him to make about whether or not we fund a program or do not. I'll admit freely, I'm far more of a callous individual than my colleague. I say that with a smile because it's true. He's having a hard time with these decisions because he understands that there is a need. I disagree with him in those cases. I think that we're creating needs where they don't exist. We're creating entitlement programs. I digress. I have a disagreement with him as far as the need. I do understand that there is a perception that a need exists. And I do understand that there is an effort to try to fill that need. There is, I understand, an effort to try to fund that need. The mechanisms we're using, folks, are going to have long-term detrimental effects on the state of Colorado. They already are. I would ask you to open up your little held hand computer and do searches on the businesses that are leaving Colorado. It's not going to take you long to be able to find that. The little computer is going to tell you that it is happening. You've got it in the palm of your hand if you wish to use it. I ask for a no.
Representative Richardson.
Thank you, Madam Chair. Spoke to some of the amendments that came previously, so it's probably not a surprise that I oppose this bill. And we can debate policy. I don't like the policy. But worse, I think, is the mechanisms that are trying to be employed in this bill. I'm going to try a little thought experiment right now. I declare the 2026 legislative session over. There, I declared it. But that doesn't make it so. I may want it to be true. The people of Colorado probably want it to be true because it would stop some of the madness. But wanting something to be true doesn't make it so. If it were, the world would be a very different place. The bill, previously, there was amendment brought to page 7. It's the legislative declaration. It's the things that we find to be true in order to underpin the policies that are being recommended. But as we just found, making a declaration doesn't make it true because we're still in session, even though many of the seats are empty. The claims in this bill very clearly, I mean, it's verbatim if you want to take a look at lines 4 through 12 on page 7, that the changes are merely incidental. And again, it's hard to make that claim that it's incidental to the main purpose of the bill when the title of the bill specifically says we're changing tax policy and we're going to use it to fund a program. That's not incidental to the bill. It is the primary purpose of the bill. It also claims that the changes to tax policy that are being made are de minimis. If you look at the fiscal note, year 1, 190 million. Year 2, 330 million. Year 3, 255 million. Year 4, 180 million. If de minimis means nearly $1 billion over 4 years, again, I will take that check. It is not de minimis. Those claims are just made in the declaration because of a case involving the Tabor Foundation and RTD. Well, in that case, RTD had changed some administrative procedures, and that was the purpose of their change. It was to increase some efficiency, some administrative efficiency. As a byproduct of that change, there was a truly de minimis change in revenue to RTD. And the courts did find that the purpose of the change was not to raise taxes, and the change that was made truly was very small. We heard earlier the sponsor also reference Lakewood. More specifically, it would be Metro PCS California versus Lakewood, and saying that this idea of net zero was examined in that case and validated. Well, that's not true. It may have been declared, it may have been spoken, it was not true. This courts did not even rule on the net zero argument. They didn't rule on that case on that argument. They ultimately didn't have to even get there because they decided that what Lakewood had proposed was, in fact, a new tax. So, though the net zero argument was printed on paper, it was not decided by any court. The Supreme Court of Colorado didn't have to decide on that. But they did reaffirm a few things. They did look at the concept of whether a change was incidental. They supported that. This is not an incidental change, as we talked about. They reaffirmed that de minimis was probably valid. This is not a de minimis change. Again, nearly $1 billion over 4 years. Hardly de minimis under anybody's definition. What they did indicate was courts will not let the government hide behind terms like incidental, de minimis, or even fuzzy net revenue gains. In fact, the final determination really supports that the intent and the effect of a change is absolutely what is controlling, not just the accounting labels that are used. This whole bill, based on that underlying declaration that we're trying to skirt around things by just making a claim of things that are not true, incidental, de minimis, it falls apart before you even get to Section 2 of this bill. Just on the face of it, regardless of what the policy that's contained in it, this bill is intending to defraud the people of Colorado. And we should vote no on it. And the sequels and prequels that are coming up over the next few hours in this chamber. Please vote no. At least maintain the dignity of this chamber.
Representative Luck.
Thank you, Madam Chair. The prior speaker declared that this General Assembly was over. He declared it. And then he made mention that if that were the case, it is his belief, a belief that I share, that many in Colorado would rejoice. He followed up by saying simply declaring a thing doesn't make it true. But in light of his desire and the desire of so many other Coloradans, I move to adjourn sine die.
That is a proper motion. The motion before this body is to adjourn. All those in favor say aye. Aye. All those opposed, no. No. The noes have it. The motion fails. To the bill, is there any further discussion? Seeing none, the question before us is the passage of House Bill 1222. All those in favor say aye. Aye. All those opposed, no. No. The ayes have it. House Bill 1222 passes. Mr. Schiebel. Madam Majority Leader.
She's laying it over. Oh, okay.
Madam Majority Leader.
Thank you, Madam Chair. I'd like to lay over Senate Bill 150 to after 12:30.
Senate Bill 150 will be laid over until after House Bill 1230. Mr. Schiebel, please read the title to House Bill 1289.
House Bill 1289 by Representatives Garcia and Brown, also Senator Weissman, concerning modification of certain tax expenditures.
Representative Garcia.
Thank you, Madam Chair. I move House Bill 1289 and the Finance and Appropriations reports.
To the Appropriations Committee report.
Thank you, Madam Chair. Today, in Appropriations, we adopted 9 amendments to House Bill 1289. In essence, we clarified that joint filers are eligible for the same credit amount as single filers under wildfire mitigation credit. We made a technical change under the e-bike tax credit to reference qualified retailer instead of retail qualified. We improved the administration of the credit. We also allow for better coordination between DOR and supporting agencies. And we create a process by which a retailer that is not in compliance can be removed from the program. We also address the concerns that came directly from the chamber on Water's Edge. And in that, we clarified that it doesn't pull in income to the corporate report if it's from a country that has entered into a double taxation treaty with the U.S. We also clarified that it doesn't pull in income to the corporate report if it's effectively connected to the conduct of the trade or business, and we also are making sure DOR's ability to disregard a C Corp's Water's Edge election is only applicable if the firm, quote, knowingly fails to comply with or recklessly disregards the statute, which was previously just fails to comply with. We also, in Amendment 37, we clarified under the property for use in spaceflight sales tax exemption that we were not, in fact, repealing that tax credit. We are simply delaying the credit that has gone unused for 3 years, and then it turns back on. And that was to the committee report. And then we also addressed the electric lawn equipment tax credit, where we improve the administration of the tax credit. We allow better coordination between DOR and supporting agencies. We created a process by which a retailer that is not in compliance can be removed from the program. We also passed 2 other amendments. One was directly around our tax havens a list of tax havens that we have in the state. This amendment is creating an independent review process for assessing tax and transparency criteria and recommending retentions of designation. And then finally, in L42, we are extending the EITC credit that is limited to families to eligible elderly, and we ask for an aye vote.
Representative Rutinel. Rep Brown, did you want to speak to the committee report? Nope. Rep Rutinel.
Thank you, Madam Chair. I just wanted to give a quick thank you to the bill sponsors for their work on this bill, specifically that last amendment that was mentioned, where they are expanding the earned income tax credit to make sure that we're covering folks over the age of 65. Right now, if you are over the age of 65, both at the federal level and at the state level, you don't qualify for the earned income tax credit, even though you're a working senior trying to make ends meet. And as we've seen with previous bills that we've passed, the earned income tax credit, the family affordability tax credit, these are tax credits that have proven something very clearly, and that is that poverty is a policy choice. When we passed and expanded those bills in the past, childhood poverty got cut by nearly 40% overnight. That is something we should be extremely proud of. Unfortunately, too many of our seniors are barely able to make ends meet. They have to work. They should qualify for the same tax credits. And so I want to thank the bill sponsors. I want to thank Representative Zokai, who was my co-prime sponsor on our effort this year to try to bring that bill. Just grateful overall for the work that we're doing. Thank you.
Representative Zokai.
Thank you, Mr. Chair. I just wanted to also take a moment and thank the sponsors for including this key provision that was added this morning in Appropriations Committee to remove the maximum age limit for the earned income tax credit. More and more older Americans are working later in life, and it is not because they want to, it's because they have to. Nearly 1 in 5 Americans age 65 and older are still in the workforce. And they cite rising costs, stagnant wages, and growing wealth inequality, which has left far too many older Americans without the retirement security that they were promised. In fact, today, nearly half of older Americans have no retirement savings at all. So what this addition did is allowed the earned income tax credit to be eligible to more people. Currently, for the EITC, you must be a resident who is working, earning a low to moderate income, and otherwise meet the federal EITC eligibility rules. It is a credit designed specifically to support people who are working but still struggling to make ends meet, and it is one of the most effective anti-poverty policies that we have. And I am very grateful that it is included in this wonderful bill that is before all of us today, because older Americans are facing an economy that no longer works for them. And it is because wealth has concentrated at the top while the cost of living rises for everyone else. And I urge a yes vote on the Appropriations Committee report and to this bill, because it will make a tangible impact on Coloradans' lives.
Is there any further discussion on the Appropriations Committee report? Or,
Is there any further discussion on the Appropriations Committee report? Representative DeGraff. We move the committee reports in reverse order. So we have started with the Appropriations Committee report. We will then move to the Finance Committee report. Representative DeGraff, please proceed.
Okay, just based on the comments, I would like, I think I'm glad that we have a point of agreement in that, and I look back to my previous bills, my efforts to expand the senior and disabled veterans tax credits, property tax credits. and making sure that they were portable and at least partially adjusted for inflation. And those were denied a couple years ago when we did not have the full up deficit that we have. So I'm going to be interested to see what was done here to do that. But I do agree that we need to provide the citizens of Colorado, because they have suffered because of rising costs. And as I pointed out, that under the Biden regime, there was a 22.5% inflation. That meant everybody's buying power was deflated by about 25%.
Representative Graff, I'm going to just gently nudge you back to anything that has happened in Appropriations Committee this morning. Please keep your comments to specific policies that we're discussing in the Appropriations Committee report.
Well, thank you, Madam Chair. I was talking about what you were talking about, that the citizens, I think they said that right, because there were rising costs. Costs rose because of the inflation.
Yes, and Representative DeGraff, my comments were to an amendment that was adopted in the Appropriations Committee this morning, so I'm going to ask you to keep your comments to the Appropriations Committee report.
Okay. So you don't want me to talk about 1222 chasing business and jobs out. So I'll move on and I'll let my colleagues speak.
Is there any further discussion on the Appropriations Committee report? Seeing none, the question before us is its passage. All those in favor say aye. Aye. All those opposed, no. The ayes have it. The Appropriations Committee report passes. To the Finance Committee report, Representative Garcia.
Thank you, Madam Chair. So in finance, we brought a really large amendment, L001, that made significant changes. I think the most important change that I want to mention is that what we did in, actually that was L002. So L001 did a whole bunch of different changes to the Opportunity Zone program, to the Water's Edge election, changes to the corporate income tax, the Opportunity Zone program. We made changes to the Innovative Truck Credit. We also made changes to the Pine Beetle and Wildfire Mitigation Credit. We addressed changes to the Community Food Access Program, which is Section 9. We also made changes to the Geothermal Industrial Energy Credit. We addressed some technical corrections in the Sustainable Aviation Fuel Credit section, and then a lot of this was really technical changes that we needed to do to the lawn equipment, the electric lawn equipment tax credit, the rail safety use and tax expansion, the beetle kill sales tax exemption, as well as a cigarette vendor fee. And then in the changes to the Enterprise Zone Program credit, we made some corrections to the original draft to the Enterprise Zone reforms to align with our intent of what we were expecting. We also we are clarifying that no longer impacts to new employee credit and only restricts the health insurance credit. And then we also made some changes to the commercial vehicle credit. L2 is where we repealed, I'm sure if you all remember the thousands of emails you got about gold bullion, L2 is the amendment where we repealed that sales tax repeal. And then L3, we repealed the sections of the bill that convert the property tax rent and heat credit program into an actual refundable tax credit. And we asked for an aye vote.
Is there any further discussion on the Finance Committee report? Rep. Hartsook.
Thank you, Madam Chair. As you just heard in finance, there were a multitude of amendments, and some of them were huge. We were playing catch-up trying to read all of them, and there are significant changes. One of the things that in finance that we discussed at length was the impact of all these taxes and everything that's going on. Along that same vein, I move L59 to 1289, request to be properly displayed.
That is a proper motion. One moment. And that amendment is before us. Please proceed.
Thank you, Madam Chair. One of the things, when the state levies taxes on businesses and businesses have to collect that tax, there's a cost, not only of the tax, but there's a cost to the business of collecting that tax. In this particular case, specifically the cigarette stamp purchases, these are taxes that are required by the state. The state has the business collect that, publish it, do everything else. So if you buy cigarettes, you see that little stamp that's on there. the state used to sell those stamps, this tax piece, to the businesses at a 0.4% discount, kind of like the vendor fee. There's a vendor fee that we used to have until last summer in the special session when we got rid of it to businesses. So what you now have is, in addition to the regular tax, you have a de facto tax that is because the business has to absorb that, and that will get passed on. In this particular case, this is a requirement. You must have the cigarette tax. It's non-negotiable. The state requires it. The business is required to do it. Up until this massive legislation came through, the business would get a 0.4% vendor tax, a necessary rebate almost, discount, so they could pay for putting the stamp on, the labor, the machine, everything that's involved in doing that stamp on the cigarettes, so then they could send it to the retail for sale. This takes that away. That is, in a net effect, that 0.4% immediate tax suddenly on businesses. What this amendment is saying is like, no, we're going to waive that, we're going to cut it out. We should not be putting something through and not calling it a tax when it is a tax because we're taking away the reimbursement for the vendor fee. That is a sleight of hand. If you're going to say business, you have to put this tax stamp on the cigarettes. And oh, by the way, I'm going to charge you for that tax stamp because you have to remit that to the state. And all along you've been given that credit for that. And now suddenly the state says, no, we changed our mind. We are not going to give you that credit anymore. We're not going to give you that discount on the vendor fee. You're going to pay all of it. That is an immediate 0.4% tax on that business that will be passed on to the consumer. Now, whether you agree or disagree with cigarettes and smoking at this point is irrelevant. What is key on this tax issue is that there is suddenly this 0.4% tax that is levied on businesses. That is wrong. I urge an aye vote on this amendment. Thank you.
Rep. Brooks.
Chair, thank you. You know, there'll be a little bit of a repetition with what I am going to say when I speak in favor of this amendment with what my colleague had just talked about, that we did something very similar to this, if you remember. I try to forget. The special session, not so special, the not so extraordinary session that we had where we removed the vendor fee, removed the fee for like restaurants to collect and then remit the tax. This is very similar in that way. And, you know, to my colleague's point, it's, you know, I mean, cigarettes, it drives me nuts how we keep passing taxes and increasing taxes on it, because I think there's this it is absolute inaccurate notion. Be like, well, if we tax it to death, then people are going to stop smoking. And, you know, smoking's nasty, so I don't like smoking, so let's tax it. As a matter of fact, we have like one of the highest tax rates in the nation, and, you know, like many things in this chamber, we're skyrocketing our way to number one. I think the national average is about $1.97 a pack, median of $1.80 in taxes. If you remember under Proposition EE, where we hoodwinked the taxpayers again to say, hey, cigarettes are bad, okay? So let's go ahead and let's do some more in the way of tax collection on the backs of cigarettes. It's going to go up to $2.64 per pack. We look at this, if we want to have conversations, we want to have serious conversations about the last bill and some of those measures being de minimis. Goodness gracious, this is what, we're talking about $400,000 a year, I think. Still, eliminating this, it shifts the collection costs entirely onto private distributors for a very small general fund gain. This covers the wholesaler's expenses when it comes to the administration, the finance, remitting the excise tax. Honestly, when I look through this bill, and it was presented, and we talked about helping out seniors. I mean, really, this is going through and prioritizing the things that we believe are good, which is a lot of what my colleague calls green grift, and then masquerading it as something else. I ask for an aye on this amendment. This retains that de minimis cost that is yet meaningful to the wholesalers in the collection and the remittance of the excise tax.
Representative DeGraff.
Thank you, Madam Chair. Yeah, this was put in there. Again, what the government giveth, the government taketh away. The purpose of promising everything is to take it. So I guess the blood money on collecting this tax on behalf of the state was this rebate. Because there's cost involved. There's bookkeeping costs, there's reporting costs, there's all the costs that have been mentioned. But once again, besides destroying the Taxpayer Bill of Rights, because that is anathema to the purpose of the Colorado General Assembly, now literally, I suppose it's more figurative than literal, but by the words, by the literary intent of the words, the General Assembly is shaking our small businesses upside down by the ankles to see what will come out of their pockets. Because they set this in motion. They said, we're going to need somebody to collect this tax. We have to collect this tax, so you're going to do it for us, so you're going to do the work for us. Because what would that be if you just said for them to do the work but didn't reimburse them? The word is coming to me. It rhymes with compelled labor. Oh yeah, I think it's slavery. So this is just another compelled labor. Is the state, besides removing the remuneration for doing its dirty work, is the state going to give them that money back? No. Is the state going to stop requiring that they do that work on behalf of the state? No. The state has just decided, from each according to their ability to each according to his need. So in this case, their ability is to do that, and they don't need to be reimbursed. And that's the nature of socialism. Somebody will decide how much you produce, and that same person will decide how much you need to take. So if you want to know what the brave new world looks like in utopia, it means you work for the government and you don't get paid. Here's another example.
Representative Barone.
Thank you, Madam Chair. Members, I come up here in support of this amendment simply because of the reason that I see the business side of this. I toured a wholesaler this off session. Of course, I can't speak the name here at the well, but I seen the operation of putting this tax stamp on these cigarette packets. I seen the machine that is being used to do this. They do it safely, they do it effectively, and they do it only when those cigarettes have been sold to a distributor. Now, there's one person that's operating the machine certain times during the day. Now we're taking away this discount, which helps out with that overhead cost to the wholesaler. And on the business aspect of this, I'm seeing that now we're taking that away. Now we're adding to the overhead of this wholesaler. This wholesaler is not going to eat that overhead. You know what's going to happen? It's going to be placed on the cost of the good, which in turn gets placed on the consumer. It's a trickle-down effect that's going to happen here. Either that, which is most likely, or this is going to eat into the bottom line of that wholesaler. And it's going to, it's not, probably this is not going to be the end all of the wholesaler leaving the state, but it's another step towards that. And trust me, we take a lot of those steps here to where these businesses leave the state. It's a small percentage, 0.4% discount. But it's huge to these companies. It is huge. I support this amendment. I urge an aye vote.
Representative Brown.
Thank you, Madam Chair. We asked for a no vote on this amendment. This amendment is really about consistency. We've passed some policies similar in terms of collecting and remitting sales tax, actually just during special session. And so this amendment is in line with that work that we had previously done. I will also just say that while I appreciate my colleagues and their commitment to the Constitution and the Taxpayer Bill of Rights in particular, we are allowed to make tax policy changes. The TABOR does not prevent us from doing that. We can make decisions about what tax credits or what tax expenditures we can make. That is not unconstitutional. I understand that they may disagree with that, but that doesn't necessarily make it unconstitutional in and of itself. So I appreciate their commitment to the bottom line and to folks' taxes, but we asked for a no vote on this. This is really just about consistency.
Representative DeGraff.
It is weird how we disagree on the Taxpayer Bill of Rights, because I think we can make tax policy changes for things like decreasing revenue, no change in revenue, but clearly the purpose of this change is to increase revenue. And I do appreciate pointing out that this is just the second, in that you did a similar thing and I'd forgotten all about this with the most recent extraordinary tax spend debt session, at the cost of, I don't know, a couple $100,000 to the citizens of Colorado in order to tax them more to get us out of a deficit because of overspending. That you did is pretty much the same thing on the collection of sales tax. So the government will continue to have you do their dirty work, and they will continue to say we're not going to pay it because we have other programs to spend it on. Not necessarily citizens, of course. We wouldn't want our spending to be burdened by things like proof of residency. So, citizens of Colorado, this is a great amendment because it brings forward just two of our socialist thoughts on from each according to his ability to each according to his need. You will work, you will not get paid, you will like it.
Seeing no further discussion, the question before us is the passage of Amendment L59. All those in favor say aye. All those opposed, no. The noes have it. L59 is lost. To the Finance Committee report, Representative Marshall.
Thank you, Madam Chair. It's an honor to serve with you.
It's an honor to serve with you.
I move Amendment L044 to the Finance Committee report of House Bill 1289. Ask for it to be displayed.
That is a proper motion. And given that this is more than a page, I will note that it was received timely. Please proceed, Rep. Marshall.
Thank you, colleagues. Many of you have heard me down here quite concerned about the IDD caregivers, because in less than 2 months, with that other bill being passed and the long bill, they're going to be cut 25% in the income that they've been expecting, and it will be 50% in the next year. I really think we need to have a glide path for that community and not do it in such a horrible way. So we couldn't do anything with the budget, but with the grace and help of the sponsors, looking at doing a refundable tax credit, which normally I am not a fan of, but I think it's a blunt instrument that can at least solve some of the wounds that would come from this. So 30% for those, only those who are at the max hours who are going to be cut back for the next 3 years. So I ask and hope we can get a lot of support for that. Thank you.
Is there any further discussion on L44? Representative Garcia.
Thank you, Madam Chair. Members, I just want to rise and say that we do support this amendment, and we ask you to say yes.
Seeing no further discussion, the question before us is the passage of Amendment L44 to the Finance Committee report. All those in favor say aye. Aye. All those opposed, no. The ayes have it. L44 passes. To the Finance Committee report, is there any further discussion? Rep. Marshall.
Thank you, Madam Chair. I move Amendment L065 to the Finance Committee report of House Bill 1289.
That is a proper motion. Please proceed.
So, colleagues, we have been devastating so many of the citizens in Colorado and the residents of Colorado across the board with cuts. We've spent hours blaming each other's side for why it's happened, but it's happened. I mean, we know the numbers don't lie. We got a massive hole. We have to make it up. What's particularly disturbing, I think, though, in terms of optics, is at the same time we're cutting all the providers 2% across the board, we're demanding that the IDD community take a 25% cut in income within 2 months. And when we're taking Medicaid away from so many or reducing the benefits, our commission report that automatically gives all the state elected officials a pay raise goes into effect at the exact same time we are devastating all these other communities. That's just not good leadership. That's not the leadership I learned, and I don't think it's the leadership a lot of us learned. We should share the pain. And we could try to do a late bill to delay the pay raise 1 year, and that would be my preference. But given we only have 13 days left in the session, and I'm not sure we could get a late bill to delay, this is the second best option. For just one tax year, beginning January 1, 2027, we'd impose a tax of 100% on the increase of pay from the Pay Commission. That's the 6% increase for us and the 45% for the Attorney General. And again, we're talking 1 year because that 1 year is the year we are devastating so many in the state of Colorado. And if we cannot share the pain with our constituents, we really shouldn't be here. So for that reason, I hope we can support this amendment. Thank you.
Representative DeGraff.
I'm in agreement. Our purpose here is to secure these rights of the citizens of Colorado. Now, we can talk all we want about about these programs. We could have looked for finding this money in all of the various fraud. I mean, we point out one department, over $300 million worth of fraud found in one department. We could talk about keeping that going. I mean, not finding that, making sure we root that out. Now, instead, it's just going to keep going. Because the solution is just always, well, we don't want to give the, the government employees, everybody has lost money because of the inflationary policies. I get that. But so have those families. Be an example to your men in your duty in your private life. Let them see by your endurance of fatigue and privation. Something like that. I don't remember the whole thing, but my colleague does. I'll try to remember it a little better. It just came to me now. But if we're going to be leaders, if this room is going to be leaders like the pretense of being leaders instead of dictators, then we lead. We lead in the pain, and we follow in the gain. This bill is about leadership. This amendment is about leadership. Especially when the pain emanates from this room. It comes out from the policies of this room, the boot on the face of the citizens of Colorado stomping over and over again forever comes out of this room. And we've seen this morning that the sponsor's previously bill will just make that boot stomp harder. So I'm in favor of this bill. I'm in favor of this amendment. Because leaders lead in the pain and they follow in the gain. Ma'am, I understand your question. That was a reference to Orwell.
Representative Bradley.
Thank you, Madam Chair. I also rise in support of this amendment. The previous representative just talked about one department that I have talked about over and over this session, $285 million in fraud by one federal audit, $25 million in rideshare fraud for one audit, $78 million in an ABA audit. We're cutting caregiving hours and hours to the IDD community. We've heard from these parents. They cannot afford these cuts. They are begging us. Provider rate cuts are being cut another 2% in the state. Why not put this raise on hold? Why not tell the people of Colorado that we see you, we hear you, and we will stand with you? Why not tell them that we are also serious about the budget crisis that we are in, the affordability crisis we are in, that we all are struggling with you to afford groceries and electricity and all the same things that you guys struggle to do? And that right now it is unfair for us to take a pay raise while we watch you struggle to put food on the table and to keep your electricity on. This is a fair amendment. And then I think I can go to my town halls after the session ends and say, and look them in the eyes and say, we did our due diligence, and the rules for thee are also for me. If we're going to be serious, I don't think I can say, well, I didn't vote for the pay raise anyway. Just to be clear, I did not vote for legislators to get a pay raise. Being in a second fiscal crisis, again, for the second year in a row, headed probably into another special session, I did not vote for that. But this is a good amendment. Put it on hold. Let's tell our taxpayers that we are serious about not adding to the budget while we are cutting hours for caregivers in the IDD community. If I could give part of my raise to that community, I would do that. But right now, let's cut this for those of us in this building, and let's be more fiscally responsible in here. I urge an aye vote. Thank you.
Representative Luck.
Thank you, Madam Chair. This is tax policy I can understand and get behind. Thank you. I noted a couple of days ago that I'm not a fan of tax policy and its complexity, but this is one that everybody can get. Basically boils down to the idea that state elected officials, as well as legislators, don't get a pay raise next year. That's it. Don't get a pay raise. Yeah, we get money in, but then we get taxed on those dollars. And yes, that does sort of burden us with respect to our federal tax liability, and there are some other complications, but what's good for the goose is good for the gander. And if we're willing to impose ourselves on other people's lives in such a way as that, then we should be willing to receive that same imposition on our own. I'm grateful for the amendment sponsor for bringing this forth. I enthusiastically support it.
Representative Soper.
Thank you, Madam Chair, and it's an honor to serve with you.
It's an honor to serve with you.
I also agree with my good colleague from Fremont County that this is definitely an amendment that what's good for the goose is good for the gander, that here we're cutting off other people's budgets, we're passing on unfunded mandates to our counties and our municipalities. We're saying to everyone, tighten your belt, try to do less with more. And then the General Assembly is about to have the biggest pay increase probably in the history of this state. And what the amendment would do is it would say there's 100% tax on that pay increase, so it would all be pulled right back into our budget, not necessarily budget for the General Assembly, but for the state of Colorado, because we should really be saying, if we're making other people cut their budgets, we will do the same as a General Assembly. So I appreciate where this amendment is coming from. I think that members should get behind this and say that as we're facing tough economic times, we shouldn't then be accepting a massive pay raise for doing the work. Thank you.
Representative Kelty.
Thank you, Madam Chair. I am absolutely up here in absolute support of this amendment. You know, there's no better way to lead by example than showing that we understand the fiscal hardship that we're going through and that we would definitely, no problem, allow our pay to be halted so that the people of Colorado understand how serious we are about taking care of the fiscal responsibilities that we have been handed by them for us to handle. So when I worked for a company, he's gone now. I worked for a gentleman named Ross Perot. I was a junior executive. And we went through some difficult times. And at that time, all the executives decided that we would forgo our bonuses, which were in our contracts. But we all decided to go without those bonuses. We piled them together and gave them to the rest of the employees in the company, because that's how you lead by example. I doubt there's anyone in here that will fall apart if they don't have their pay stay the same for a year or two. I think we're all pretty okay in that department. But you know who's not? So many other people, so many other Coloradans across the state. So if we want to actually say that we're taking things seriously about our budget and the critical nature that it's in, this amendment does exactly that. This amendment is probably my favorite amendment of the day, and I am asking for an aye vote, most definitely.
Rep. DeGraff.
Thank you, Madam Chair. There's only one problem with this, and that I think it would generate a Tabor trigger, because this would, in fact, now perhaps, I don't know, perhaps it would be considered de minimis for this 100% taxation, but I thought, and I'd like the, I'll talk to the sponsor offline on this, but proposing that this becomes a not tax increase by creating a simultaneous spending program where this money goes to the IDD community and provider rates in case there's any extra. So that way, this would not be a tax increase. Otherwise, this is conceivably a tax increase. So what we'll do is we'll say it's not a tax increase because we'll simultaneously create a new spending program to give it to the IDD community, and that should make the sponsors very, very happy. So I'd like the sponsor to consider that as a potential amendment. I think it's called a conceptual amendment, conceived of, to become an amendment at some point in the future, as conception does. So I like this amendment, but I think it needs to be complete.
Representative Garcia.
Thank you, Madam Chair. In addition to the fact that this violates probably one of the only things that the supporters know of Tabor, that this is an actual tax increase and requires to be a vote of the people, this also violates Section 8 of Tabor, in which you can't have different tiered of taxes. So this amendment is straight up violating Tabor, and we just had the party of the Tabor protectors coming up saying, vote yes! So, with that, I ask for a no vote.
Is there any further, Representative DeGraff?
You are correct that this is the party of protecting the taxpayer Bill of Rights. But like I said, you should lead in pain, and you should follow in gain. I missed something going on here. But, so as the defenders of the taxpayer Bill of Rights, I'm willing to also offer that 100% and get that and have that, and I'm willing to take it. I am willing to take that. Do we need to have a conceptual amendment also to take this before the voters of Colorado? I would be in favor of that. I think we could make a ballot initiative to take this before the citizens of Colorado and ask them, would you like to see the pay raises taxed at 100% for 1 or more years to pay for these services for our IDD community? I do appreciate the clarification, and I am willing to expand the conceptual amendment to make sure that it goes to the people, and we'll see if the people are in favor of the General Assembly getting a big raise when they don't.
Is there any further discussion? Representative Luck.
Thank you, Madam Chair. For those listening in, let me just explain that we have reached that time in the session where a little bit of levity and frivolity is important to keep sanity. And so I think a number of the folks who do otherwise support the Taxpayer Bill of Rights did come up in strong support of this amendment in light of the foolishness of it, in hopes of being able to point out the underlying foolishness of these larger conversations and the hypocrisy in it, but also to add a little bit of levity at a very important time.
Rep. Soper.
Thank you, Madam Chair. And I did want to come up and follow one thing, that hasn't really been mentioned. You know, it certainly is good that we have now learned that both sides know what the Taxpayer Bill of Rights is, and that it's in our Constitution. It does not require, or allow, I should say, does not allow for different percentage rates for taxation. I think that's good that we've gotten it on the record that we all know that. So I did just want to say that and appreciate that that's out there.
Rep. Marshall.
Thank you, Madam Chair. So we had a colleague come up and say it's in jest and it's in frivolity. It's not meant that way. It came up in the early morning because I've submitted a late bill request to delay our pay raise by 1 year. Not sure that will be forthcoming, and this idea came. I would not support this legally, but in the terms of de minimis of what else this body has pushed through, and in terms of differing percentages compared to what this body has put through, I think it falls right in the black. And if challenged, I suspect the requirement for standing would need to be one of the legislators here in the Capitol to bring the suit to ask the court to overturn, to get the 6% pay raise while we are cutting providers 2%, and we're cutting IDD community 25 to 50% during that time period. That's not a suit I would want to see on the front page. So again, can this be revised and amended? Certainly. And it should have that opportunity going forward. We got a bill that is a laundry list of de minimis items, items that may not be Tabor compliant themselves for increasing taxes and violating Tabor. And again, in the overall scheme of things of this bill, this amendment would be very small. So I ask for support. Thank you.
Seeing no further discussion, the question before us is Amendment L65. All those in favor say aye. Aye. All those opposed, no. No. The noes have it. L65 fails. To the Finance Committee report. Is there any further discussion? Rep. DeGraff.
Hey, Madam Chair, I move L049 to House Bill 26-1289.
Are you moving it to the bill or to the Finance Committee report?
To this green paper, the Finance Committee report.
Can I have you restate that motion?
I move L049 to the Finance Committee report for House Bill 26-1289.
That is a proper motion, and the amendment is before us. Please proceed.
Tell me 3 or 4 times, I catch on right away. Okay. So we have all these de minimis things. But the one I want to look at right now is the tax credit for expenditures made in connection with geothermal energy project. Now, one thing that we know about this state is that it has screwed up its energy program. And I only say that because we've spent $17 billion, over $17 billion, in decreasing our dispatchable energy by over 40%. And we are now at the point where we are normalizing public safety, power shutoffs. We're normalizing things like, hey, we're going to just give you a brownout because we put a smart meter on your house and that's what they're for. We've normalized these things because of pet projects in the air. Now, this one is about geothermal, and I'm a fan of geothermal. I built a whole geothermal house. It was really cool. I mean, it was cool until the bank stole it. But it's cool in the summer. It's warm in the winter. The people that purchased it enjoy it. But the Industrial Clean Energy Tax Credit and the separate Geothermal Energy Tax Credit are already substantial tools that give refundable, transferable income tax credits for industrial, and this is the whole decarbonization thing. For crying out loud, Colorado. I asked the other day, just because I had to, not because I enjoy watching the Colorado Energy Office or CDPHE or the Polish Utility Commission squirm because they can't answer the question, but they all defer back to the General Assembly and say, yeah, those climate goals that we have, we don't know what they are, but we're imposing them because the General Assembly said so. And I've asked, including the sponsors, what those climate goals are. Not a single clue. And I say climate goals because climate goals are different than carbon goals, and the climate goals would be a temperature. And if we assume, of course, that 100% of the 33 degrees Celsius, that is the greenhouse effect, and we factor in the 0.125 billion tons of CO2 and divide it by the 3,300 billion tons in the atmosphere, we get a whopping 0.00125 degrees Celsius that you could possibly change with the $17 billion that we have changed none of. Yet the sponsors are going to continue to drain your pockets for their pretended goals, make your energy more unreliable, and pretend that they're saving the planet because fees for feels will continue until the voting improves. Geothermal projects with an existing $35 million aggregate cap for geothermal credits under Section 3922, 552, House Bill 26-1289 does not just clean up those credits, it lets Colorado Energy Office move unused cap from industrial clean energy credit into the geothermal credit, so we're just shifting around, and we already talked about the bill the other day that these unused credits can then be sold. So you take these credits, you expand them, and then you create this line of credit, literally a credit card, for the drunken sailor that lives under the gold dome of the cesspool, that then we can sell those credits. Now, you get 82 cents for the cheeseburger today, and then you pay it with $1 on Tuesday, but That's the way credits work. I mean, that is a massive interest rate. Opening the door to much larger geothermal studies without a clean upfront debate on that new cost. And that clean upfront debate doesn't need to happen because this makes somebody feel good. Geothermal already has a dedicated capped credit. Mixing geothermal and industrial cap blurs the priorities and makes the program harder to manage and oversee. But again, the purpose of promising everything is to take it. So I ask for an aye vote on this amendment. Let's just clean up our tax policy. Nothing against geothermal, I'm a big fan. But the savings used in geothermal are their own motivation. And what we know when a government program gets involved in something like this, what it does not generate success, it just generates fraud. So, which is another purpose of government. So I ask for an aye vote on this amendment. Let's clean up our tax code, stop the fees for fields, and get back to some serious, actual, legitimate energy policy.
Representative Brown.
Thank you, Madam Chair. We ask for a no vote on this amendment. The geothermal tax credit is an important one. It's part of our all-in energy solutions that many of us have been talking about, and particularly if we are interested in renewable energy and promoting that, then making sure that we are incentivizing geothermal is really important. So we ask for a no vote on this amendment.
Rep. DeGraff.
And I didn't say anything against that. Now, renewable, it's just such, there's just so many misnomers in this world of fees for fields. Renewable energy just means you have to replace the infrastructure on a regular basis to provide the investors another 10% on the billions of dollars of infrastructure paid. That's all that means. Solar, wind, they just have to be replaced on a regular basis. Solar generates lift, lift generates thunderstorms, thunderstorms generate hail, hail turns solar panels into hazardous waste. Wind just blows them over. So all renewable is, when you're talking about renewable energy, is you're just talking about renewable subsidies. You're not talking about anything that actually benefits the citizens of Colorado, because this program, again, Citizens of Colorado, this new renewable fees for fields program, has cost you $17 billion, over $17 billion, plus another 10% on that for the investors to invest your money to get the rate of return. That's why your utility rates have jumped up like they have, because you have to pay for all those power lines stretched across Colorado to reach the solar and wind fields, because that's where you harvest diffuse energy. It's energy, not power, because power is energy over time. You have to have the availability. So Colorado, you've paid $17 billion to achieve a subfraction of 0.00125, and the only thing renewable about it is the subsidies that the fees for fielders are going to impose on you every time they come up here. So I do respect the amount of creativity that the fees for fielders put into this type of program, that they have found a way to tap into. Instead of tapping into the mineral resources of Colorado, they've managed to tap into the imagination and fear of Coloradans. And that seems to be boundless. It accomplishes nothing, makes them feel good.
Representative Luck.
Thank you, Madam Chair. Fun fact about geothermal energy, real quick. Colorado's state capital, first state capital to be powered on geothermal energy. Our heating and cooling is done through geothermal energy. Just thought that I would add that into this important conversation for those who are not all that familiar with what it does.
Representative DeGraff.
I just wanted to throw out why we don't need these kind of subsidies. I talked to a mining operation the other day, and they want to turn their entire program into geothermal. They could run the generators, they could run the fans, they could do it all with geothermal right now. Do they need a subsidy? No, they just need permission. They need permission. And who would give them the permission? Well, the Polish Utility Commission would give them permission. So why don't they just give them permission to do it without having to take money from the citizens of Colorado or do these things? Because that's not the purpose of it. The purpose of these programs, these giveaways, is to favor certain industries, to money launder into other industries, other favored players. You don't need to incentivize things that make sense. And that's how you make sure they make sense. What doesn't make sense? Electric cars. They don't make sense. Why do we have so many? Government subsidies. What doesn't make sense? Solar panel, wind. Why do we have so much of it? Why have we spent $17 billion to lose 40% of our dispatchable energy to get public safety power shutoffs? Because of government subsidies. The entire caucus is about the opportunity of sucking up government subsidies. Make it stop.
Seeing no further discussion, the question before us is the passage of Amendment L49 to the Finance Committee report. All those in favor say aye. Aye. All those opposed, no. No. The noes have it. L49 fails. To the Finance Committee report, Representative DeGraff.
Thank you, Chair. I move L051 to the Finance Committee report for House Bill 26-1289 and ask that it be displayed.
The amendment is before us. Please proceed.
I feel like I'm missing out here in the front row. Okay, tamale license plate to run the film office. Okay. Sustainable aviation fuel credit. Let's see, retail, jet service, Jet A, $7 to $8 per gallon. SAF, 8 to 13 gallons, depending on higher. Depending on the location and the credits. For example, U.S. airport averages for SAF have been reported around 1036 per gallon. So those are actually down, so that's encouraging. It's going in the right direction, but basically you're looking at spending more energy to get less energy. And then putting a credit on top of it so you offset. So in order to buy aviation fuel that's more expensive, you give that purchase a credit so that the credit goes comes out of the pockets of the citizens of Colorado. So for this mandate, the climate mandates, the taxes, the climate taxes, because since they achieve absolutely nothing, then more taxation is certainly the only reason to do it. Well, besides behavioral control. So instead of mandating it and then driving up the cost of the prices, what they do is they mandate it and then they give a credit in order to offset the costs so that it goes to the taxpayers who would have otherwise paid it if they were just paying it directly. Now there's shipping and handling involved, of course, so that you end up paying more for the credit than the value, which is zero, in order to spend more to make the fees for feelers feel better. The fiscal note estimates that the SAF purchase credit will reduce the general fund revenue by about $1.5 million and $3 million per year in fiscal year 2028-29. So we're going to mandate that they use this, and then we're going to give a credit, and then we're going to lose money out of the general fund so that we can then take the money out of the IDD community. You, not we, it's you. When federal law already provides significant SAF incentives, which I think is a bad idea, hopefully they'll change that, including the federal SAF credit under the IRS code 40B $1.25 per gallon plus a supplemental amount. So that's about 10%. So the federal level already pays for it. This is just another way to launder money to preferred industries, to pretend that we're doing something for the climate. You're not. You can't point to any positive benefit in the climate. It achieves absolutely nothing. It makes you feel good and virtuous, and I don't think that's worth the money of Colorado.
Seeing no further discussion, the question before us is the passage of Amendment L51. All those in favor say aye. Aye. All those opposed, no. No. The noes have it. L51 is lost. To the Finance Committee report, Representative DeGraff. Welcome back.
Welcome back, Madam Chair. I move L053 to the committee report for House Bill 1289 and ask that it be displayed.
That is a proper motion. Please proceed.
We're going to go all the way to page 11 of this rewrite of this 15-page rewrite, in addition to the other rewrite, of a bill that has about a 20-page fiscal note, and I think it's about 63 pages overall of grift and giveaways. And so I ask for what this does is it strikes lines 1 through 15 on page 11. The renewable energy investment provision lets large enterprise zone renewable projects turn their existing 3% enterprise zone investment credit into an 80% refundable cash payment up to $750,000 per year per taxpayer instead of waiting to use the tax credit against tax liability as effectively a new refund mechanism for big projects that increases near-term general fund costs by millions of dollars with highly uncertain upside and absolutely no climate benefit. Well, I say absolutely none because I think a fraction of 0.00125 is close enough to zero. The Ledge Council estimates that making these ITC credits refundable will reduce income tax revenues by about $0.8 million in 26-27, $1.9 million in 27-28, and $2.3 million in fiscal year 28-29. And what are these tax credits purposed for? They are purposed for fees for fields. They're not purposed to accomplish anything. The sponsors have no idea. They have absolutely no intent of having any idea of what they would accomplish. They'll spout off something about carbon goals. Carbon goals have absolutely nothing to do with that other than possibly 0.00125. That doesn't mean they're not going to continue to siphon money into favored programs. The caucus is going to take that opportunity to siphon money into other programs, and they are not that there's any kickbacks. So this is just another Fees for Fields program. It's costing Coloradans money. It's achieving absolutely nothing. Everybody knows it. Nobody cares. I ask for a yes vote.
Seeing no further discussion, the question before us is the passage of Amendment L53. All those in favor say aye. Aye. All those opposed, no. No. The noes have it. L53 is lost. To the Finance Committee report. Is there any further discussion? Seeing none, the question before us is the passage of the Finance Committee report. All those in favor say aye.
Aye.
Aye. All those opposed say no. The ayes have it. The Finance Committee report passes. To the bill. Representative Garcia.
Thank you, Madam Chair. I want to thank the chorus in the front row for the entertainment. Appreciate it. Members, we have today before you, oh, wait, do I have to move anything?
No.
No, great. We have today before you House Bill 1289. Like what happens generally almost every year is the state evaluates its tax policy, it evaluates its tax credits, its tax expenditures, and it decides whether it's the purpose of the tax expenditure is being met. It decides if the investment is appropriate, if the return is appropriate. It really evaluates the efficacy of the tax expenditure that this body has created years before
and puts forward recommendations for adjustments and modifications. And that is exactly what 1289 does. And it's bringing to you multiple purposes of modifications. And before we get into all of the details of what we're trying to accomplish in 1289, many of which you already heard because they were already tried to be amended out, I will turn it to my co-prime.
Representative Brown.
Thank you, Madam Chair. I appreciate this. And I just want to say what a pleasure it is to be on this bill with my good co-prime, who I think has distinguished herself as one of the great tax experts in this building. And this has been truly a labor of love. And so I just appreciate all of the work that she has put into this bill. You know, this bill is really about making important updates to a range of tax expenditures. We're expanding some, we're limiting others, and we're eliminating certain provisions. And a lot of these are based on recommendations by the Office of the State Auditor and program administrators. We're really trying to implement best practices in state taxation policy. Some of our provisions remove rarely used state expenditures. Other provisions implement things like things related to fuel tax reductions, or they make important changes to certain economic development tax incentives to be more targeted and efficient. We spend a lot of time on federal opportunity zone program and offering, and the tax treatment are related to that, and we make some significant changes to this program that are to the benefit of Colorado. So for that, I will turn it over back to my co-prime sponsor and just say that we appreciate your support.
Back to you, Rep. Garcia.
Thank you, Madam Chair. Okay, I'm just going to run through the different provisions of this bill because it is complicated and it's addressing multiple different expenditures. And I just want to make sure we are all understanding what we're trying to accomplish in 1289. The first part is we are clarifying for the rail safety sales and use tax expansion. This bill clarifies that this major safety expense for passenger rail construction is covered by the rail sales and use tax exemptions and including local sales and use taxes. Regarding the Opportunity Zone decoupling, this bill requires gains on Opportunity Zone investments to be added back to the income to be subject to the state tax unless the investment was from within the state of Colorado. This means that what we are saying here is we are incentivizing in-state investments. This provision would also ensure that corporations can't use this loophole to decrease their Colorado taxes. Regarding 280C and 951A deductions, for those of you who are unsure about what that means, it's basically a provision in our federal tax code that prevents double dipping. And what we're doing here is we are, adjusts for double dipping. So what we are doing here is we are repealing the 280C deduction for Colorado and the 951A deduction in order to stop this exact double dipping tax benefit at the federal and at the state level. For innovative motor vehicle tax credit, we are increasing the credit for 27 and 28, and we are increasing the price cap for eligible vehicles from $35,000 to $40,000, and we are removing the automatic reduction tied to the revenue forecasts. Pine beetle and wildfire mitigation credit. This provision expands eligibility to actions to mitigate the spread of pine beetles. I'm sure many of you have had to deal with that last summer, and you'll probably have to deal with it again. Take advantage of this. The bill would expand eligibility to ease administration and increase overall uptake while also lowering the cap and the total credit allowed to reflect underutilization. With regards to electric-powered lawn equipment tax credit, this bill would make this credit eligible for quarterly prepayments. We heard from businesses that annual payments makes it really difficult, and so we wanted to make it easier where they could actually receive a credit on a prepayment basis to be able then to provide the service on the electric-powered lawn equipment without going into a negative revenue, a negative income before they get the credit at the end of the year. Industrial facilities credits. This bill expands the industrial facility tax credit so nonprofits and other non-tax entities can also qualify. The bill also creates a new geothermal energy tax credit, which, whew, we almost could have possibly gotten rid of in the amendment, but thank you for holding strong. We also have a heat pump tax credit, which removes the triggers that currently exist, which would cut the credit in half in future low budget years. Heat pumps are major money savers for households, and if we risk this tax credit, we risk the ability for people to be saving up to $18,000 on a heat pump for their home. The electric bicycle tax credit. This bill removes the triggers, which would cut the credits in half in future low budget years. It's the same concept that folks that need to get around town, can't afford a car, can still get the credit for the e-bike that allows them to get around town. The sustainable aviation fuel. This tax credit, we changed from being a tax credit dedicated to establishing refineries or the systems that will create the cleaner air for aviation to a simple tax credit for the purchase of cleaner aviation fuel. Again, thank you for holding strong and not letting this one get repealed either. The beetle kill sales tax exemption the provision extends the beetle sales tax exemption to 2031. And the property for use in space sales tax flight exemption, we were going to repeal it. We were going to say, see ya, because it's not being used at all. However, we heard that it could possibly be used in the future, so we are just putting it on hold for 3 years, at which point it'll turn back on. The fuel tax deduction, this reduces the allowance from 2% to 1% and repeals the 0.5% allowance for special fuel. We already talked at length about the vendor fee alignment, so I'll go ahead and skip that one. The enterprise zone research and development credit. This bill limits this, again, we also talked about it, I'll just repeat it, to businesses who spend at least $150,000 on research and development each year, limiting it to the most impactful research and development spending in the enterprise zones. And our enterprise zone vacant building credits. This bill clarifies that buildings that are not rented out for at least 135 of the previous 180 days are eligible, and the maximum credit amount is increased from $50,000 to $200,000 to keep up with construction and labor costs. If you care about how vacant buildings are being used, you would like this. We also removed Liechtenstein from the state's tax haven list. Yay.
We cheered.
For you. Well, for them, yes. And we also require DOR to conduct a study every few years to revisit our tax haven list and make recommendations.
Representative Brown.
Thank you. And I just want to add that I just want to appreciate the work of the staff on this particular bill. Mr. Sabetsky and his team in LCS have done an amazing amount of work analyzing the 30 sections of this bill. And there are 5 different fiscal analysts that are listed on the fiscal note. So I think it goes without saying that our LCS staff is phenomenal, and on this bill they have really distinguished themselves.
Representative Garcia.
Thank you so much for that, for saying that, Representative. And I want to just second that, even to the dedication that the fiscal analyst staff did in preparing the amendment from appropriations, or preparing a new fiscal note of the amendments that we passed in appropriations this morning, and being able to get us an updated fiscal note within the same day. So props to them. And I also want to thank the lead organization on this bill with the initials FCI, not in that order, for all of their work in analyzing these tax credits and tax expenditures as well, and making sure that we stay on track. With that, we ask for an aye vote.
Representative Johnson.
Thank you, Madam Chair, and thank you, sponsors, for the thorough explanation for House Bill 26-1289. It seems like a bill where you just want to say, but there's more, and you keep going and explaining. But appreciate the thorough explanation. A lot of it seems like deja vu. We saw a bill in the committee this year already addressing the pine beetle issue. We saw in 2023 already addressing, why we led into the electric lawn mowers and everything else. And the list can go on of everything that we've had, whether it's coming in to modify or duplicate. But one of the things that really hit me, that I was listening to, was the special fuel loss in transit allowance, and cutting that in the
what it was claimed was to put money back into the state budget, but what it really is going to do is take money out of the people's wallet. I move L057 to House Bill 1289 and ask that it be properly displayed.
That is a proper motion. And the amendment is before us. Please proceed.
Thank you, Madam Chair. So what this bill currently does before this amendment is move the special fuel loss in transit allowance cut from 2% to 1%. What my amendment is doing is striking the motor and special fuel loss in transit allowance cut to leave it at 2%. Why is this important? Well, Colorado's motor and special fuel excise tax allow distributors a 2% loss in transit and unloading deduction from taxable gallons to account for unavoidable evaporation and handling losses. This happens when you move liquids around. They're going to evaporate. What House Bill 1289 does by reducing this allowance from 2% to 1% is going to put a lot of cost onto those who are selling these gallons of gas, and that's going to be moved into the people. Right now we're seeing it, gas has hit over $4. In some areas it's getting close to $5. If more cost is put onto the people going to fill their vehicles so they could get to work and get to their children's events or to hospital visits, we could easily see our gas prices skyrocket to $6 or $7 a gallon. That is going to be expensive for Colorado. The 2% was designed to match real, unavoidable fuel costs. The state auditor's evaluation notes that the loss in transit allowance was set to reflect typical evaporation and handling losses and is meeting its purpose. Lowering it to 1% assumes that distributors can eliminate physical losses that are largely inherent to transporting liquid fuel. This is beyond their ability to stop it. We are accounting for natural things of occurrence. While this is a tiny revenue bump, it effectively will be a backdoor fuel tax increase on distributors. Again, another attack on oil and gas industry. While we heard of everything else promoting renewable energy. If we are all for all energy, why are we picking one over the other? And why are we putting it at the expense of the people of Colorado? I urge a yes vote.
Representative Brooks.
Chair, thank you. Want to make sure to be able to get in my comments before y'all are asked for a no vote. Just in case it might change the outcome of whether or not asking for a no or a yes. Look, I mean, my colleague covered it, that if we go, this is just, I mean, it's, first of all, Liechtenstein, all right. Look, if we're nickel and diming to this extent, we know we're going to push up the cost. You can't sell something you don't have, right? This is an evaporative margin that was allowed for the transport, right? Things happen during transport. This is something that can now not be sold because that product has been lost. It has been lost in transport. There is, Office of State Auditor understood that there was a reason for an in-transit loss allowance to reflect typical evaporation and handling losses. That was set at 2%. Now we're cutting that by 1%. What does that mean? That we just eat the 1%? Oh, it's gone. It's okay. No. You know that it's going to result in the increase of cost. You know that it's going to increase in that being passed along straight to consumers because they have to make up that margin somewhere. If we're stealing the nickel and dime margin from them on what the Office of the State Auditor has already recognized as a very reasonable allowance for transit loss, that needs to be made up somewhere. These little cuts, little nickel and diming, they don't happen in a vacuum. They don't happen in some place to where we can just do it and move money from one place to another and think that that's the end of the story. What is the downstream effect? What is the downstream impact? What is the unintentional, perhaps intentional, but what is the unintentional consequence of the $6 million that we're moving around for environmental programs? gets passed on to consumers. Office of the State Auditor set this as a typical allowance for evaporative transit loss. I believe this is a very reasonable amendment to keep that in place to try to defray yet another cost that will be eventually passed on to consumers. I ask for an aye vote.
Seeing no further, Representative Brown.
Thank you, Madam Chair. Just real quickly, we asked for a no vote on this amendment. This particular section of the bill actually comes from the state auditor themselves because the 1% is actually what was determined to be the actual amount of fuel that is lost based on research. 2% was too high, 1% is the actual, so that's what we're going to give folks credit for.
Representative Johnson.
Thank you, Madam Chair. And I would question what was said. 2% was designed to match real unavoidable fuel costs and fuel losses from the state auditor's evaluation notes. This is confusing when looking at it, and why is it set right now in current statute at 2%? Because that's what was determined to be due to these losses. And now we're saying something else when that is, there is a question of when we have two contending pieces of information, and we are in the last 13 days of session. Maybe this is something we need to slow down, pump on the brakes, and come back next year if we're going to have data from 2%, 1%, 1% to 2% being questioned. This should be concerning to Coloradans as we're playing with what the effect of this will be is higher gas prices when you fill your vehicles up, when you're already struggling to pay for your groceries, your medications, and your students to be involved in school activities. This right here, what we're hearing in this well, with the difference of statistics and information is why we need to pump the brakes. I urge a yes on this amendment.
Seeing no further discussion, the question before us is the passage of L57. All those in favor say aye. Aye. All those opposed, no. The noes have it. L57 fails. To the bill, Representative Garcia Sander.
Thank you, Madam Chair. So I have a, question about the Colorado Enterprise Zone vacant building, Section 31. I was getting ready to sing do 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 mana do 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 do, and then you could come up. So Section 31, that addresses Colorado's Enterprise Zone vacant building rehabilitation credit. And that section gives owners or tenants of long vacant commercial buildings in enterprise zones a state income tax credit equal to 25% of rehab costs, capped at $50,000 per building if the building's at least 20 years old and has been completely unoccupied for at least 2 years. And I'm concerned because Section 31 of HB 26-1289 will weaken that standard by letting a building qualify after only 183 days, or any 135 days in 180 in the fiscal note. And it's 183 days in the bill summary of the vacancy and quadrupling the cap to $200,000 per building. If that sounds confusing, it's because it is. The credit, to me, seems like it's no longer focused on truly long-term vacant buildings. The current law requires a building to be unoccupied for at least 2 years to qualify, ensuring the credit targets genuinely stuck properties. The credit targets genuinely stuck properties that private markets have not been able to bring back into use. And so by shortening that time frame, it means that your building is not really stuck as vacant. And that blurs the line between long-term blight and short-term turnover, and it dilutes the credit's original purpose. Also concerning is quadrupling the cap to $200,000 per building when we're talking about a year when we're facing the structural deficit, when we're trying to trim costs from everywhere we can. We're expanding the cap from $50,000 to $200,000 per building and shortening the time that a building has to be vacant. That just doesn't seem like it's meeting the original policy intent. And so with that, I move L054.
That is a
And
proper motion.
And ask that it be displayed properly. Sorry.
Amendment is before us. Please proceed.
Thank you, Madam Chair. This amendment will bring the easy enterprise zone vacant building rehabilitation credit back to current status quo, meaning 2 years, which is a perfect time period, and the $50,000 cap, which is not expanding the cost to government. So with that, I urge an aye vote.
Is there any further discussion on Amendment L54? Representative Johnson.
Thank you, Madam Chair. And I would also urge a yes vote on this. This amendment would bring it back to the original policy intent when we were looking at vacant building credit. The purpose was to tackle long idle properties in distressed enterprise zone areas, not to help owners of buildings that happen to be between tenants for a single leasing cycle. I know in rural Colorado, we have a lot of, they're towns, many that don't have post offices, so they're villages. We have a lot of areas, communities on the cusp of becoming ghost towns because they are struggling economically. This is where the original intent was for, to help these communities get back on their feet and thrive when there are so many other burdens pushing down on them against small businesses in the state. For the areas that have many vacant buildings that have been vacant for years because no one could afford to build that back. Not to help between just because of a cycle, because someone left to expand or they left out of Colorado because they couldn't afford anymore. And then we had it vacant 6 months, a year. This bill takes away from that intent to help the communities who are truly struggling. This amendment puts it back into the intent of helping Coloradans, and I would urge a yes vote.
Representative Barone.
Thank you, Madam Chair. I also come in support of this amendment, and I want to speak to the door this is opening. As somebody that buys homes, refurbishes them, and rents them out, or I even have the option to sell them now, given the prices of homes right now. Under this bill, I can buy a home that's totally messed up. Walls are falling, everything like that. It'll take me about 8 months to rebuild that home to a place where I can either rent it or sell it. I'm seeing that loophole right now. Do you think if I see that, other people are going to see that? It's going against what the intent of the bill sponsors are actually wanting to do, to help the people that really need this. I see that loophole opening, that door opening, to where now I can buy a home right away, qualify for this tax credit, and resell that home at a higher price, or rent that home at whatever price I want to rent it to. So I strongly urge a yes vote on this amendment, so it goes back to the intent of this tax refund, or the bill, and help the people that actually need it, and not opening that loophole up for people that are going to be prying and taking advantage of this for their own gain. I urge an aye vote.
Representative Garcia.
Thank you, Madam Chair. Thank you for bringing the amendment. It allows us to have a conversation about what exactly enterprise zone vacant building credits do. So what this credit particularly does, it actually helps owners of vacant buildings in these enterprise zones that are at least 20 years old rehabilitate their property. This requires, though, that the building has to be vacant for 2 years with even a couple days of renting it out or in between. Like, for example, a haunted house. We've seen a lot of times haunted houses are used in some of these vacant buildings to make a building ineligible for the credit. That means that then, if you use it for a week for Halloween, even if it's been vacant the entire year, you're screwed. You can't access this credit.
So what we are doing is we are actually trying to just clarify that the buildings that are not rented out for at least 135 days of the previous 100 days, that they are eligible for the maximum credit amount, and that it's increased. The credit amount is actually increased from $50,000 to $200,000 to keep up with the construction and the labor. So this is actually a really good update. What we're doing here is we are saying, look, you can have your haunted house, you can have your spring fling, you can have your festival for Valentine's Day, and that's not going to impact you because you are not renting the space for the duration of 120 days. So I think that if you pass this amendment, you are actually reverting this update to what currently exists, meaning, sorry, you can't have your haunted house, you can't have your little festival, you can't have your fair, your spring fling, otherwise you lose the opportunity for the credit. So I kindly ask for a no vote.
Representative Johnson.
Thank you, Madam Chair. And I've heard some great things from the sponsor that sparked questions and our colleague before that who sparked questions. When looking at the market, specifically the private market, which sometimes gets lost in this building as we think government should come in and swoop in and save everything, but when looking at the market and looking at the communities who are truly struggling, it's not because there aren't businesses wanting to come in and take these buildings when something leaves. It's truly because the market that this state has created is driving business out, and we are leaving deserts behind of communities that are struggling to survive. That's why we have that 2-year cycle, to see if naturally the private market, the free market, can bring it back, and if the community has the aspirations or the resources to do so. That was the original intent, to help those who direly need it. In communities where we see buildings vacant for whatever reason, in more thriving, successful areas, we're not seeing these buildings get left empty that long. But due to the way this is amending it to 183 days of vacancy as opposed to 2 years, it almost looks like this is a benefit to those who are richer, and this will discredit those who are truly struggling in the areas that need the help, is what I was hearing, and I just want to make sure I hear it right, because communities who are truly struggling aren't the ones that are putting these haunted houses in place. Rural Colorado, we don't have the resources. We're struggling to put it out in the corn mazes to bring up what revenue we have for the area. So it really is the areas that direly need this that I feel like are going to be left out because of this change.
Rep. Garcia.
Thank you, Mr. Chair. It is particularly keeping in mind the lower income businesses, rural communities, that this cleanup is necessary because we are increasing the credit from $50,000 to $200,000. They are getting $150,000 more than originally because we understand that there's a huge cost to renovating buildings. So this is actually a positive credit for rural Colorado, for industry or for businesses, small businesses that own a building but they can't afford to do anything. That is what this credit is intended to do. It's supposed to help them update. It's supposed to help them be able to renovate their buildings if they're within the enterprise zone.
Rep. Garcia Sander.
Thank you, Mr. Chair, and I appreciate that explanation, but really the purpose of this originally sounds like it was to be a blight reduction tool, not a general purpose renovation subsidy. And so, this is not for renovating your Airbnb or your event center. This really is supposed to be a blight reduction tool. So I urge an aye vote on this.
Seeing no further discussion, the motion before us is the adoption of L54. All those in favor say aye. All those opposed say no. The amendment fails. To the bill. Rep. Bradley. Rep. Marshall.
Thank you, Mr. Chair. It's an honor to serve with you.
It's an honor to serve with you.
I ask to move Amendment L045 to House Bill 1289 and ask for it to be displayed.
All right, that is properly displayed. To the amendment, Rep. Marshall.
Colleagues, this is a random sample pick, but this is a serious one. When the bill was brought forward that has 30-plus sections, sometimes it's difficult to plow through every section. But there is one that did, and 2, 3, maybe 4 or 5 that caught my attention. But this one, there's very good evidence for why it should not be in there. When it was brought,
Rep. Marshall, hang on a second. Members, it's too loud in here. We cannot hear the conversation happening in the well. Rep. Marshall. To the amendment.
this is not meant to cast any aspersions, but when it was brought, I thought I asked what was a simple question for the electric vehicle credit. Do we have any evidence of its effectiveness? The purpose of the electric vehicle tax credit is to increase the number of electric vehicles that will be bought. We have several years of the credit being in place. Is there any data? Colorado Energy Office said no, they don't know, and there's no good studies. But that's not true. The Congressional Research Service, the nonpartisan, very professional Congressional Research Service, has produced studies on the effectiveness of electric vehicle credits. And I tried to explain those studies, but since it was tax and tax law, I probably wasn't very good at explaining it. So I'll read straight from the Congressional Research Service report. Marginal versus infra-marginal tax credit recipients. The efficiency of electric vehicle tax incentives depends in part on the degree in which they induce marginal electric vehicle buyers or accrue to infra-marginal EV buyers. Marginal EV customers are those whose decisions to purchase or not purchase an electric vehicle are directly impacted by the existence of a tax incentive. Put differently, they are on the fence or the margin with regards to their decision. In contrast, infra-marginal buyers are those who have decided to purchase an EV regardless of the tax credit. The tax credit may cause infra-marginal buyers to purchase a more expensive EV, but it does not motivate a decision to purchase an electric vehicle. It goes on and then says, while the precise estimates differ, the literature on electric vehicle tax credits suggests that most tax credit recipients would have purchased an EV without the credit. For such individuals, the credit represents a financial windfall. A windfall, meaning just handing them tax money from the taxpayers. Studies of the reformed credits suggest that roughly 7 out of 10 electric vehicle tax credit recipients are inframarginal. Multiple studies have an estimate of the inframarginal share of being 67 to 77%. And the CBO estimates a share of 68%. These estimates align with studies of other EV tax credit programs, international ones. Estimates that for the previous versions that which predated the IRA, the tax incentives, 70% respectively of tax credit recipients were inframarginal. 74% of consumers receiving a rebate for a hybrid vehicle would have bought the hybrid without the rebate. Finally, when the German government abruptly and unexpectedly eliminated its $4,900 EV subsidy, sales fell 26.6%, consistent with roughly 3/4 of subsidy recipients being inframarginal, meaning 75 to 80% of the money we send out for these EV tax credits goes right into the pockets of people without doing what is intended, to induce further purchases. And who are these people?
Well, the Congressional Research Service also has the distributional effects. Again, since I'm not very well versed in tax policy, I'll probably just have to read it directly. Economic theory suggests that the people benefiting from tax credits are not always the people who receive them. For example, if the government creates a new $1,000 tax credit for buying electric vehicles, and if this credit increases demand for electric vehicles such that car dealers are able to raise prices by $700, then consumers are only $300 better off. On paper, it appears that consumers receive a $1,000 EV tax credit, but economists would note that consumers receive 30% of the credit's incidence, whereas car dealers receive 70%. Drawing upon such findings, we'll get to just the basic conclusion. On the distributional effects, %50 of all the money for tax credits go to the top 5% of the income levels. Only 3% to the bottom 60%. And 70 to 80% is wasted money of not inducing any further electric vehicle sales. There are better ways to achieve climate goals. This one is a fantasy if you think it's doing what you think it is. Some people, faced with evidence, change their opinions. Others hold on to opinions throughout. The evidence is pretty clear. This is a tax credit that would definitely benefit my district. It's one of the few things in the entire tax code here that benefits my district. But my district doesn't want this. Those numbers, too, of saying 70% are inframarginal, that's based on the federal $7,500 tax credit. This bill is increasing it from $1,000 to $2,000. Well, we can continue to lull in mediocrity, or we can actually look at some studies and understand what's going on.
Further discussion on L45. Rep. Brown.
Thank you, Mr. Chair, and I appreciate my good colleague from Douglas County's passion for this particular issue. I will say that my community very much values electric vehicles, and especially since as I was driving here this morning and I passed our local gas station and saw that gas was now at $4.59, there's never been a better time to have an electric vehicle where you're paying significantly less than that on a per mile basis. But I will just say that I honestly think that my colleague and I are looking at similar data, but we're coming to very different conclusions about what's going on. Since the repeal in particular of some of the federal tax incentives, sales of EVs have plummeted, which indicates to me the exact opposite, that the incentives that we have in the market are helping people to afford these vehicles, that people want to buy these vehicles if only they were at parity and in terms of cost with other vehicles. In fact, in the first quarter of this year, EV sales are down 64%, and plug-in hybrid sales are down 73%. And they're dragging down all overall vehicle sales in Colorado by nearly 20%. There are many low and moderate income households who are purchasing EVs. Almost a third of EV buyers have household incomes less than $100,000. And for a family of four, that would easily qualify you for the kinds of assistance that people would need to afford their health insurance if you purchase it for yourself on Connect for Health Colorado. So what we are doing in this bill and what this amendment repeals is an increase to our EV sales tax credit, which will help to mitigate some of the harm that the federal government has done to not only the EV market, but to consumers' pocketbooks and ultimately to our environment. Because we know that the EV sales are helping not only our climate, but our communities as well. So we ask for a no vote on this amendment. I think it is, I just think it is wrong, and that the increasing the EV tax credit here in this bill is the right policy.
Rep. DeGraff.
I always appreciate a good, solid application of the laws of wishful thinking. All right. Start with climate goals. There are none. You don't have any, you can't define them. Now, what are they based on? Let's look at the EV sales. They're based on the application of the exploitation of slave labor in third world countries and destroying the ecology of the same. Let's look at the losses of these EVs. I think it's great that the EV sales are down because it's a parasitical venture. If you look at the billions of dollars that are lost on EVs, that's the reason, plus the drop, that's the reason that these are going down in production. 2025 operating losses on EVs. This was just for Ford, $4.8 billion, improved slightly from a loss of $5.1 billion in 2024. Big write-down impairment, $19.5 billion announced in late 2025, mostly for asset impairments, canceled EV programs. Cumulative impact since 2022, EV losses exceeded $15 to $16 billion. Adding the write-down brings the fiasco cost to around $35 billion. Ford overall reported an $8.2 billion net loss for 2025. Where did those costs go of that government mandate? Those costs went on came out of the pockets of those who bought ICE vehicles, internal combustion engine. So that's why I call the EVs a parasite. They are living off others. They're living off the internal combustion engine vehicles. And those people that need actual reliable vehicles, they're paying the price for the rich, for the EV toys for the rich. As my colleague said, and the other tried to defer. Per vehicle losses have been extreme in some quarters, tens of thousands of dollars per EV sold, sometimes reported as $20,000 to $50,000 range, depending on the period in accounting, as high development, battery, and production costs outstrip sales volumes and profits and pricing amidst softening demand. And so what's the government solution to that? Is to throw $1,000 at it. But would that encourage you to buy that car? No, it wouldn't encourage you to buy that car, so that cost is rolled into the cost of your friends' cars. It's a parasite. Context in imposed ICE vehicles. Let's look at the cost per gallon. What's the equivalent cost per gallon if you roll in all those subsidies? If you take those subsidies out, if you don't push that $50,000 per vehicle onto your neighbors, what is your cost? The most commonly cited figure, cost estimate of EV fuel when factoring in subsidies, regular credits, infrastructure burdens, and related cost is around $17.33 per gallon. Now that's a figure that's a couple years old, so right now it's probably a little bit more. Again, EVs are parasites. I guess the cars are not themselves a parasite. But the costs of the EVs are imposed onto your neighbors. So when you're driving to work and you're saying, I'm paying $1 a gallon, it's because your neighbors are paying $16.33 per gallon for you. That's a parasite. Then, in order to encourage that parasitical behavior, the government imposes taxes on the productive and then gives the tax incentives to the same parasites. That's wasteful spending. This entire bill is behavior modification based on from those who think that they can manipulate the market with their cleverness. Instead of allowing the free market to work. We don't have a free market. We have a FUBARD market, and it's been FUBARD by those who have absolutely no idea how the market works. Because in fairness, nobody really knows how the market works. Supercomputers can't match it, and yet we come into a room like this, and then it's like, well, if we tweak this and tweak that, instead of just getting the face-stomping boot off the face of the citizens of Colorado. Imagine a school playground, 100 kids, packs of Pokemon cards, handed out at random. You let it play out. Very quickly, an order emerges. The good players accumulate rare cards, the collectors sort, the negotiator deals. No one planned it, and yet every card ends up in the hands of those who gets the most value from it. The system maximizes the total happiness of those in the playground. That's the invisible hand. Now bring in the teacher, the Karen. She finds it unfair. Leo has 50, Tom has 3. She confiscates, redistributes, enforces equality. Then 3 immediate effects. The good players stop playing. What's the point? The bad ones have no reason to improve. They'll get their share anyways. Trades collapse. The playground is equal and dead. The teacher's problem is that she can't have the information the playground had collectively and unknowingly. This entire bill is about behavioral modification. This is just a great example of why the citizens of Colorado need to get out of it. And this is another example of why we need to get rid of things like the EV tax credits that encourage some Coloradans to be parasites on their neighbors.
Seeing no further discussion, the motion before us is the adoption of L45. Rep. Marshall.
A couple quick corrections. One, this isn't just stopping the increase. This was a full repeal. They're going $1,000 to $2,000. And again, the federal tax rebate was $7,500. And the inframarginality for that is about 25 to 30%. I gave citations, so I asked for some more. The citations we got actually did confirm a 27% drop. So the question is, do you think this is an efficient use of tax dollars? You can have climate goals. We don't even have to argue about that. We have emissions issues in Metro Denver. We don't have to argue about that. The question is whether this is an efficient use of tax dollars to get to that goal. All the evidence says it's not. It's a subsidy for the better off. My parents live in Evergreen. There's Teslas all over that place. There's Teslas all over in Highlands Ranch. And I'm sure there are Teslas all over in Boulder. But I don't see them being driven around in lower income neighborhoods because just like the Congressional Research Service, which I'm citing, the nonpartisan, very professional Congressional Research Service, who has access to all the federal government's tax data, 50% of all these tax dollars go to the top 5% of income levels and only 3% to the bottom 60%. That's what we're voting for. It's an inefficient government program that's subsidizing the wealthy. Please vote yes.
Seeing no further discussion, the motion before us is the adoption of L45. All those in favor say aye. All those opposed say no. The amendment fails. To the bill, Rep. Richardson.
Thanks, Mr. Chair, colleagues. Yeah, we haven't talked about HR 1 for a while. It's a shame that it made us give tax credits away and impact our own revenues. Oh, wait, it didn't do that. Those were decisions we made. I move L047 to 1289 and ask that it be displayed.
That is displayed to the amendment. Rep. Richardson.
Thank you, Mr. Chair. This amendment will allow the electric lawnmower tax credit to expire as it was planned to at the end of this year. Very simple. We've heard multiple times over the years that good policy is based on good evidence. We heard in an earlier amendment that we really should be paying attention to what our state auditor says. And we don't have evidence regarding the impact of this credit. This was meant to encourage adoption of more electric mowers in replace of gas-powered ones. The auditor has said that they can't determine the actual revenue impact of the electric lawnmower equipment credit. And the available data is not sufficient to tell how much it actually incentivized any shift from gas to electric. The statute that established it explicitly said the credit meets its purpose only if sales of new gasoline-powered equipment are significantly reduced within 5 years after the credit takes place. There is no evidence yet that gasoline equipment sales are significantly down because of this subsidy. So what has this done for Colorado so far? It's certainly reduced revenues when we apparently need revenues very badly. What has it done for the planet? We don't know. What evidence do we have that the program is achieving its goals? We have none. So in this fiscal environment, adding on tens of millions, and this is nearly 35 million in 3 years, to subsidize lawn equipment when we have so many other pressing needs is really a poor fiscal trade-off. I think we should let this program expire as it's planned to, and I urge a yes vote on this amendment.
Seeing no further discussion, the motion before us is the adoption of L47. All those in favor say aye. Aye. All those opposed say no. The amendment fails. The question before us is the adoption of House Bill 1289. All those in favor say aye. All those opposed say no. The bill passes. Mr. Shebo, please read the title to House Bill 1223.
House Bill 1223 by Representatives Woodrow and Basenecker, also Senators Ball and Roberts, concerning modifying certain tax expenditures.
Mr. Speaker Pro Tem.
Thank you, Mr. Chair. It's an honor to serve with you.
It's an honor to serve with you.
I move House Bill 1223 and the Finance Committee report.
To the Finance Committee report.
Thank you, Mr. Chair. In the Finance Committee, we ran through a couple of amendments working on the clarifying the eligibility thresholds for the FAC, clarifying that this is a state-level exemption only, and then also clarifying a state law linked to the sales tax base of special districts like RTD and other districts. We also ran a decoupling amendment, and that was about it. We asked for a yes vote.
Rep. Woodrow.
We don't, actually.
Thank you. Before we ask for a yes vote, I move L007 and ask that it be displayed in the manner the front desk deems appropriate.
All right, that's more or less displayed to the amendment. Rep. Woodrow.
Thank you, Mr. Chair. It's an honor to serve with you, sir.
It's an honor to serve with you.
So, folks, we ran a decoupling amendment, as my good co-prime said, in the Finance Committee. It turned out after further stakeholding with our local government partners, we needed to tweak the language a bit. That's what 007 does, is it makes the decoupling clear so we don't get tripped up down the road. We ask for an aye vote on L007.
Seeing no further discussion, the motion before us is the adoption of L007. All those in favor say aye.
Aye.
All those opposed say no. The amendment passes. Seeing no further discussion, the motion before us is the adoption of the Finance Committee report. All those in favor say aye. Aye. All those opposed say no. The Finance Committee report is adopted. To the bill. Mr. Speaker Pro Tem.
Thank you, Mr. Chair. I'll keep the description brief because I'm sure we'll have plenty of chance to discuss. But House Bill 1223 repeals the downloadable software sales and use tax exemption that the legislature created in 2011. Right now, someone buying software online will not pay sales tax on that software, while someone buying the same software in a store pays it. The tax code shouldn't treat the same product differently based solely on whether it is downloaded or delivered on a disk. And at the same time, Colorado families have benefited from the Family Affordability Tax Credit, which helped offset rising costs for household. This bill ensures that the revenue gained from updating the sales tax treatment of digital software supports a permanent family affordability credit, helping families without raising net taxes. It's a simple, fair, and balanced way to make our tax code more equitable while protecting Colorado families.
Representative Woodrow.
Thank you, Madam Chair. It is an honor to serve with you.
It is an honor to serve with you.
So, colleagues, the downloadable software exemption exempts software downloaded from the internet from sales tax while keeping the same software purchased at a physical store subject to sales tax. No matter how a good is delivered, taxpayers should be treated the same. Most other states treat software like a tangible good subject to sales tax. Colorado should align with this standard. Only 7 states still exempt electronically delivered software: California, Florida, Kansas, Nevada, South Carolina, Virginia among them. Custom software for a specific user remains exempt, preserving software tailored for individual businesses or users. We've also identified that certain home rule cities, Aurora, Denver, Colorado Springs, Fort Collins, and Lakewood, all impose a sales tax on software regardless of its delivery method. Before we turn the discussion over, I move L012 and ask that it be displayed.
Please hold. The amendment is displayed. Please proceed.
Thank you, Madam Chair. What Amendment L012 does is it ensures that the amount allocated to the Housing Development Grant Fund stays constant despite sales tax revenue increases. It's largely technical. It's what we intended to do from the get-go. Appreciate the bill drafter catching it and making sure that we are effectuating the intent of the legislation. We ask for an aye vote.
Any further discussion on L12? Seeing none, the question before us is the adoption of L12. All in favor say aye.
Aye.
All opposed? The ayes have it. L12 is adopted. Representative Woodrow.
Thank you, Madam Chair. Before we turn the debate over and leave the well, I just want to thank my co-prime sponsor for his dedication and work on this policy and for being such a great colleague the last almost 7 years now. It has been an honor to serve with you, sir. I'm going to miss you terribly. We ask for an aye vote.
Any further discussion? Representative Hartsook.
Thank you, Madam Chair, and I hate to rain on the happy farewell parade here, but thanks to the sponsors. You know, we had a great discussion about this bill in finance. What I would like to point out, we've been debating, I don't know, half the day now, tax issues, tax bills. There's been tax credits, tax vendor fees. There's been all kinds of things we've debated. I have personally lost count of the number of fees, taxes, and things that we have added to small businesses, and this is another one. It was just stated we're coming in compliance. Most states do this, not all of them, but most. Some places do it, some places don't. But here's the bottom line. Here's what matters if you have the small business that's out there. This will impact you, and this will impact your bottom line. And that means you either have to raise your costs to the consumers, or you have to reduce your expenditures or cut back. There is no net zero on these things. When there are taxes levied, no matter how small and how much everyone seems to think it's insignificant, It is very significant when you are that small business owner that is looking at their profit margin and meeting what their customers need and what consumers want and figuring out how to do it. Every little penny makes a difference. And this is one more of not of 1,000 cuts, but at this point, 1,000,000 cuts that is impacting small businesses. I urge a no vote. Thank you.
Any further? Representative Luck.
Thank you, Madam Chair. It is my recollection that this particular, that one of the tax credits in here, let's just get ordered for a second. That some of these tax credits are refundable. Refundable tax credits are interesting things. It means that you get an amount of dollars that you didn't actually contribute in. So let's say your tax liability is $0, but you're eligible for a refundable tax credit to the amount of $1,000. When you file that tax return, you get $1,000 back. And so I move Amendment L11 and ask for it to be displayed.
Please hold. L011 is properly displayed. Please proceed.
Thank you, Madam Chair. This just says that the tax credit that are impacted by this would not be refundable. They would be non-refundable, meaning that if you paid in $0 and there was a tax credit that otherwise would apply had you paid in enough, that you're not going to get that $1,000. If it's such that you did pay in enough, then you could see some extra dollars back. Pretty simple. Don't pay in, don't get out. Seems fair. I ask for an aye vote.
Any further discussion on L11? Seeing none, the question before us is the adoption of L11 to House Bill 1223. All in favor say aye. Aye. All opposed, no? No. The amendment fails. No has it. Backwards, whatever. It fails. The noes have it. Any further discussion on 1223? Seeing none, the question before us is the adoption of 1223 as amended. All those in favor say aye. All those opposed, no. The ayes have it. House Bill 1223 as amended is passed. You're not Mr. Shebold. Please read the title to House Bill 1221.
House Bill 26-1221 by Representatives Zokai and Sirota, also Senators Amabile and Wallace, concerning the adjustment of certain tax expenditures.
Representative Zokai.
Thank you, Madam Chair. I move House Bill 1221 and the Finance Committee report.
To the committee report.
Thank you, Madam Chair. In committee, we limited the executive compensation deduction to $250,000, up from $0. We removed the alternative minimum tax credit to address some double taxation concerns, and we changed the dates of the family affordability credit to align with the family affordability tax credit. And we needed to make some changes to that end that are technical, and so I move L9 to the Finance Committee report.
Please wait while it's displayed. L9 is properly displayed. Please proceed.
Thank you, Madam Chair. These are just some conforming technical changes caught by the drafter due to some of the changes we made in committee, and we ask for a yes vote.
Any further discussion on L9? Seeing none, the question before us is the adoption of L9 to House Bill 1221. All in favor say aye.
Aye.
All opposed, no. The ayes have it. The amendment is adopted. To the bill. To the committee report.
We ask for a yes vote on the Finance Committee report.
Any further discussion on the committee report? Seeing none, the question before us is the adoption of the Finance Committee report to House Bill 1221. All in favor say aye.
Aye.
All opposed, no. The ayes have it. The committee report is adopted.
To the bill. Representative Zokai.
Thank you, Madam Chair, and it is super cool to serve with you.
It is super cool to serve with you.
Members, in my work as a tax attorney, I know that our tax code is rigged. It is rigged to favor the ultra wealthy and giant corporations. And that is able to happen because the middle class and the working class subsidize wealthy and corporate interests. And the working class continue to pay in at a disproportionately higher rate. And now, with the passage of H.R. 1, that problem has exacerbated. H.R. 1 disproportionately benefits the wealthiest of Americans, with over $100 billion in tax cuts for the top 1%. This includes increases to allowed deductions and a reduced corporate tax rate. At that same time, federal tax policy cut billions to Medicaid and SNAP. While the private jet owners are reaping the benefits of these tax breaks and handouts, our families here in Colorado are struggling to afford basic necessities. And so what we have before you today is an opportunity to provide just a little bit of balance. The bill before you today makes changes to the executive compensation deduction and the net operating loss deduction. It caps the executive compensation deduction so that top executives can only deduct up to $250,000 of their salaries. It also caps the amount of the net operating loss deduction that is able to be carried forward and the number of years that it can be carried forward. These changes are to ensure that our tax code is consistent with our values. Do we prioritize tax breaks for millionaire CEO salaries, or do we support everyday working people who are struggling to juggle rent, groceries, and utilities? And the thing is, progressive tax policy works. We know this. The Family Affordability Tax Credit is associated with a 20% reduction in child poverty, and when coupled with the Earned Income Tax Credit, child poverty drops by nearly 40%. Due to these policies, Colorado now has the lowest rate of child poverty in the country. And that is why I am so thrilled that the tax policy changes in this bill will allow us to fund the Family Affordability Credit to ensure that those same children are not thrown back into poverty. This is a matter of priorities. Ours are clear. Children matter more than corporate profits, and I ask for your yes vote.
Representative Sirota.
Thank you, Madam Chair. So, as chair of the Joint Budget Committee, I have been front row to the impacts of federal tax changes on Colorado's families. Last year, H.R. 1, the federal tax bill, significantly reduced our state's revenue growth, which then triggered the Family Affordability Credit off after only 1 year of implementation. In that single year, Colorado achieved something remarkable. We became the state with the lowest child poverty rate in the nation. That progress is real, and it has a measurable impact on the lives of Colorado's kids. Also, today, I am here as a parent. I know that Colorado faces an affordability crisis, and this hits families with kids particularly hard. From childcare to healthcare to housing and education, every dollar counts. The Family Affordability Credit put resources directly into the hands of families who need it most. It gave them choices, stability, and opportunity, things that every parent wants for their children. That stability is now threatened because of federal changes. So this bill, House Bill 1221, does more than restore that support. It increases the fairness and integrity of our state tax system. It adjusts the executive compensation limit so that corporations can't reduce Colorado taxes through excessive executive pay, and aligns our net operating loss deduction for C Corps with national and international norms. These are responsible, targeted changes that ensure profitable businesses contribute their fair share, while families continue to benefit from the resources that they need. And by creating a permanent Family Affordability Credit, we are protecting families, strengthening our economy, and ensuring Colorado remains a national leader in child well-being. I ask for your yes vote.
Representative Johnson.
Thank you, Madam Chair. And it's been a long day talking about taxes, so I just want to make sure that dots I'm connecting in my head are connecting with you all. So we've heard about how the poor and the middle class are the ones subsidizing the rich, if I got that correct. And so I see a nodding on the side. And so in that regard, we talked about when we're updating the tax codes, we're subsidizing renewable energy. And we heard from the congressional studies on another colleague that those subsidies are going to the rich communities.
Representative Johnson, can I ask you to stick to this one particular bill, please?
Yes, Madam Chair. And so when we're looking at tax adjustments or tax expenditure adjustments, I just want to make sure we're on the same page that it seems like when we're talking all about this, that it really is because of the special interests, such as renewable, that are going to the
Representative
rich.
Johnson, excuse me, this bill has nothing to do with renewable energy. So this is particularly talking about CEO compensation.
Correct. So I just want to know, though, like when we're setting the board and talking about taxes, and who's getting the subsidies and who isn't, and how we're doing the adjustments, that we're just making sure we align the talking points on all of it, and we're not saying one thing someplace and another, connecting the dots, and I just wanted to make sure when I got the nod that I was hearing that correctly. So thank you, Madam Chair.
Thank you. Any further discussion on 12? Representative Taggart.
Thank you, Madam Chair. It's an honor to serve with you.
It is an honor to serve with you, sir.
I'm going to ask, which I ask, I think, every session. I understand the need to help families with a tax credit. What I take very personally, though, is when we as CEOs or companies that are profitable are thrown under the bus in discussion. For a person that was a CEO for a very long time, I lost a tremendous amount of time with my wife and my family. And I worked 80 to 100 hours a week for a long, long time, which I will never get back. And you have to forgive me when I'm accused of being greedy because of our deductions, or that my corporation was greedy, that we made money, and at the same time employed 1,400 people and paid them very, very well and treasured what they did for us. I understand the need for tax credits to help young families that have children. But I don't think it has to be, and I understand that some of that has to come from corporations and some with people. But we don't have to be degraded in the process. And I would just appreciate if that could be taken out of the discussion. Because I was never greedy, and I never, ever, ever, as a corporation, took away from society. In fact, we put a lot into society. And please, if we could do nothing else, stop the us against them. I take it very personally, and I apologize for that.
Representative Richardson.
Thank you, Madam Chair. This bill, like several of the others we've heard today, has a lot of concerning pieces in it, but I do think there's one truly fatal flaw, and that is assuming that we make these changes and everything else remains neutral, that we cap net operating losses, we cap the amount of time that they can be taken, we impose all sorts of other revenue restrictions on businesses, and we think they're just going to sit there and absorb them, not change how they operate, not change tax strategies, not change where they're going to locate their executives. And that's not true. Nothing is neutral. There's going to be a reaction to every action that we take. And if we think that we can just squeeze a little harder and get a little bit more, eventually you get to the point where you've just strangled it completely and we stop getting any revenue. That's really what we've been seeing over this last nearly a decade, where we continue to pass bills like this year after year that put more pressure, more stress, more strain on our businesses, and they react. They move away from that pressure. They move away from this state.
Okay.
We are killing our revenue streams, slowly and steadily, but more and more apparently. And bills like this are going to lead to the demise of anything other than panic and short-sighted decisions that we have to make just to balance a budget year after year. We've watched it. We've sat in this room and we've watched desperate attempts to balance a budget very short-sightedly, knowingly, and understanding that we're creating a bigger problem in the future we have to address. This just continues that trend in a way that will eventually catch up with us. It's caught up with us already, clearly, in many ways. But at some point, we're going to hit the spot where you just can't do any more. I'd urge a no vote on this bill.
Any further discussion? Representative DeGraff.
Hey, Chair, whenever we did, these squeezing out the last dollar, I always think, the story of the golden goose was not about farm animals. It was about human nature. The farmer had a golden goose, laid golden eggs, get a golden egg every day. Sell the golden egg, everything is good. But then wanted more golden eggs.
I'm really excited, Representative DeGraff, to see how this is related to House
Awesome.
Bill 1221.
Stay tuned. Stay tuned. So then what the farmer did was it just cut off the head of the golden goose to reach into it and get all the golden eggs out at one time, and then found nothing. And we have the golden goose in the free market. And then the do-gooders, the Karens, the endless machinators, the ones that Bastiat warned us about in 1850 with some really good contemporary political analysis. Same people, same issues, same agenda. Always trying to figure out how to eke out more for the same good intentions. And if you look at when we had things like the Taxpayer Bill of Rights, RIP, the economy was booming. I mean, the economy was booming before we needed the Taxpayer Bill of Rights. And then things like the flat tax, you can plan, you can schedule, you could come to Colorado, you could be part of that rugged individualism instead of the smothered of the nanny state. The Karens of the nanny state, I care more than you do.
To the bill.
And what did we have?
DeGraff.
We had a thriving economy. And now what do we have? We have bills like that are trying to choke out the last remaining vestiges of life of an economy because it has been destroyed by just the continual machinations, eking out a little more here, a little more there, but it's all for good intentions. It's wafer thin. Businesses are leaving. Families are not safe in this state. Education has plummeted. All by the same people, the same good intentions, driving the economy under, driving the education under, and driving the productive citizens of Colorado out. So I don't think there is no solution other than voting, and not sure. But I ask for a no vote.
Any further discussion on House Bill 1221? Seeing none, the question before us is the adoption of House Bill 1221 as amended. All those in favor say aye. All those opposed say no. The ayes have it. House Bill 1221 as amended is passed. Mr. Shebold, please read the title to House Bill 1065.
House Bill 1065 by Representatives McCluskey and Woodrow, also Senators Roberts and Exum, concerning transit and housing investment zones.
Representative Woodrow.
Thank you, Madam Chair. And I know I said it before, but I want to be clear. It is super awesome, rad, and dope to serve with you.
It is super awesome, rad, and dope, and bodacious to serve with you.
Nice use of bodacious. I move House Bill 1065, the Appropriations Committee report, and the Finance Committee report.
To the Appropriations report.
Okay, members, we had a really good conversation in appropriations from what I'm told. We appropriated some money, $190,000 for one FTE. I believe that's it. Do we have an amendment? Give us 1 second to. We have no amendments to the Appropes report. We ask for an aye vote.
Any further discussion on the Appropriations report? Seeing none, the question before us is the adoption of the Appropriations report. All in favor say aye.
Aye.
All opposed, no. The ayes have it. The Appropriations report is adopted. To the Finance report.
All right, thank you. Members, we had an amazing conversation in the Finance Committee. We actually had about a dozen amendments that we ran. Going over them briefly, just for the sake of posterity and putting it in the record, we extended the boundary from 1.5 to 2 miles around a transportation facility. We tried to increase the amount in our initial pilot round to 6 zones. We amended the ledge deck to explain the accounting and treatment of sales tax in transit investment areas that are not made in person. We reformatted some definitions. We did that through several amendments. We asked for an aye vote.
Any further discussion on the Finance report? Seeing none, the question before us is the adoption of the Finance report to House Bill 1065. All in favor say aye.
Aye.
All opposed, no. The Finance report is adopted. To the bill. Speaker McCluskey.
Thank you, Madam Chair. It is an honor to serve with you.
It is an honor to serve with you.
Thank you. Members, I am very excited to stand here with Representative Woodrow today to bring forward House Bill 1065, which is a novel approach, a financing tool that will help us better support our local governments in improving investments around transit-oriented communities, and also a way to help us continue to foster affordable housing through tax credits, also designed for these development areas. You know, we have invested dollars these past, 8 years in trying to strengthen our community partnerships, local control, working to help really incentivize more affordable housing. One of the most notable bills we passed several years ago that Representative Woodrow led was House Bill 1313, which ensured that we would be incentivizing transit-oriented development to be sure that we were maximizing our affordable housing dollars, also improving climate action around this state. And as we have been listening to our partners out across the state, we've recognized that there is a serious need for more financing tools to help them support these developments. House Bill 1065 will help us do just that. It is going to help us use state sales tax only as part of a financing tool for a limited number of projects, but projects that could come to us from any part of the state, from rural communities, urban communities, and everywhere in between. I will allow my co-prime to take a few moments and speak to the content of the bill as well, but I urge your support of an effort that has received overwhelming support from both Democratic and Republican-led counties and communities, because everyone sees the value in this type of financing tool, especially when we're talking about
these specific development areas.
Representative Woodrow.
Thank you, Madam Chair. Thank you, colleagues. Before I begin, I would like to thank my esteemed co-prime, Madam Speaker. It has truly been an honor to serve with you these last 7 years and to finally run a bill together. And thank you for coming into my wheelhouse. Colleagues, for the past several sessions, my work has largely focused on the intersection of intersections. Housing and transit are truly linked at the hip when it comes to solving our state's climate issues, our transportation and traffic issues, our affordability crisis. We need to build more housing, and we need to do so in a smart, strategic way by transit. With a new financing tool using state resources, 1065 gives us an opportunity to make convenient, reliable, multimodal transit options the norm rather than the exception in Colorado. This bill makes it easier for local and regional partners to provide needed infrastructure for transit stations and mobility hubs that supports new housing and ridership without overburdening local budgets. Does this in two ways. It creates transit investment areas using TIF financing. Zones will be up to 2 miles around current and future mobility hubs, transfer stations, park and rides, transit stations and rail stations across the state. Local governments can partner with a transit agency in their zone to submit applications to create these transit investment areas to fund transit-related infrastructure like first and last mile connections, safety improvements, wayfinding, and placemaking amenities. The TIF will use only the 2.9% state sales tax within the designated transit investment area for a period of no more than 30 years. It also provides for a new state income tax credit, the Transit and Housing Investment Zone Tax Credit, with awards beginning in 2027, administered by CHAFA for entities who develop housing with within certain affordability ranges in a transit and housing investment zone. These credits are modeled after the state affordable housing tax credit, which is Colorado's version of the federal low-income housing tax credit, also known as LIHTC. However, affordability requirements can be more flexible than LIHTC since housing around transit station tends to be more expensive. Before we turn things over, I do believe that we have 2 amendments which my co-prime will move and explain.
All right, Speaker McCluskey.
Thank you, Madam Chair. I move L17 to House Bill 1065.
Give us a moment.
And ask that it be properly displayed.
All right, Speaker, tell us about the amendment.
Thank you, Madam Chair. L17 will remove continuous spending authority from House Bill 1065 and instead replace it with an annual appropriation. We have done this at the after having a conversation in Joint Budget Committee with our Joint Budget Committee members in Appropriations Committee this morning. I ask for an aye vote.
Any further discussion on the amendment? All right, seeing none, the question before us is passage of L017 to House Bill 1065. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. L017 passes to the bill. Speaker McCluskey.
Thank you, Madam Chair. I move L018 to House Bill 1065 and ask that it be properly displayed.
Okay, give us a sec. All right, to the amendment, Speaker.
Thank you, Madam Chair. This amendment ensures that projects approved by this bill that have received Build Authority bonds, B-U-I-L-D authority bonds, would be required to meet Build Authority criteria to ensure contractors hire and train apprentices for careers in the construction industry from bona fide registered apprenticeship programs. Again, I ask for an aye vote.
Is there any further discussion on the amendment? All right, seeing none, the question before us is passage of L018 to House Bill 1065. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. L018 passes to the bill. Representative Woodrow.
Thank you. Colleagues, I would just add to the conversation that the state demographer still says we're about to add 1.7 million more folks to Colorado by 2050. The question is, where are they going to live? Are we going to keep building in a sprawled out way drive till you qualify, adding to vehicle miles traveled, or are we going to do it in a smart, strategic way that encourages density, that brings people together, that cuts down on vehicle emissions? The number one thing we can do to bolster Colorado's economy is to make housing more affordable throughout the state. When you ask businesses why they're not relocating to Colorado, for the few that have chosen not to join our beautiful state, they will often tell you that they cannot have a workforce here because housing is too expensive. They cannot afford to pay folks the amount of money required to cover housing costs. By lowering the cost of housing, we actually incentivize businesses to come to Colorado. We make life cheaper for everyone, more affordable, and I know that's everyone's main goal, to make the lighten the pocketbooks of Coloradans as much as we can, to lighten that burden. When folks are sitting around the table trying to make ends meet, this is the number one driver of that conversation. We ask for an aye vote.
All right, any further discussion on the bill? All right, seeing none, the question before us is the passage of, where am I in my notes? House Bill 1061, 5. House Bill 1065. All those in favor say aye. All those opposed, no. All right, the ayes have it. House Bill 1065 as amended passes. Mr. Shebo, please read the title of the next bill.
House Bill 1004 by
10,
Representatives McCluskey and Caldwell. Also, Senators Coleman and Simpson, concerning a continuation of the income tax credit for a qualifying contribution to promote child care in the state.
To the bill.
Thank you.
Who's gonna move it?
I move House Bill 1004.
All right, Minority Leader Caldwell.
Okay.
Continue.
Thank you, ma'am. Members, what we're bringing here is the child care tax credit, child care contribution tax credit. If you've been here for more than a couple of days, you probably know that this has been a very popular program that's been around since 1998. And the important thing is what it has accomplished. As recently as the 2023 tax year report, is that it's incentivized $66 million a year in private philanthropic support, with only a $33 million impact to the state budget. It's been a wildly popular program. Now, I know there's a lot of conversations and debates in this chamber about different tax credit programs that we have. However, this is one that has been extremely popular in Colorado. I'm sorry, kind of lost my train of thought there. It's been important to providing families with the child care needs. We all know that child care is extremely expensive here in Colorado, and this has helped to improve quality and increase wages for our child care workers. It's increased the access to care, affordability of care, and it also promotes the workforce. We have families who have both parents who are working in a household, and one of the big issues that has held them up from being able to find employment is the cost of child care. And so, happy to bring this along, and certainly ask for your support on it.
Madam Speaker.
Thank you, Madam Chair. It is an honor to serve with you.
Ditto.
Thank you. I am very pleased to stand here alongside Minority Leader Caldwell and present to you House Bill 1004. There is a desperate need for more support in early childhood care and education. The CCTC, the Child Care Contribution Tax Credit, helps providers raise critical funds, whether that's to open new centers or expand their current center. It recruits and helps recruit and retain high-quality teachers and staff. It improves the quality of programs by being able to fund additional needs within a center or a learning facility. And it helps our hard-working families by ensuring that we are doing everything we can to help keep childcare affordable and accessible. This child care tax credit provides a 50% tax credit when a cash donation is made up to $100,000 for child care programs and after-school providers. The eligible recipients include licensed child care centers and home-based programs, foster care homes, residential child care facilities, and homeless youth shelters. I am so delighted to bring this the continuation of this child care contribution tax credit, a lot of C's in all of that, because it matters to all of us, Republican and Democrats alike, rural and urban, suburban. We all need to do what we can to invest in our child care centers. I urge an aye vote.
Is there any further discussion on the bill? Seeing none, the question before us is adoption of House Bill 1004. All those in favor say aye. All those opposed, no. The ayes have it. House Bill 1004 passes. Mr. Shebo, please read the title of Senate Bill 141.
Senate Bill 141 by Senators Robertson, Simpson, also Representatives McCluskey and Taggart, concerning optional fees during motor vehicle registration that primarily support wildlife projects and in connection therewith, using the proceeds of a newly created optional fee to construct wildlife crossings and other transportation improvements and making an appropriation.
All right, Speaker McCluskey.
Thank you, Madam Chair. I move Senate Bill 141.
All right, moved. Continue.
Thank you. Members, I am delighted, I am privileged to stand here with my co-prime Representative Taggart to bring forward a bill that is very real and relevant for our communities on the Western Slope and truly for anyone living in Colorado. You know the hazards of what we see on our state and local highways, our local roads, because we are the West. We are a state where we have a diversity of wildlife, often crossing our highways, our roadways, as they are migrating or simply trying to access water or food. What we have seen over the years is a tremendous increase in the number of vehicle and wildlife crashes, accidents. In 2024 alone, there were 7,500 crashes involving animals, and from 2010 to 2025, these tragic accidents resulted in 52 motorist fatalities and over 5,500 injuries to drivers and passengers. This particular bill brings forward a financing tool for us to begin ongoing year-over-year work in critical infrastructure, creating wildlife passageways and corridors, improving wildlife fencing. We are hopeful that with your approval today, we'll see the launch of some very much-needed projects that the Colorado Department of Transportation has identified. They have been counting on us to be able to bring a funding source forward, and I am delighted to share my enthusiastic support of Senate Bill 141 with all of you and invite you to say yay.
All right, further discussion on the bill. Representative Taggart.
Thank you, Madam Chair. I think it's important to understand that this fee that we can pay for when we register our car each year is totally voluntary. It's $5. It's totally voluntary for structures, infrastructure along our highways that today, with data indicates it reduces these interactions between automobiles and commercial vehicles 92%. There are not many things that can reduce that kind of impact and save lives, save the life of the animal, help our hunting industry. And I happen to be one of those West Slope individuals that travels through these migration patterns every time I come back to the Capitol. And I can tell you, I always want to avoid dusk or dawn, because that's when this migration pattern is at its most significant. So just keep in mind, this is totally voluntary for registrations, and I would ask for your yes vote.
Representative Brooks.
Chair, thank you. I understand that this is a volunteer, that it's an opt-in. I did hear this in committee. And my angle on this might surprise some folks. It might surprise some folks because I have a personal connection to a story that, a sad story, about Victor Rodriguez. So my son, growing up, my oldest kid, his baseball coach, buddy of mine, I worked with in radio for 20 years, and then very coincidentally kind of reconnected, and he was the baseball coach. His father, Victor, Cuban immigrant, was driving down Santa Fe when a truck coming the opposite direction hit an elk, threw the elk into the vehicle, through the windshield, and instantly killed Victor Rodriguez. His daughter was one of those that testified during committee hearing. His daughter has been working tirelessly since that accident roughly 18 months ago to try to ensure that there is wildlife fencing along Highway 85 in Douglas County. Turns out the bill sponsors were kind enough to draw a direct correlation between the animal strikes in my county, that it is the second highest. Douglas County is the second highest for animal strikes. An opt-in, kind of like the Keep Colorado Wild, strictly opt-in, is a way of being able to raise some funds to provide some options. Wildlife overpasses, like the one that was just built in Greenland, just south of me near Larkspur. I believe that this is something, and I know it's not just Douglas County. I said that we're the second highest. There's a county that's the first highest, right? There's a county that leads, and there are plenty of counties right behind it. It's not just that it's about the animal deaths. It's about the deaths that result to motorists as a result of this as well, which, if I remember from committee, was somewhere around 36 or so over the past handful of years. One, Victor Rodriguez was enough for me, and I do very deeply appreciate the efforts of his daughter that continue to this day to try to find ways to ensure that we have wildlife fencing or that we have wildlife overpasses, that we have ways for wildlife to be able to traverse a highway and diminish greatly, which statistics have proven that this does, the risks to motorists. So I am in favor of this, and I would certainly appreciate support also from my Douglas County peeps as well, given our difficulty with this in our area. Thank you.
Any further discussion on the bill? All right, seeing none, the question before us is passage of Senate Bill 141. All those in favor say aye. Aye. All those opposed, no. The ayes have it. Senate Bill 141 passes. Madam Majority Leader.
Thank you, Madam Chair. I would like to move House Bill 1328 before House Bill 1111.
All right. Are there any objections? Seeing none, the committee will proceed out of order for consideration of House Bill 1328. Mr. Schiebel, could you read the title of that?
House Bill 1328 by Representatives Stewart Kaye and Winter, also Senators Mullica and Kirkmeyer, concerning non-emergency medical transportation for Medicaid members.
All right, Kaye Stewart.
Thank you, Madam Chair. I move House Bill 1328 and the HHS and Appropriations Report.
Wonderful. All right, Representative Stewart, continue about the Appropriations Report.
Do we have one? Okay, approps first. Yes. Yep. So in appropriations, we added a word and we brought that fiscal note down. Yay us.
Is there any further discussion on the Appropriations Report? All right, seeing none, the question before us is adoption of the Appropriations Report. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. The Appropriations Report is adopted. To the Health and Human Services Committee report. Representative Kaye Stewart.
Thank you, Madam Chair. In HHS, we ran a number of amendments after a lot of stakeholder work and conversations with HCPF to get us to a much better place. And I'll go into depth, as will my co-prime, when we get to the bill.
Any further discussion on the committee report? Seeing none, the question.
Wait. Wait. Is that to the? Yeah. I need to move an amendment here. Thank you. All right, whew. That was close.
All right, Representative Kaye Stewart.
Okay.
Go for it.
Thank you, Madam Chair. I'd like to move, I will move, L7 to 1328 and ask that it be properly displayed.
To the committee report?
To the committee report,
Okay.
sorry.
Can you restate that motion real quick?
I'm out of practice. I move L7 to the committee report.
Excellent. All right, give us a moment. All right, L007 will be up on shortly. And folks, this was distributed on your desks at 12:56 p.m. Assistant Minority Leader Winter.
Thank you, Madam Chair. L007 addresses a handful of changes, and we felt it best to bring as one large amendment and walk through it rather than bring numerous. Overall cleanup, it changes State Department to Transportation Broker to in Section 2 of the bill, which places the advisory board under the purview of the broker rather than HCPF. Very small language tweak around the ambulance providers and a very small language tweak around the reclassification language. It changes the definition of transportation provider. We wanted to ensure we encompass all forms of NEMT providers, including nonprofit entities. It adjusts the makeup of the advisory board. It's always been our goal to ensure that the advisory board is made up of a diverse group of folks in the NEMT space. And so through stakeholder engagement, we are adding a seat to be filled by a nonprofit or public transportation provider that services both rural and urban areas. It requires that when appointing the members of the board, there's equitable representation of nonprofit, for-profit, and public transportation providers, including local gov or public transit agencies. It touches on record keeping. It cleans up language around policies for utilizing a dispatch system for recording important metrics such as pickup and drop-off locations, miles driven, driver and vehicle details, and other things. Stakeholder feedback from other providers. This is an additional parameters to mitigate fraud, waste, and abuse and ensure that providers are kept to transparent standards. In Section 2 of the bill, we are adding in an additional language around credentialing and reimbursement. Clarifies that HCPF is responsible for determining if providers, drivers, and vehicles are credentialed and that they address member safety and privacy. HCPF is responsible for determining credentialing requirements and the manner in which the broker is responsible for verifying. We also add clarifying language that vehicle drivers that are determined to be non-credentialed are not eligible for reimbursement. Video recording systems. We are adding the requirement for video recording systems, specifically two-way video dash camera systems in provider vehicles for verification and safety, stakeholder feedback from other providers. This is an additional parameters to mitigate fraud, waste, and abuse and ensure that providers are kept to transparent standards. We also include language that ensures member privacy remains a top priority when equipping and utilizing these camera systems. Additionally, these systems must not be required for billing purposes, however, can be required to provide should a provider be audited. This requirement does not apply to small providers operating 5 or fewer vehicles. And finally, in Section 3 of the bill, we are clarifying language around the transportation broker, including specifying that transportation broker may not also operate an NEMT transportation provider. We are clarifying NEMT. We do not want to inhibit any current partnership between the broker and RTD, and therefore we are specifying NEMT. We also clarify that prohibiting a broker from operator owning an NEMT provider is contingent on the broker signing a contract with the state after January 1, 26. This is again to not inhibit any functions of the current broker while transitioning to the new broker. We clarify that broker may only direct a member away from a preferred provider if that provider is subject to certain restrictions due to a corrective action plan outlined within the bill. We added language that makes it clear that the broker is responsible to determining Medicaid eligibility of patients, not the transportation provider. And finally, we clarify that when or if a TNC enters the provider market, they must meet all credentialing requirements established by HCPF. And with that, I urge an aye vote.
Any further discussion on the amendment? Seeing none, the question before us is adoption of L007 to the Health and Human Services Committee report. All those in favor say aye. Aye. All those opposed, no. The ayes have it. L007 is adopted. Back to the Health and Human Services Committee report. All right, Kay Stewart, Representative Stewart.
We ask for an aye vote.
All right, any further discussion on the committee report? Seeing none, the question before us is adoption of the Health and Human Services Committee report to House Bill 1328. All those in favor say aye. Aye. All those opposed, no. The ayes have it. The committee report is adopted. To the bill, Representative Kay Stewart.
Thank you, Madam Chair. So why this bill? Non-emergency medical transportation is a Medicaid-covered benefit that provides transportation to medically necessary appointments. It's essential for ensuring access to care, particularly for seniors, individuals with disabilities, and rural populations without reliable transportation. Effective NEMT services help reduce missed appointments, prevent avoidable emergency room visits, and improve overall health outcomes while helping to control long-term health care costs. At a high level, we're working to lay down framework for implementing a statewide broker, ensuring that provider groups across our state receive equitable support from the broker, hold providers accountable, and allow ethical businesses in this space an opportunity to grow while rooting out providers engaging inappropriately. What we're trying to accomplish is mitigate access to care challenges in rural Colorado where distances are longer, provider networks are more limited, and transportation reliability is critical to maintaining care continuity. To support a phased-in broker implementation to ensure stability in all regions as this transition takes place, including in rural areas, ensure network adequacy so rural members are not underserved or left without options, promote flexible scheduling policies that accommodate both routine and time-sensitive care needs, highlight the importance of maintaining continuity of care during transitions in program structure, and maintain patient choice in the new statewide broker model by maximizing patient preference whenever possible. So we ask for your aye vote.
Right. Assistant Minority Leader Winter.
Thank you. With the explanation of the amendments and what my colleague have to say, I do want to say that, you know, not many times we get to come down here in the well and talk about, but we're going to be able to draw down some funds for this. We figured around, what, $40 million?
Yeah.
I mean, with the reclassification of the NEMT, we're going to be able to draw down about $40 million in federal funds to help with this program. I think in the fiscal crisis that we're in right now.
You should say it again.
$40 million. One more time for those of you who aren't listening, $40 million. And we're going to be able to draw those down to help with the program. There's not many times, especially nowadays, that we can get up and talk about money that we're going to draw down. We've been working on this bill for quite some time. We've talked to many providers, and we know that there's still a lot of work done to be done in this space. But with all the fraud that we saw and all the abuse that we saw, this gives us a really good opportunity to hammer down on that, bring some federal funds in, and make sure that not just people in rural Colorado, that all people are able to get to their important appointments, but most of all for two rural legislators, this is ultra important because you see these vehicles on the road all the time trying to get clients that are trying to get to specialists that are in more centralized or metro areas, and this is a real help for those people, so we urge an aye vote.
Representative Johnson.
Thank you, Madam Chair, and thank you, sponsors, so much. I know this has been a hot topic for years. I know I was highly engaged with it, understanding that at one point the conversation was one size fits all from the department. We know rural does not work the same as urban, and urban doesn't work the same as rural, and we need NEMTs. They are not Ubers, they are not Lyfts, they are not those groups. They are specialized transportation models that help get the patient not just from the vehicle to the location, but sometimes into the clinic and helps them when they have accessibility issues. This is also has cost savings. It's fiscally smart. The number I think again was 40 million. For those not listening, 40 million. This is fiscally responsible. Let's do this for the patients. This fits for all the communities. Thank you so much for taking this burden on. This has been a headache. This is a brilliant fix, and I'd urge a yes vote.
Any further discussion on the bill? All right, seeing none, the question before us is adoption of House Bill 1328 as amended. All those in favor say aye. Aye. All those opposed, no. The ayes have it. House Bill 1328 as amended is passed. Mr. Schiebel, please read the title of House Bill 1111.
House Bill 1111 by Representatives Marum McCormick, also Senators Kippen Roberts, concerning the creation of a program for the end-of-life management of pesticide products and in connection therewith creating the pesticide product disposal and container recycling enterprise to develop and administer the program.
Representative Morrow.
Thank you, Madam Chair. I move House Bill 1111 and the committee reports.
All three of them. Okay. All right. We'll start with the appropriations report. Representative McCormick.
Thank you, Madam Chair. In appropriations, they were kind enough to move the bill along and pass the appropriate appropriation. We ask for an aye vote.
All right. Any further discussion on the appropriations report? Seeing none, the question before us is adoption of the appropriations report. All those in favor say aye.
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 All those opposed, no. The ayes have it. The appropriations report is adopted. To the finance report, Representative McCormick.
Thank you, Madam Chair. In the Finance Committee, we adopted an amendment to cap the annual product registration fee and to make sure that we align the dates appropriately so that we could start collecting the fees before the program is initiated. And we ask for an aye vote on the Finance Committee report.
All right, further discussion on the finance report. Seeing none, the question before us is adoption of the finance report. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. The finance report is adopted. To the Agriculture, Water, and Natural Resources report, Representative McCormick.
Thank you, Madam Chair. In Agriculture, Water, and Natural Resources Committee, we passed a couple of amendments that clarified the role of the enterprise that we are setting up and also ensure that the fee is paid by eligible products and also set an upper payment fee for those products. And we ask for an aye vote on the Agriculture, Water, Natural Resources Committee report.
All right, is there any further discussion on that committee report? Seeing none, the question before us is adoption of the Agriculture, Water, and Natural Resources report. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. The committee report is adopted. To the bill, Representative Morrow.
Thank you, Madam Chair. I am very excited to tell you all about a new Colorado pesticide disposal program to provide a solution for commercial pesticide applicators and private farmers and ranchers that have not had an economical means to dispose of bulk or restricted use pesticides. And I'd like to thank my co-prime, and I ask for your aye vote. Do you want to say that?
Representative McCormick.
Thank you, Madam Chair. Yes, this is a new program that's been probably waited on for decades. There are folks that have unused old containers of pesticides in their garages and sheds that are of danger to our soil and water, and this provides a very economical way for those products to be disposed of as a hazardous waste in our state. And it'll be very accessible to our farmers and ranchers because they will set up events that will move across the state. And these events will be advertised, and we really hope that it'll help get these products recycled in a way that they should be. We ask for an aye vote.
Any further discussion on the bill? All right, seeing none, the question before us is adoption of House Bill 1111. All those, as amended, all those in favor say aye. That was weak. All those opposed, no. The ayes, I guess, have it. House Bill 1111 as amended is passed. Mr. Shebel, please read the title of House Bill 1117.
House Bill 1117 by Representatives Ricks and Gonzalez, also Senator Lindstedt, concerning temporary hospitality event permits that authorize the consumption of marijuana.
Representative Ricks.
Thank you, thank you, Chair. Anyways, I move House Bill 261117 and the committee reports of appropriation and finance.
All right, to the...
And the business report as well.
All right, you've moved all three reports to the appropriations report first. Representative Ricks.
Yes, in appropriations this morning, we were able to move L8 or L9, which brought the fiscal note to zero. What that amendment did was to remove the enforcement requirements for tobacco and for alcohol. And so because they don't have to do that anymore, Denver will be able to do part of the enforcement, and that helped to bring the fiscal note down to zero. We ask for a yes vote on the committee report.
Any further discussion on the appropriations report? Seeing none, the question before us is adoption of the appropriations report. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. The appropriations report is adopted. To the finance report.
We do have an amendment for that finance report. I move the finance report, and I also have an amendment that we need to display.
All right, can you move your amendments?
I move L10 to the Finance Committee report of HB 1117.
All right, give us just a moment. All right. Representative Gonzalez,
Thank you. So
tell
all
us
we're
about the
doing-
amendment.
So all this amendment does is on line 42, we're going to strike or and substitute and.
All right, is there further discussion on the amendment? Representative Ricks.
And what that does is it's going to say that we are going to do security and ID checks at each event. So it's not either or, it's and. We'll be doing both as a precaution to keep people who are under age 21 out of these events. We ask for your yes vote.
All right, is there further discussion on the amendment? All right, seeing none, the question before us is adoption of L010 to the Finance Committee report. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. L010 is adopted. Back to the Finance Committee report. Representative Ricks.
In finance, we did a lot of work talking with the city and county of Denver. Right now, Denver is the only municipality that really allows for these types of events. And they want to play a stronger role in the enforcement within their jurisdiction. So this amendment allows for Denver to come in. We also made some other adjustments there just to ensure that, take some of the suggestions from some of our stakeholders like Blue Rising and others. And that was what was done in the Finance Committee.
All right, further discussion on the finance report. Representative Johnson.
Thank you, Madam Chair. To the Finance Committee report, I move L013 on House Bill 1117 and ask that it be properly displayed.
All right, give us just a moment while we display that. All right, Representative Johnson to the amendment.
Thank you, Madam Chair. So through talking, and stakeholding with the public safety communities, such as law enforcement, what this amendment does is says that during these events, you cannot sell marijuana between the times of 12, so midnight to 5 a.m. There is the safety concern that if it's still selling between midnight and 5, when folks go home, we're adding more liabilities on the road. When looking in statute, understanding that in 2019 there was a bill, this dealt with the hospitality portion of marijuana. What this is dealing with is the licensure of when these events can or cannot allow for the selling and purchase of marijuana. So would ask for a yes vote to ensure safety in our communities per the law enforcement stakeholding.
Representative Ricks.
Thank you, Rep. Johnson, for this amendment. But I just want to remind you that these events, there's no sale of marijuana. People bring their own marijuana to these parties, and current law states that these events can be held until 2 a.m. And again, with the events planning, people bring their own cannabis. So there's no sale and there's no purchase during those hours, okay?
Representative Johnson.
Correct, and I did misspeak. It's been a long day. So in the 2019 bill that came about, it deals with the hospitality aspect. This bill, this section would be dealing with the licensing aspect when you're licensing for events to take place, saying that at these events, then the consumption cannot happen between midnight and 5 a.m. I misworded, but it still fits in that this is the licensing on the permitting side, while the 2019 dealt with the hospitality side. For the consumption, there's a lot of statutes going in my head right now. It's been a long day, so thank you for the clarification, but did check and looked at the CRS book to make sure that they were not crosshairs.
Representative Ricks.
So in order to do these events, you have to have a hospitality license, right? So if you don't have a hospitality license, you cannot show up to Denver and say, hey, I want to do this event. So that's the first step through MED, which is the Marijuana Enforcement Division. Secondly, in order to host an event, you now have to request a permit from the municipality to do this. Every event has to comply with current laws related to cannabis and related to the hospitality license. So 2 a.m. will be the cutoff for any event, and you will not be able to purchase or sell because these events is not held by a dispensary. It's just by an events planner for this particular purpose of just consuming cannabis. So that's what you need.
Representative Johnson.
Thank you, Madam Chair, and thank you for that. There are still two different matters. One is not affecting those who have a set-up location of sales. They can still do the hospitality aspect until 2 a.m. and cannot start again until 7 a.m. What this would do is saying for those events, which are temporary, in that community space that it's happening or that private sector space that it's happening because it's not a set-up section, that we are not going to allow for it in these areas because it's not as well established. This has again been asked by public safety stakeholding, and we're just asking because these are different events happening. We don't want them on our public roads. We don't want them driving if they've had that consumption. We're just looking for that public safety aspect. For those who have that permit that's set up permanently in the buildings, if you go to a dispensary or such, still allowed. This doesn't cross that. This is just affecting the event space that happens for purpose of days.
Representative Ricks.
This is not something we would accept. All of the events will comply with current state laws, which allows these events to go till 2 a.m. in the morning.
Any further, Representative Johnson?
Thank you. And colleagues, I would just like you to consider that when we are looking at that 2 a.m. to 7 a.m., that is set in place, that they already have those routines for law enforcement when they're traveling around, when they're trying to sell. What this is doing is when you have pop-up events happening that are not set in set statute for rotations, for the public safety, that aren't used to these sections, and these are temporary things that we do different things on that. And understanding that this doesn't take away for those who are permanently set up. This is just asking for a public safety piece for these events that are temporarily happening and aren't set in a brick and mortar section permanently year-round.
Seeing no further discussion, the question before us is the passage of Amendment L13. All those in favor, please say aye. Aye. All those opposed, please say no. No. L13 is lost. To the committee report. Is there any further discussion? Seeing none, the question before us is the passage of the Finance Committee report. All those in favor, please say aye. All those in favor, please say aye. Aye. All those opposed, please say no. The Finance Committee report is passed. To the Business Affairs Committee report, Representative Ricks.
Thank you, Madam Chair. We passed the bill out of committee. There was a lot of testimony, and we, were able to get it out on a party line vote. Basically, we asked for your yes vote on the committee report.
Is there any further discussion on the Business Committee report? Seeing none, the question before us is its passage. All those in favor, please say aye. Aye. All those opposed, please say no. The committee report is passed. To the bill, Representative Ricks.
We do have an amendment on the bill. This is a technical amendment that's basically going to say that it's going to name what the marijuana license type is a marijuana hospitality license, and we ask that it be displayed.
Can you move the bill with bill number?
Yes, I move L16 to the bill, HB 1117.
Thank you. Okay, it is displayed. Representative Ricks.
And basically what we're doing is inserting anywhere the word marijuana is, talking about the license, we're inserting hospitality, because this is a marijuana hospitality license. And we ask for your yes vote.
Is there any further discussion on L16? Seeing none, the question before us is its passage. All those in favor, please say aye.
Aye.
All those opposed, please say no. L16 is passed. Back to the bill. Representative Ricks.
Thank you. Members, this bill is basically about modernizing support for Colorado's small businesses when it comes to marijuana. The bill aims to strengthen the support for the hospitality and cannabis industries by creating new opportunities for collaboration. HB 261117 authorizes licensed marijuana hospitality businesses to host safe, regulated events for adults 21 and older on a temporary basis. This bill advances the industry's responsibility by maintaining strict guardrails, preserving local control, and supporting small businesses. 1117 creates a temporary event-based hospitality permit for already licensed marijuana hospitality businesses, allowing adults 21 years old and older to consume marijuana at a time limited, locally approved, and permitted event. The bill emphasizes local authority and maintains state regulatory power while requiring a clearly defined regulator-approved event footprint to be produced, ensuring public health and safety guardrails remain intact. The event must occur within a clearly defined approved event premise, and the footprint of the event must be reviewed and approved by regulators. Putting power in the hands of local government is an important part of this bill, and local jurisdictions must adopt a resolution or ordinance authorizing the events before any event can take place within that jurisdiction. Local government also retains full authority to approve or deny locations, determine the appropriate zoning, ensure compliance with clean air or building requirements. Local governments may impose reasonable conditions relating to safety, traffic, and neighborhood impacts as they see fit. Local governments may not, however, issue or deny an event permit solely based on advertising content of participating licenses. The bill is going to prioritize local consumption over unregulated use of marijuana and is limited to adults who are 21 years old and older. And the sale, transfer, or distribution of alcohol or marijuana is prohibited at these events. Attendees may only possess marijuana legally obtained in accordance with existing Colorado law. To avoid classification as open and public consumption, events must be obscured from the public view, and access must be controlled through security personnel and credentialed entry. Events must also comply with applicable noise, odor, and air quality laws, and the Colorado Clean Indoor Air Act, and applicable ventilation and open air rules, ensuring responsible adult usage in a confined, regulated setting.
Representative Gonzalez.
Thank you, Madam Chair. The bill uses a temporary permit model because it is a common model in Colorado for other regulated industries. This does not create a new marijuana license type or an expansion of marijuana sales, nor does it override local governments or benefit any one operator. It provides a structured, enforceable, locally controlled pathway for temporary consumption events. It is not intended to be a deregulation measure or a sales bill. Participating licensees, including retail marijuana stores, medical marijuana stores, cultivation facilities, and the products manufacturers, may collaborate with the event permit holder for educational displays, promotions, community or cultural programming related to cannabis awareness and safety, or retail transactions that are not marijuana sales. However, deceptive, false, or misleading health or physical benefit claims may be in any educational or promotional materials. Applications for a temporary hospitality event permit must be filed with the state licensing authority annually and at least 60 days before the first proposed event. Applications for an event permit must be submitted to the local licensing authority at least 45 days before the event and must include a site plan as well as security, odor, and waste management plans. State and local licensing authorities retain inspection authority separately or jointly and may take disciplinary action for violations. Fees collected from permits help offset administrative costs. The state licensing authority sets application and insurance fees to cover direct and indirect costs, while the event permit fee is set at $25 per event. The bill takes effect January 4th, 2027, with the state licensing authority accepting applications for temporary hospitality event permits on or after that date. And we ask for an aye vote.
Representative Brooks.
I'll talk from this side. Chair, thank you. I'm still, before you think I've gone insane in the membrane, I'm still a no on this vote on this bill. But I do want to recognize something that during the process, I was having an opportunity to speak with the bill sponsor, one of the bill sponsors, about some amendments that I was considering, and I very much appreciate the process of consideration, to look at them and to want to understand them, to see if it was something that could be accepted. One of them we ended up not bringing, and the other one I understand why it was not accepted, but I just want to say thank you for the process of consideration. I thought that was it was very kind and felt that it needed to be recognized. So I won't go that far.
Representative Brooks.
Okay. We asked for your yes vote, Rep. Brooks. Thank you so much for the compliments.
Representative Gonzalez.
So in closing, I will just say, without a lawful pathway, marijuana consumption shifts to unlicensed pop-up events, sites face enforcement challenges, and licensed operators lose economic viability. Hospitality has historically been one of the low-cost entry points into the cannabis industry and a space designated to support smaller operators over large, vertically integrated companies, offering meaningful opportunities for social equity participation. This bill preserves those access points for small businesses while stabilizing struggling hospitality operators by providing a lawful alternative to unregulated consumption events, and we respectfully ask for your yes vote.
Seeing no further discussion, the question before us is the passage of House Bill 1117. All those in favor, please say aye. All those opposed, please say nah. 1117 passes. Mr. Shebel, please read the title. Wait. Madam Majority Leader.
Thank you, Madam Chair. I'd like to lay over House Bill 1230 until Monday.
House Bill 1230 will be laid over until Monday. Mr. Shebel, please read the title to Senate Bill 150.
Senate Bill 150 by Senators Ball and Judah, also Representatives Froelich and Jackson, concerning reforms to the Regional Transportation District to increase accountability.
Representative Jackson.
Thank you, Mr. Chair. I move Senate Bill 150 and the THLG report.
To the committee report. Rep. Froelich.
Thank you, Mr. Chair. We had a lively discussion in Transportation and Local Government Committee, and I need to move a technical amendment, so I move L39 and ask that it be properly displayed.
Yeah, so it's not
Thank you.
That is properly displayed. To the amendment.
Thank you, Mr. Chair. This just makes sure that there's alignment. As mentioned, it's a technical amendment. We ask for a yes vote.
Seeing no further discussion, the motion before us is the adoption of L39. All those in favor say aye.
Aye.
All those opposed say no. The amendment is adopted. To the committee report.
Thank you, Mr. Chair. Oh, sorry.
Rep. Froelich.
Thank you, Mr. Chair. We moved 2 amendments in committee on local government cooperation and on the reporting structure back to the legislature, and we asked for an aye vote on the committee report.
AML winner.
Oh, it's not to the bill. It's on the
Thank you, Mr. Chair. I would like to move L038 to the committee report and ask that it be properly displayed.
That is properly displayed. To the amendment. Rep. Winner.
Thank you, Mr. Chair. In this amendment, we just don't want the governor to be able to appoint these people. We think that it should be a vote at large by the people. They should be able to choose the people that sit on this. And I think, giving the governor all the power to choose who sits on this is not the will of the people, and I urge an aye vote.
Rep. Richardson.
Thank you, Mr. Chair. I know there was a similar amendment that was brought forward in committee that was not accepted there, but this further refines the fact that the 4 seats that would have been appointed by the governor are actually going to be voted for at large. One of the things that was identified as a weakness on the board is it's kind of fragmented right now. 15 district elected directors. There's nobody that's really elected that has responsibility to folks across the entire district. So this corrected both that and having a governor who probably would never take mass transit from appointing folks to direct it.
Rep. Johnson.
Thank you, Mr. Chair. I also rise in support. The district for Northeast Colorado has seen something where we had an amazing director appointed by the governor, ended up speaking up for rural Colorado, and then ended up getting relieved of his position. We got someone else who has not been active in the district or visited anywhere. So by having it elected by the people, we actually have people who are dedicated to the community, not to a certain branch's directives. And this would allow for them to actually get out with the community, see what we have, and give them that ability to actually voice what we're asking them to voice without worrying that they're going to get dismissed. So I urge a yes vote for the people, especially for rural areas where our roads are crumbling and it's becoming a huge disaster, and we need them to be able to not be worried about their seat, but instead be able to say the truth of just how many crashes, potholes, and unfortunately deaths we're having because of the low maintenance we're getting. So I urge a yes vote.
Rep. Froelich.
Thank you so much, Mr. Chair. Folks, really the whole point of this bill is the third RTD Accountability Committee in 6 years. The RTD Accountability Committee met for a year, a diverse body, and their ultimate recommendation was establish a 9-member board, 5 elected, 4 appointed by the governor, and confirmed by the Senate with a vote of 11 in favor and 2 opposed. We ask for a no vote on this amendment.
Seeing no further discussion, the motion before us is the adoption of L38. All those in favor say aye. Aye. All those opposed say no. The amendment fails. Rep. Richardson.
Quickly, Mr. Chair, I move L037 to the committee report and ask that it be displayed. Yeah.
Okay, that's properly displayed. To the amendment.
Thank you, Mr. Chair. Colleagues, while we can all hope that third time was a charm and that this study actually got the right answer for us to implement, changing the salaries of the RTD directors right now would be a little premature before we actually have some proof that this is actually doing something to improve service to the people of Colorado. The fiscal note notes that there'll be a study provided by a third party to look at providing services to riders with disabilities and others that's funded in 26-27, but that beginning in 28-29, the bill increased the annual costs to raise salaries for RTD board members by $162,000. I just think it is premature at this time before we even know if this is going to have some impact that we're paying before performance by increasing salaries. We've got plenty of time to decide in the future if these directors, if the directors and the makeup of the board is the reason why RTD is failing the people of Colorado, then perhaps we should let them prove their worth before we increase their salaries. I urge a yes vote.
Rep. Jackson.
Thank you, Mr. Chair. This isn't about pay for performance or pay before performance is demonstrated. The increase in salaries is to make these seats more competitive and to be able to attract people to want to run for these positions. If you look back, a lot of these RTD district seats have largely been unopposed and one person running and winning. And so the reason for this is to try and make this more competitive so that we can have better expertise, better skill sets on the board so that we can get better outcomes for our communities. I would ask for a no vote on this amendment.
Seeing no further discussion, the motion before us is the adoption of L37. All those in favor say aye. All those opposed say no. The amendment fails. Seeing no further discussion, the motion before us is the adoption of the committee report. All those in favor say aye.
Aye.
All those opposed say no. The committee report is adopted. To the bill.
You want to go first?
Yes.
Rep. Jackson.
Thank you, Mr. Chair. This bill really is about better outcomes. And I think one thing that we can all agree on is that RTD has not been delivering the results that any of us want to see. We have seen routes cut. We have seen existing routes that have been maintained, the frequency of those buses coming around being less frequent. We have seen safety issues, and part of the reason we haven't seen improvement is a result of the board makeup. there have since been 3 accountability committees, and let me say bipartisan accountability committees, who have taken the time to look at all of the contributing factors to what RTD should be doing, where they have missed the mark, where they have not appropriated dollars where they should have, where they appropriated dollars that were wasted. And so this was this most recent accountability committee, it was an evidence-based process, and if anyone knows about what evidence-based means, it means that the things that they were looking at had already been proven to be effective by research. And so one of the 2 big portions out of that the committee were that board governance and also operations. And so what this bill addresses is the board composition in making sure that RTD actually works for the people who rely on it every day. We know that RTD has had declining ridership, budget issues. There was already talks like last week about further budget cuts and further cuts to service. And so this bill directly responds to the recommendations of that committee, and it takes a comprehensive approach to improving governance, performance, and rider experience. It requires a data-driven assessment and a long-term plan to improve our paratransit services, ensuring that riders with disabilities have reliable and accessible transportation. It modernizes the governance structure by creating a smaller, more effective board that combines elected representation with subject matter expertise in finance, transit operations, and equity. And a lot of the conversation that we've heard around board governance is saying that, everyone agrees that RTD needs improvement, and nobody agrees on exactly what that looks like. But the Accountability Committee was very intentional in looking at all of the different options, and they came up with a 5-4 makeup. I'm sure we will have amendments about the makeup. But lastly, what this bill does, it strengthens accountability. It identifies clearer performance expectations regarding the finances and also around ridership, so that we are really delivering the best results we can for riders who rely on RTD every day. And I would ask for your support.
Rep. Froelich.
Thank you so much, Mr. Chair. Folks, thanks to the folks who are remaining. Some folks are not in the RTD district. So I would just simply say your vote is a vote for economic accountability, for good outcomes, and for a robust transit system in Denver. If you are in RTD district, chances are you are not getting the service that you pay for, and you would like an effective transit system. RTD has failed to keep up with transit agencies in recovering service after the pandemic. Only 76% of its 2019 service hours, when their peers have recovered 94 on average after the pandemic. They've failed to keep up on recovering ridership after the pandemic. We're at 62%. The other peer agencies are at 75. They have the lowest year-over-year growth of any peers at 0.1%. They deferred maintenance to the tune of $200 million, and they are now in deficit over that deferred maintenance. Their response to maintenance has been reactive, not proactive. It was only the PUC that made RTD take action, and they shut down the tracks on the downtown loop and put in tighter inspection standards in 2021 and have failed as of now to implement those safety procedures. They have failed on their transit asset management. They have lost $307 million on light rail. These aren't small numbers. When RTD was forced to act, they closed they had three highly disruptive projects in the same year at the same time. That led to a 30% decrease in year-over-year light rail ridership. They just discovered the G&B line, paid for service, oops, never got it. When pressed only by outside advocates, they said, oh, we routed that money to the A line. And when the investigative journalists went in, they discovered the delta between the investment in the A line and the G&B service that was never delivered doesn't add up. So the RTD Accountability Committee met, and a 13 group of folks, and came to a remarkable consensus. The least number of votes in favor of anything that we're implementing was 11 and 2 opposed. They are the ones who have suggested a 9-member board and a 5 elected and 4 appointed. The 4 appointed purpose is to bring expertise into RTD. The 4 appointed must have either finance, transit, we have the first in the nation union presentation, and then we have DRCOG making an appointment to make sure that we're geographically diverse, which is another of the criteria, and that we address disproportionately impacted communities. The only way to get that is through the appointments. We have not had expertise on the RTD board. 40% of the seats go uncontested completely, and in this particular board seated right now, 2 people ran and there was nobody running. So they were write-in candidates who received a couple hundred votes and are now sitting on the RTD board. So we want to attract people to the board for those 5 elected seats. We're paying them triple what they're going to be paid now, and then we have these 4 appointments. I don't think there's anyone in the chamber, bar a few, especially on my side of the aisle, that has had more challenges with the first floor. And so for me to say that I really think this is the way to go, I think holds force, and we'll let the folks who have a different idea come forward.
Any further discussion? Brett Bacon, Amel Bacon.
I don't know what this is. Sorry. Okay, thank you, Mr. Chair. Members, I want to share with you, for what it's worth, why I'm here with my colleague from Aurora. We have been told that the City and County of Denver and Aurora opposed this bill. I do want to mention, though, because I know everybody's frustrated about it, that on behalf of myself, I might speak a little bit differently than my colleague from Aurora, but on behalf of myself, in having watched this conversation for the last couple of years, I do believe that the work of the task force has been really, the accountability task force has been really important. And there's some really, quite frankly, some spot-on policy recommendations in the bill. Denver and Aurora, though, have been asking for advocacy and representation on the remaining elected seats. Between our 2 cities, we have the lion's share of ridership. And so if you have been hearing about ridership, what we're talking about is, even though we recognize that the RTD, or the district that is for the regional transit, spans into some other cities, the majority of the people who use the transit reside in ours or enter or board, if you will, through our cities. I represent the airport at the one end of the A line. Downtown Denver and Union Station is the other end. What we were always familiar about with rideshare is the definition of it, which, you know, our colleagues have explained, which rideshare really means where people get on. And so, yes, in my district, we have the airport. A lot of people coming in and out of Colorado come through the airport. Denver does pay its fair share, if not more, of sales tax because people come through our city. What happens through Denver is really moving people around the region, but most importantly, what I know about my district is that the rideshare numbers are attached to where people get on, but we have always utilized that for representation and voice, considering who typically uses RTD. There are people that I represent in my district who do not have, I guess, the typical background of those who would enter advocacy. I have lower income people, people who need transportation. I have the disabled. Between our two cities, we have routes to multiple hospitals for low-income and disabled people. And so when we look at the seats, it is not lost on anybody every city's interest in having representation. It is not lost on us. But when we're talking about ridership, we have an interest. Now, what we hear from the sponsors is that of the 5 elected seats, given their size, Denver and Aurora are bound to have a seat. We do know, though, that when we think about that seat and that it's at an at-large type of space, if the districts were drawn towards ridership, there could be potential to actually have a little bit more of proportional representation on behalf of our communities, and that our communities wouldn't have to figure out how to advocate for their needs for buses that run through Colfax with the majority of a board who are in the suburbs. And so for our cities, or I'm sorry, I'll speak for myself in this moment, when we talk about rideshare, that is why we had an interest in figuring this out. Our cities have asked for guaranteed seats. I will say, by default, given the size of these districts, it is true that Denver and Aurora may be bound to have their own seats, but if the seats were drawn towards rideshare, we would have representation. And so given personally some of my conversations with you all about how I feel generally about at-large districts, because Denver might have 1 seat, I am concerned. Our city has had many conversations about who has the ability to run and access to run. And when I think about who might represent Denver, I do think about how can we think about districts where folks who have the needs I just identified could be the people eligible to run versus just someone from across the whole city that may not even, actually have these buses run through it. So these are the conversations. When you see that opposition, it has been about seats and rideshare. Again, and I know people are frustrated and they may not be listening, but it is not about some of the concepts that we heard with the need for professionalism on this board, the professional expertise in planning and finance. But what we're considering, and yes, our RTD might be one of the only elected boards in the country, but it is our culture. And people do want to know they have a pathway to advocacy and how they can be received. So I will also acknowledge the 4 appointed seats. But when it comes to the bulk of this work for this elected board, let alone this agency, is to manage amongst all of us who utilize the service, then we should be thinking about who utilizes the service. And so that's where our cities are coming from.
Members. Rep. Ricks.
Yes, thank you, Mr. Chair. Look, members, I'm very concerned about Denver and Aurora. I'm an Aurora rep, but I'm standing here with my colleague, Rep. Bacon. These 2 cities have the largest share of ridership when it comes to RTD. They were not invited to the stakeholding work on this bill. Denver and Arapahoe counties contribute the most sales tax revenue to RTD and contain the most system-wide rail-covered corridor miles in the region. In 2024, Denver contributed over $22 million in sales tax revenue, and Aurora contributed $15.3 million. And they were left out of the conversation. This board has the opportunity to impact a large portion of Denver and Aurora residents And the fact that they were not guaranteed sufficient representation is detrimental to RTD operations. Denver and Aurora have asked repeatedly, over and over, again, for board representation to take into account ridership as a consideration for designing the districts. They have been told that the accountability study shows something otherwise, so therefore their voices don't count. Ridership was actually included in the introduced version of this bill, but it was stripped out in the House. In the Senate. So I cannot support this bill. There's nothing in the bill really that proves that by redoing the composition of the board is going to have the impact on the ridership. And ridership is important. People use this to go back and forth to work. They use it to go to school. They use this, to go to hospital. Some people, that's all that they have. And so we want to make sure what we're doing is the right thing, not just because there's a bill that we've been trying to push for the last 6 years, should we just push this bill through. We want to make sure that people are represented, and the cities that are going to be greatly impacted the most have a voice and have strong voices on this board. We ask for a no vote on this bill.
Further discussion. Rep. Jackson.
Thank you, Mr. Chair. As being a representative from Aurora, another one of the bill sponsors is from Aurora. I would like to set the record straight about the level of engagement with the city of Aurora. This is one of the most heavily stake-held bills that I have been a part of, and that engagement was not matched. That engagement was not reciprocated. So it wasn't from a lack of engagement on behalf of the bill sponsors. It was a lack of engagement for I don't know what reason. I don't have that answer, but this is one of the most highly stake-held bills that I have been on. And coming from Aurora, with over 400,000 residents, Aurora is one of the only 2 cities in the region that will be the majority of one elected seat. So what that means is Aurora has representation. We're not taking representation away. We are changing representation. Go ahead.
Rep. Froelich.
Thank you, Mr. Chair. Couple things. 2 years ago, we brought a bill, and Aurora took an amend position on that bill. Then that bill died, and then we brought last year's bill, which created the Accountability Committee. The Aurora never took a position on that bill. The Accountability Committee meets and invite public comment throughout. Aurora never engaged. The bill sponsor presented at DRCOG, where representatives from Aurora were present, and they did not engage. Aurora first reached out to the bill sponsor on the Senate floor asking for an 11-member all-elected board with no appointments and no expertise. As was mentioned, 2 of the bill sponsors are from Aurora. Let's not mistake stakeholder engagement when you don't get the outcome you want with the stakeholder engagement not happening. Let's talk a little bit about ridership. This is a really important metric. This is the whole reason I do these RTD reform bills. We lag in ridership. Does Denver have the most ridership? Yes, it does. Why? It has the most service. We would love to have service. They cut a whole line into my district. They consistently cut suburban districts and suburban service. So no, ridership is not evenly spaced. The only way you can get to the airport is to embark at a station in Denver, at what's it called? Union Station in Denver to get to the airport. All of that counts for Denver ridership. We would love to be able to go up 225 on the light rail and get to the airport. The workers at the airport have been asking for access to the airport. That would be in Aurora. Aurora does not get the service that it deserves. We're in this to get service for working people, for people to go to their doctor's appointments, for youth to work after school. After a year of deliberation, this accountability committee for the third time came up with this solution. We asked for a yes vote.
Rep. Jackson.
Last thing, thank you, Mr. Chair. Last thing that I'll say is that as we aim to improve the governance structure of RTD, it should better serve economic hubs in Aurora, like Anschutz Medical Campus, like the Buckley Air Force Center. We need better outcomes on the Colfax corridor. And as the second most populous city in the region, Aurora will benefit from a more accountable, performance-driven board that understands residents' needs and prioritizes frequency with reliability to get more residents on transit. I ask for a yes vote.
Mr. Speaker Pro Tem. He was first.
Thank you, Mr. Chair. It's an honor to serve with you.
It's an honor to serve with you.
Members, I wanted to take a second to speak about this bill because for years now, Fort Collins, the district I represent, has been...
Mr. Speaker Pro Tem.
Thank you, Mr. Chair. For years now, Fort Collins has been a spectator to issues with RTD that have come before a committee I have served on since my first day in the legislature. What has been interesting to me is not only the multiple accountability committee and reform committees that I've had the obligation to entertain results from, but also the conversations that continue into this bill. And I will say it is a point of pride for me to serve on transportation, housing, and local government because I think our committee is intentional and thoughtful about moving bills forward that impact transit, not just for the Denver metro area, but quite frankly have implications all across our state. In recent years, my interest in this space has shifted significantly because I understand, as many throughout our state understand, that without a vibrant, healthy RTD, we cannot meet the transit goals elsewhere in our state. And that includes serving my district and the districts in between Fort Collins and Denver with Front Range Passenger Rail and building that out to the south. And so I will say there is an interest of the entire state in making sure that RTD is viable and able to meet this moment. What we hear time and time again, however, is the struggles that they've had in doing so. And I think you can point to a lot of things for why those struggles have happened. But one thing I want to point to in particular comes from the accountability report in particular. And this I'm just going to read briefly because I think it highlights both why we're talking about this today and also why I'm proud to support this bill. In the subsection that says governance at a critical crossroads, the case for urgent reform, it reads as such. The RTD Accountability Committee concluded that governance reform represents the most consequential and time-sensitive issue within the committee's statutory charge. While RTD has served the region for decades under its current governance model, the committee determined that the structure, practices, and expectation that may have been adequate in the past are no longer sufficient to meet the scale, complexity, and urgency of the district's current and future challenges. It goes on to say that members expressed a strong and shared belief that incremental or cosmetic changes to governance would be insufficient. And I think you have that in front of you now, a measure that meets the moment. These are not inconsequential or cosmetic changes that our bill sponsors are bringing forward. They represent not just a majority opinion of the RTD Accountability Committee, but in fact, in terms of governance, the only supermajority recommendation that was moved forward. That's the measure you have in front of you. I understand the concern about representation on the board. You also have communities between my district and Denver Metro that have for years paid for transportation that they have not received. That is true in terms of fast tracks. We see those things in terms of being denied representation or being denied service and demanding something better. I hear the concerns around this bill, but I firmly believe that 5 elected members, 4 appointed members, and then all of the other processes that exist around that governance structure would truly position the board to meet the moment. If 15 members, or 11 members, or 9 members, or 7 members were sufficient to meet the moment, then we would have that governance structure and we would not be in this issue. But instead, time and time again, and year after year, we hear the same concerns. So I salute the bill sponsors for taking a bold step forward, recognizing that RTD's success is our shared success as a region and as a state. I think this represents a bold step forward that ultimately reflects not just the consensus or supermajority opinion of the RTD Accountability Board, but what we all know to be true, that if current governance was effective in solving RTD's challenges, we wouldn't be here today. Instead, this is the opportunity to right-size the board, professionalize the board in a way we have not had the opportunity to do in the past, and also balance that with appointed officials that are able to bring key expertise. So thank you, bill sponsors. I'm in support of your legislation. I ask for a yes vote.
Rep. Joseph.
Thank you, Mr. Chair. I just want to thank the sponsors of SB 150 for all the work that they have done. My community, I am in support of the bill. I want to start there. I will be voting yes on this bill. But I just wanted to lay some of my concerns on the record. My community remain concerned that the proposed board structure will dilute representation for the northwestern communities within the district. Even though they are directly impacted by RTD service decisions, they have asked for the numbers of elected members increase from 5 to 7, while maintaining 2 DRCOG appointments. That structure reduces the overall board while preserving local accountability. The DRCOG appointments are important because DRCOG is well positioned to recommend individuals who understand ridership patterns across metro area, including counties with higher communities that need stronger transit access. The communities in my district are facing real infrastructure and service challenges. Ridership growth cannot happen in a vacuum. If the goal of the bill is to modernize RTD and increase use of the system, then the governance structure needs to have robust representation from across the district. The overall point is that modernization should not come at the expense of representation and equity. For communities, this is about making sure the new RTD structure reflects both where ridership exists today and where ridership can grow with the right support. Again, some of the amendments that were being asked, even though I will be a yes on the bill, was to expand the numbers of elected members from 5 to 7, reinstate the 2 appointed board members from DRCOG recommendation, and the board mandate to grow ridership must include all parts of the districts and more local government collaboration and sub-regional service councils. Again, I think this is a great bill. I do believe that the sponsors are on the right track, and with a few amendments, we can get the bill to a great place. And I will be a yes on this bill because when we are here at the Capitol, we don't want the perfect to be the enemy of the good, and we believe this is a good bill. Thank you.
Seeing no further discussion, the motion before us is the adoption of Senate Bill 150. All those in favor say aye. Aye. All those opposed say no. The bill passes. Madam Majority Leader.
Thank you, Mr. Chair. I'd like to move Senate Bill 160 to Monday.
Seeing no objection.
I'm sorry. Let me withdraw that,
Madam
Mr.
Majority
Chair.
Leader.
Thank you, Mr. Chair. I move Senate Bill 160. I'm sorry, I'm doing it again. I'd like to lay over Senate Bill 160 until Monday.
Seeing no objection, Senate Bill 160 will be laid over till Monday. Mr. Shebo, please read the title of Senate Bill 151.
Senate Bill 151 by Senators Colker and Gonzalez, also Representatives Bacon and Lukens, concerning modifications to the Public Employees Retirement Association.
Amel Bacon.
Thank you. I'm sorry. Thank you, Mr. Chair. I move Senate Bill 151.
To the bill.
Thank you. Members, Senate Bill 151 is a para cleanup. Ultimately, we needed to be in a place where a particular charter school network who was outside the scope of para when they formed back in 2004 have now agreed to be a part of para. And in order for them to do so, we need to change this within statute. This is good for para as it's going to bring now another 1,000 or so people into the program. The other thing that the bill does is move the Denver Public Schools seat, which is now ex officio, into a voting member because of the critical mass of people they bring into the program. And so again, members, this is a cleanup bill. In order to allow this charter network to participate in para, we need to change it as a matter of statute. For what it's worth, all of the other charter networks within Denver Public Schools are part of para. This particular network is Denver School of Science and Technology. They have teachers across multiple districts. And so the teachers that are in Aurora are participating in para, while the teachers in Denver cannot. And so we need this bill to pass so that we can find that streamlined execution. Lastly, I'll say is that any teacher that's a part of para means that their ability to teach elsewhere is portable without them losing their retirement. And so we do believe that this is fair for that network's teachers. Ooh, excuse me. And with that, I'll pass it off to my co-prime.
Representative Lukens.
Thank you, Mr. Chair. Senate Bill 151 brings fairness and consistency to teachers in accessing retirement benefits, and we ask for your yes vote.
Seeing no further discussion, the motion before us is the adoption of Senate Bill 151. All those in favor say aye. Aye. All those opposed say no. The bill passes. Mr. Schiebel, please read the title to Senate Bill 142.
Senate Bill 142 by Senators Ball and Kipp, also Representatives Joseph and Gonzalez, concerning the development of thermal energy resources.
Representative Gonzalez.
Thank you, Mr. Chair. I move the Energy and Environment Committee and Senate Bill 142.
To the committee report.
So in the Energy Committee, we had some amendments we had some more stakeholdering done to get people on board. So virtually there's no opposition. We had 3 amendments to make sure we had people who will benefit also from geothermal energy, and we ask for an aye vote.
Seeing no further discussion, the motion before us is the adoption of the E&E committee report. All those in favor say aye.
Aye.
All those opposed say no. The committee report is adopted. To the bill, Representative Gonzalez.
Thank you, Mr. Chair. So I'm really excited about this bill. This does geothermal energy. As we all know, we are pushing very ambitious climate goals, net zero emissions. So this bill will help us make sure that we have energy standards, making sure we have energy security, and making sure we don't have blackouts. I think at a time when we're also going to start having nuclear in the state, we have people in the state of Colorado who really want to have geothermal at their disposal, and making sure we work with the private sector and other stakeholders who want to be part of this. And I think this is just a good bill. So what Senate Bill 142 does, it's no mandates. It's no new mandates, geothermal. Right now, unclear statutes create unnecessary legal costs, delays, and financial risk. This bill provides clear rules of the road, lowering transaction costs and making projects more financially viable. Participation is entirely optional. No community is required to build or join a thermal energy network. Local governments retain full control over whether and how to pursue these projects. And first, this bill catalyzes geothermal investment at no cost to the state. By removing legal barriers rather than creating new programs or spending, Senate Bill 142 unlocks thermal energy networks that attract private capital to geothermal projects. Clearer legal pathways lower development costs, reduce financial risk, and make more projects bankable, all without a fiscal impact to the state. Second, the bill empowers local governments by authorizing cities, counties, and special districts to build and operate thermal energy networks. Third, Senate Bill 142 removes unnecessary barriers by streamlining requirements for municipalities. And finally, the bill expands geothermal electric power development by increasing community geothermal project sizes from 5 megawatts to 25 megawatts, and requires utilities to solicit proposals for small and large-scale electric geothermal projects. And I ask for an aye vote on Senate Bill 142.
Representative Joseph.
Yes. Thank you, Mr. Chair. Members, hello. I rise in support of Senate Bill 26-142. This bill is about giving Colorado communities more tools to meet their energy demands in a way that is reliable, affordable, and forward-looking. Across the state, local governments are exploring thermal energy networks, systems that use geothermal resources or recovered heat to provide heating and cooling at the neighborhood level. I was running really hard to get here. These systems can lower costs, improve efficiency, and reduce emissions, but too often projects are delayed by legal uncertainty. This bill provides the clarity needed to move them forward. It establishes clear authority for local governments to develop and participate in these networks while ensuring they are not treated as regulated public entities. That distinction matters. It removes barriers without expending unnecessary regulations. At the same time, the bill maintains the integrity of our existing energy systems. Investor-owned electric utilities retain their exclusive right to provide electric services within their territories, and nothing in this bill alters the law governing electric infrastructure. That balance allows innovation to happen alongside a stable and predictable utility framework. This bill also promotes coordination. Local governments developing thermal energy network must notify the relevant utility before construction begins, helping align planning efforts and avoid inefficiencies. Importantly, this measure connects thermal energy development to Colorado's clean heat goals. Emission reductions from these systems can count toward utility clean heat plans, while clear safeguards prevent double counting. That ensures we are recognizing real progress and maintaining accountability. Finally, the bill supports broader geothermal by expanding opportunities for community-scale projects and requiring utilities to identify and pursue new geothermal resources. This helps build the kind of clean, reliable energy that can serve Coloradans year-round. Members, this bill is not just a mandate or projects or impose new requirement on communities. It simply removes barriers, provide clarity, and allows local solutions to move forward. I respectfully ask for a yes vote on Senate Bill 26-142.
Email winner.
Thank you, Mr. Chair. I also rise in support of this bill. In Los Animas County, in my local community, we've seen the map, and we're in a huge geothermal hotspot. I know that this is something that we're looking at really developing down in my area. And as we've seen a lot of good paying jobs taken out, I don't know if they'll be able to replace these jobs, but a lot of the process is the same when they explore for natural gas. When you try to get to geothermal, the process actually is almost exactly the same. And you know, these gentlemen are trained to do this job. They'll be good at it when they hit the ground running. So hopefully this allows to keep some of those jobs with that skill set within House District 47. So I urge and I vote.
Rep. Taggart.
That's okay. Thank you, Mr. Chair. This is a very good bill, and it's about 30 years overdue. In our production facilities south of Zurich, Switzerland, we have been heating from our production facilities, the heat coming off of our equipment. We have been heating apartments for over 30 years. So this bill is overdue. We need to support it. Thank you.
Seeing no further discussion, the motion before us is the adoption of Senate Bill 142. All those in favor say aye. Aye. All those opposed say no. The bill passes. Mr. Shebo, please read the title of the House Bill 1423.
Rick. House Bill 1423 by Representatives Brown and Taggart, also Senators Amabile and Bridges, concerning requiring the Department of Public Safety to submit a community corrections budget in its annual budget request.
Representative Brown.
Thank you, Madam Chair. I move House Bill 1423.
To the bill.
Thank you. This bill requires the Department of Public Safety to submit a dedicated, clearly defined community corrections budget request each year so that it is no longer buried within the broader departmental budgeting. In addition, it requires the department to provide a detailed data on system capacity, including the number of residential and non-residential beds available, demand for those beds, and how individuals are distributed across judicial districts, and how reimbursement rates are structured. And the bill also ensures that this information is presented during the department's SMART Act hearing. You know, one of the biggest challenges that we face in budgeting for community corrections is really the lack of standardized, accessible information, which can make it difficult to fully understand where the resources are needed most. So we ask for an aye vote on House Bill 1423.
Representative Taggart.
Thank you, Madam Chair. I would just say this is another bill that's way overdue. In the interests of transparency and budgeting, we need to get a much closer view of what's going on in community corrections.
Is there any further discussion? Okay. Seeing none, the question before us is the passage of House Bill 1423. All those in favor say aye. All opposed, no. House Bill 1423 passes. Mr. Shebel, please read the title of House Bill 1014.
House Bill 1014 by Representatives Taggart and Basenecker, also Senator Frizzell, concerning an extension of the Colorado Job Growth Incentive Tax Credit through state income tax year 2034.
Sure.
Speaker Pro Tem Basenecker.
Thank you, Madam Chair. It's an honor to serve with you.
It's an honor to serve with you as well.
Madam Chair, we move House Bill 1014.
To the bill.
We'll talk about the bill a little bit, but first we have a technical amendment to offer. So with that, I move L1 to House Bill 1014 and ask that it be properly displayed.
Your amendment has been properly moved and is now displayed. Please proceed.
Thank you, Madam Chair. This simply extends the reporting period through September 2042. The bill only allowed that through September 2032, and without that extension, the department would be unable to process credit claims and recapture disallowed credits. So it's a technical fix that just makes sure our state agencies can do what they need to do in administering this tax credit. We ask for a yes vote.
Is there any further discussion on Amendment L1? Seeing none, the question before us is the adoption of Amendment L1. All those in favor say aye.
Aye.
All opposed, no. The ayes have it, and Amendment L1 is passed. To the bill. Representative Taggart.
Thank you, Madam Chair. House Bill 1014 authorizes or reauthorizes the Job Growth Incentive Tax Credit. This is a critical economic tool for not only OEDIT, but to our economic development organizations across the state. It has resulted in every tax credit that has been granted has resulted in a 4-to-1 investment. It has these credits over a 3-year period, over a 4-year period, created $132 million of additional revenue for our state, which averages about $33 million a year. It's important to note that businesses, to earn this credit, have to maintain at least 20 net new jobs for at least 1 year. And that also then applies to areas like mine where there's rural, where we can't do 20, we don't have companies big enough to do 20 new jobs, can in fact, in many counties that are spelled out here, can be in fact 5 new jobs. So I stress it is reauthorizing a tax credit that has been very helpful to our economic development groups across the state. And I would ask for an aye vote.
Speaker Pro Tem Basenecker.
Thank you, Madam Chair. Just to give some numbers to the scale and importance of this tax credit, since 2020 in Denver County, over 10,600 jobs have been created. In Douglas County, 556 jobs. Weld County, 813 jobs. In Jefferson County, 2,837 jobs have been created. It's important to note, and I'll just close with this, This is such a great return on investment, not the least of which is because oftentimes this tax credit actually overperforms. So for example, there was a project called Project Blue. The goal was to create 500 jobs. They actually created 780. Project Speed, the max was 40 jobs. They created 82 jobs. Time and time again, this tax credit overperforms in a way that benefits workers and ultimately our state. We ask for a yes vote.
Is there any further discussion on House Bill 1014? Seeing none, the question before us is the passage of House Bill 1014 as amended. All those in favor say aye. All opposed, no. The ayes have it, and House Bill 1014 as amended is passed. Mr. Shebel, please read the title of House Bill 1059.
House Bill 1059 by Representatives Hartsook and Stewart R., also Senators Frizzell and Snyder, concerning the cash funds created in connection with money retained by the Department of Revenue to mitigate the administrative costs incurred by the department in collecting certain charges.
Representative Stewart.
Thank you, Madam Chair. I move House Bill 1059 and the appropriations report.
To the appropriations report.
There was a small amendment to provide a little bit more accountability for continuous appropriations.
Is there any further Representative Hartsook.
Thank you, Madam Chair. Real quick, all the bill does is it consolidates 4 administrative tasks from DOR into one for the fund. This isn't debating what the funds do. It's just consolidating the 4 tasks and reducing the size of government on those administrative tasks. We request an aye vote.
Is there any further discussion on the Appropriations Committee report? Seeing none, the question before us is the adoption of the Appropriations Committee report. All those in favor say aye.
Aye.
All opposed, no. The Appropriations Committee report is adopted. To the bill, Representative Hartsook.
Ditto.
I love that. Okay. Is there any further discussion on House Bill 1059? Seeing none, the question before us is the passage of House Bill 1059 as amended. All those in favor say aye. Aye. All opposed, no. House Bill 1059 as amended is passed. Mr. Shebel, please read the title of House Bill 1255.
House Bill 1255 by Representative Story, also Senator Cutter, concerning protections for users of electronic media and in connection therewith requiring an operator of a social media platform to ensure the social media platform provides a streamlined process to allow a law enforcement agency to contact the social media platform concerning a search warrant and requiring an operator to report to a local law enforcement agency if the operator's social media platform receives a notice that a user has posted content that threatens imminent and specific harm to themselves or another individual, expresses an intent to commit a crime, or attempts to entice an individual to commit a crime.
Well done, Mr. Shebel. Thank you. Representative Story.
Thank you, Madam Chair. I move House Bill 26-1255 and the Judiciary Committee report.
To the Judiciary Committee report.
First, I move L00, one second. In committee, we passed an amendment that clarifies the threshold for when social media companies are obligated to share the contents of a post with law enforcement. The new threshold centered around social media companies taking adverse actions against a user, including the restriction, suspension, or termination of a user's account. And I move L005 to the committee report.
Amendment 5 is properly moved and has now been displayed. You can proceed.
Thank you, Madam Chair. Based on conversations we had with a number of stakeholders, we draft this amendment, L005, to further clarify 3 key aspects of the definition of adverse actions. First, the adverse action is taken by the social media platform in response to a user violating the platform's own policies concerning specific or imminent threats. Second, the adverse action must be subject to human review before the platform has an obligation to report to law enforcement. And third, the post in question must be generally open to the public. This language was heavily stakeholdered and must be with the ACLU to ensure we do not violate First Amendment or Fourth Amendment rights, and its passage will move them to a monitor position on the bill. I ask for an aye vote on this amendment.
Is there any further discussion on Amendment L5? Seeing none, the question before us is the adoption of Amendment L5. All those in favor say aye.
Aye.
All opposed, no. The ayes have it, and Amendment L5 is adopted. To the committee report.
Thank you, Madam Chair. I move L008 to the committee report and ask that it be properly displayed.
L8 has been properly moved and is now displayed. You can continue, Representative Story.
The amendment corrects language in the enacting clause to ensure consistency with the language that we adopted from the previous amendment. I ask for an aye vote.
Is there any further discussion on Amendment L8? Seeing none, the question before us is the adoption of Amendment L8. All those in favor say aye.
Aye.
All opposed, no. The ayes have it, and Amendment L008 is adopted. To the committee report. Representative Story.
Thank you, Madam Chair. I move the committee report as amended and
Okay.
ask for an aye vote.
Is there any further discussion on the Judiciary Committee report as amended? Seeing none, the question before us is the adoption of the Judiciary Committee report as amended. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it, and the committee report is adopted. To the bill, Representative Story.
Members, I want to take a few minutes to discuss the background of how this bill originated and why
Representative
it's so...
Story, just a moment. Members, please, it's a little too loud in here. I want to make sure I can hear the bill. Thank you. Representative Story.
Thank you. Members, I want to take a few minutes to discuss the background of how this bill originated and why it's so deeply important to the community I represent, as well as Coloradans across the state. On September 10th, 2025, the shooting at Evergreen High School completely shattered the peace of our community. The perpetrator, a 16-year-old student at the school, shot and critically injured 2 students before taking his own life. In all, around 20 rounds were fired over the course of 9 minutes, both inside and outside of Evergreen High School. 9 minutes. Those 9 minutes permanently altered the Evergreen community, and its effects will be felt for years to come. Even now, some teachers and students struggle to return to the building, haunted by graphic memories that stay with them every single day. Families continue to wrestle with the heavy uncertainty of whether their children and loved ones are truly safe the moment they leave home. Despite the unspeakable horror of this event, the Evergreen community united together and displayed remarkable strength and resilience. In the Judiciary Committee, dozens of Evergreen and Conifer students, teachers, grieving families, and community members from across my district came out to testify in support of this bill. They courageously shared their experiences and trauma around this shooting, and I want to share briefly some excerpts from their testimony about the continuing impact of this horrific event. We have been through the unimaginable fear that we have been aware of since the early years of elementary school, a fear that came true, a fear that does not have to become a reality. It was a dark day. Our innocence and sense of safety were shattered. My baby sister was only 14 years old and just 16 school days into her freshman year. In the midst of the chaos, my sister had a panic attack after the shooter found her in the hallway and fired several rounds of bullets before she was able to run for safety. I received some of the most alarming text messages of my life. Messages from my sister saying she had to run for her life. While caring for the infant I nanny for, I helped safely shelter several students from our neighborhood in nearby homes. I never hugged her as tightly as I did that day. I didn't even want to let go. My son was at school that day coming back from lunch. He was there, outside the school, watching things unfold when the shooter turned the gun on himself. My son is a teenager who should have been thinking about college applications and Friday night plans, and he witnessed a school shooter's suicide. That image does not leave a person. It does not leave a family. 6 months later, we are living in the aftermath of something that should never have happened. My 17-year-old son walked into the hallway to refill his water bottle. He stopped for a moment to talk with a favorite teacher. Seconds later, he heard a loud noise and just a few feet away turned to see a gunman fire directly at him. My son ran. He followed his instincts, yelling to warn others as shots followed behind him. He could have been killed. At home, I got a text from my husband, a coach at the school. Shooter in the school. I have our son. Our daughter is running. Terror ran through my body. As I raced to get my freshman daughter, she was running through a neighborhood, hearing gunshots behind her, surrounded by students who were screaming and crying, unsure if she was being chased or how close the danger was. This was less than 2 weeks into her first year of high school. My 11-year-old sat in the dark, hiding under his desk. A text from our son said, "I love you guys." We knew there was a shooter at the high school. He ran to the band room and into the director's office while bullets flew at the room. In the weeks and months since, I have watched my children carry this with them. My son struggles to sleep. He's on edge, constantly scanning his surroundings. My daughter is afraid to be alone. She gets sick from the anxiety. Some days just going to school feels overwhelming. Unable to focus, both were forced to reduce their class loads. They lost their appetites and then lost weight. Loud sounds bring a feeling of fear into their bodies. The sound of walkie-talkies or announcements at school, lockdown drills, false alarms, and even, especially, ordinary school days bring those terrifying moments rushing back. The trauma my son lives with is not abstract. It is the reason he sometimes goes quiet at dinner. It is the reason certain sounds make him flinch. It is the reason I watch him more carefully than I did a year ago, and why I will probably keep watching him that way long after he leaves for college. 7 months later, the shooting still affects our family every single day, and nights too. Our 15-year-old has nightmares. We all have anxiety. Our 12-year-old is dealing with complex trauma and has recently started having panic attacks. Trauma counseling is ongoing. They spend part of their lives in therapy trying to process something no child should ever experience. As a parent, I feel it too. A siren, a loud noise, and my body immediately goes into panic. My heart races. My mind goes to the worst place. I must make time for therapy. As a parent, it is incredibly painful. To watch your kids carry this fear. Law enforcement responded to the Evergreen shooting in 2.5 minutes. The gap was not in their response. It was in the weeks and months before September 10th when the information that might have prevented the shooting was sitting in a platform system with no legal obligation to move. Had this requirement been in place in the summer, the Jefferson County Sheriff's Office might have received a report in July when the Anti-Defamation League flagged it. They would have had a name, or at minimum a path to a name. They would have had 2 months. 2 months is enough time to intervene in a young person's life. 2 months is enough time to prevent a shooting. My son would not have seen what he saw. The shooter had posted about violent intentions months before the attack. If adverse actions were reported by social media, the social media platform, this shooting could have been prevented. If search warrants were addressed by the social media platform faster, this shooting could have been prevented. No child should ever have to sit in a room that takes gunfire. No family or sibling should ever have to sit with that kind of fear. No social media platform should ever be allowed to sit on threats or warrants. Reporting and timely response could have saved my family and our community a lifetime of dealing with this trauma. The trauma has changed our family in immeasurable ways. The maddening part is knowing it didn't have to happen. There would have been an opportunity to intervene months earlier, before a gun was ever brought to their school, before my children had to run for their lives. Please sit. Thank you. I appreciate you. As these witnesses alluded to, this bill is a response to the systemic failure in the search warrant process that could have provided an opportunity to disrupt this shooting before it took place. A social media post foreshadowing this attack was flagged by the Anti-Defamation League in New York as early as July 5th. A complaint was filed with the New York FBI, who then, with probable cause, initiated the search warrant process. Under our current system, social media platforms have 35 days to respond to judicial search warrants. 3 separate judicial search warrants are required just to identify a single individual. Each respective search warrant uncovers a different layer of identity. This process took about 70 days to identify the user and hand over the file to the Jefferson County Sheriff's Office. Tragically, the shooting occurred 2 days before the information finally reached local law enforcement. 2 days after the shooting happened, highlighting a critical gap in how threats made on social media are identified, reported, investigated, and acted upon when necessary. Over the past 8 months, I have worked closely with the Evergreen community, Sheriff Marinelli, District Attorney Doherty, and a significant number of stakeholders from across the spectrum to address this crisis. House Bill 26-1255 requires social media companies to comply with search warrants within 24 hours. It also requires platforms to provide a streamlined process for law enforcement to contact them, including a 24/7 staffed hotline. In addition to these requirements, this bill establishes a duty to report for social media companies. As I shared earlier, this duty is triggered when a platform takes an adverse action, specifically the restriction, suspension, or termination of a user account, in response to content that violates platform policies concerning specific and imminent threats. The platform must report the content allegedly posted by the user to a local law enforcement agency no longer than 24 hours after that adverse action is taken. Some colleagues have asked about the impacts to 1255 because of similar policy, and there are a few ways to address this challenge. I attempted to address this earlier, but there was no agreement among parties to do so. I will offer 2 amendments to conform the bills so they will no longer be in conflict. I move L009 to Senate Bill 261255 and ask that it be properly displayed.
Representative Story, I'm sorry to ask you to restate that, but I'm going to have you say House bill and not Senate bill.
Oh, my goodness.
It's okay. It's been a long day.
I move L009 to House Bill 261255 and ask that it be properly displayed.
The amendment's now properly displayed. You can proceed.
Senate Bill 2611 recently passed the legislature and was signed into law by the governor. The bill establishes a 72-hour search warrant response time for social media platforms. We have drafted a couple of amendments to conform the 2 bills so that their language is not in conflict. This amendment conforms these bills in 3 key ways. First, L009 amends House Bill 261255 to add district attorneys to the enforcement provisions. This makes it so that both the Attorney General and District Attorney can enforce the provision. Second, L009 amends Senate Bill 2611 to include a $250,000 civil penalty for noncompliance with a search warrant, up from $5,000 currently in the bill. A $250,000 penalty provides a significant incentive to comply with the duty to report element. The ACLU, local law enforcement, and the DA recommended increasing the penalty amount so that it is significant enough to serve as a deterrent. And third, L009 amends Senate Bill 2611, which has a 72-hour search warrant response time, to conform to the 24-hour search warrant response time in Senate Bill House Bill 261255. Because the search warrant process is a 3-step process, a 72-hour response time would result in 6 additional days to process judicial search warrants compared to the 1255 bill's 24-hour search warrant response time. In the case of the Evergreen High School shooting, had the search warrant process taken just 3 days less or just 4 days less, local law enforcement could have interrupted or disrupted the shooter's plan. Lives could have been saved. Critical injuries wouldn't have happened. The students, educators, staff, parents, and the whole Conifer Evergreen community would have been spared the immense trauma and PTSD that will be with them the rest of their lives. Days matter. Hours matter. This is about protecting communities and saving lives. I ask for a yes vote on L009.
So is there any further discussion on Amendment L009? Seeing none, the question before us is the adoption of Amendment L009. All in favor, say aye.
Aye.
All opposed, no. Amendment L9 passes. Representative Story.
Thank you, Madam Chair. I move L10 to House Bill 261255 and ask that it be properly displayed.
Your amendment is now properly displayed. You can proceed, Rep.
This amendment substitutes the definition of covered platform that is in Senate Bill 2611 to become social media platform definition in 1255. Specifically, the definition includes a monthly user minimum of 1 million users. In response to testimony from smaller platform owners, we adopted this definition to exclude these smaller entities from the requirements. But before we vote on L010, I move L011 to amend L10 and ask that it be properly displayed.
Okay, Amendment L11 is now displayed. Go ahead and proceed.
Thank you, Madam Chair. L11 amends L10 to include internet gaming platforms in the social media platform definition, and I ask for a yes vote.
Is there any further discussion on Amendment L11? Seeing none, the question before us is the adoption of Amendment L11. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it, and Amendment L11 is adopted. To Amendment L10.
Thank you, Madam Chair. I move L10 as amended to House Bill 26-1255 and ask that it ask for a yes vote.
Is there any further discussion on the amendment as amended? Seeing none, the question before us is the adoption of Amendment L10 as amended. All those in favor say aye.
Aye.
Those opposed, no. The amendment as amended passes. Representative Story to the bill.
Thank you, Madam Chair. Members, this bill is fundamentally about saving lives. Over the past 8 months, we have engaged in extensive stakeholding to ensure this measure effectively protects Coloradans while upholding our constitutional rights. This effort has resulted in a broad coalition of support, including law enforcement leaders like the Colorado Association of Chiefs of Police and the County Sheriffs of Colorado. Our supporters also span numerous municipalities and key healthcare, educational, and civic organizations, such as the Colorado Nurses Association, Common Spirit, the League of Women Voters of Colorado, the Jefferson County School District, and the Colorado Organization for Victim Assistance. Additionally, by adopting the committee amendment, we have successfully moved the Colorado Criminal Defense Bar to a soft amend position. Based on our extensive conversations with these stakeholders, I cannot overstate the importance of the duty to report element of this bill. Law enforcement can only act on the information they actually receive. If the Anti-Defamation League had not flagged the Evergreen perpetrator's post, a search warrant would never have been initiated in the first place. Without a clear threshold for reporting, a direct threat could be scrubbed from public view by a platform before its legitimacy can even be investigated. This duty to report provides our law enforcement officers a genuine opportunity to disrupt a plan before it turns into tragedy. This bill does not mandate the removal of posts or the shutdown of websites. Instead, it ensures that when a specific imminent threat is identified, critical information moves at the speed of the modern world. Social media platforms are multi-billion-dollar industries equipped with the most advanced technology. They have the capacity to be partners in protecting our residents. By passing this bill, we are choosing to prevent acts of violence before they happen, sparing our communities from the trauma and PTSD that still haunt Evergreen and Conifer today and will for their lives. We owe the people of House District 25 and all Colorado residents nothing less. In closing, I wish to share thoughts from the family of the unnamed 14-year-old Evergreen High School victim, which was released to the public through the Jefferson County Sheriff's Office about 2 weeks after the shooting. Our 14-year-old son endured the unimaginable, a face-to-face encounter with a violent school shooter filled with anger and hatred. Our child suffered traumatic gunshot injuries and has remained hospitalized and undergone multiple surgeries since the incident. In those terrifying moments, our son showed a level of bravery, strength, and will to survive that no child should ever be asked to display. He and his friend confronted the assailant, which undoubtedly allowed time for more students to flee and the school to lock down. This life-altering encounter happened before alarms were set off or lockdown announcements made. Our son was shot at close range, yet he was able to run from the school to save his own life. As he and his friend ran through the school to escape, they alerted classmates about a student with a gun. Our son reached the recreation center behind the school and received immediate critical first aid from an EMT firefighter who was working there. The family said they are grateful for the efforts of many people in their son's escape. To the librarian who pointed him towards safety as he ran for his life through the library emergency exit. To the EMT firefighter and others who gave him care in those first critical moments. To the first responders and initial hospital staff who triaged his injuries. To the flight team who flew him to the pediatric intensive care unit. To the incredible nurses, doctors, surgeons, and care providers who dedicate their lives to helping children and families on their darkest days. To the Jeffco deputies standing guard outside of his hospital room to provide a sense of safety, as well as the victim advocates. And to the Evergreen community and communities across our state and country who have surrounded us with love and support in so many ways. It is through your support that he will persevere and return to the community that loves him. He also asked how this could happen. His mind and messages were clear. The adults responsible for protecting children must take real, meaningful action so that no child or family endures this kind of horror in school or anywhere. The road ahead for our beloved son and family will be long and complicated, physically, emotionally, and in ways we cannot yet imagine. His and our wish is that real change can come from it, finally. I urge a yes vote on House Bill 26, 1255.
Representative DeGraff.
Thank you, Madam Chair. These are tough bills, without a doubt. These kind of tough bills should not be left for the waning hours on a Friday after a full day.
Do you want to speak to the bill, Rep?
I do.
I welcome you to do that.
Thank you. The gravity of a bill like this is immense. But what we have to also contend with is the results of a bill like this. It doesn't matter how good intention. And my fear is that because we have to be very careful about crossing a line that should not be crossed. That certainly does not negate or minimize the issues that are before us. Some of those are because we have a culture that minimizes life and celebrates death. But when we start to compel private platforms to monitor speech and report users to government based on subjective standards, I have concerns. It's not a narrow tool, it's a broad mandate that invites over-reporting, false positives, and could, not the intent, but could have a chilling effect on lawful expression. So these are the things that we have to balance. These are the things that we have to wrestle with. This is a very weighty bill that should have the full weight of the General Assembly in consideration. not a fraction. We have a constitutional framework for a reason. If the government wants to access private communications, it must show probable cause and obtain judicial authorization. We have those for a reason. I've just been having a very long discussion about the Fourth Amendment and your right to privacy. Now, certainly we don't have the right to violate somebody else's life. That's not in consideration, but we have to balance now. We have to balance the concern that we have in the effort, and we have to balance that against a right that we may or may not still have. Because there are some that feel your right to privacy, your expectation of privacy, is unreasonable. And this further goes down the avenue that your right to privacy, your expectation of privacy, is unreasonable. And I think that's a very, very dangerous slope. And we can't just cross it. We can't just start going down it. However you want to use it, whatever metaphor you want to use, we can't just start going down it because it's certainly not a minimized thing, not to minimize anything, because what happened is horrific. I would also consider that what happened is a symptom of where our society is now, but this bill flips the structure. And we risk losing a safeguard against abuse. We know, whether intended or not, that tragedy is often used for purposes other. I don't think that's the case here. But we have to be cognizant, we have to be vigilant, we have to actually dig into these things because we don't want to flip that structure. We don't want to turn private companies into frontline decision makers about what speech triggers law enforcement involvement. And if we mandate that, let's say we mandate that, and we create a duty. Duty, then, is the sublimest thing. You can never do more. You should never wish to do less. And if you create a duty, you create an obligation. And if you have an obligation, that creates ramifications, because what if you fail in that duty? What if somebody is unsure? What if somebody is unsure whether that is hate speech and speech is violence, and therefore it's okay that we need to turn somebody in? We've gone down that path. We don't want to flip that structure. We don't want to turn private companies into decision makers about what speech triggers law enforcement involvement. It's not their role, and it shouldn't be. Now, I think we could encourage them. We could encourage them to, if something is known, if somebody reports something and there's something in there. But if we start monitoring this and we start requiring this and we start saying this is a duty, and if we say this is a duty, we create an obligation for them to monitor all speech. And not just monitor all speech, but be responsible for the content of all speech. And if you're responsible for the content of all speech, then at some point the only way to handle this is to start limiting it. And when you limit speech, you limit the opportunities that you have to solve problems peacefully. And you just balkanize society, and I think you could risk creating bigger problems than we have, because what we'd like to do, what we should be able to do is we should be able to encourage communication. We should certainly be able to encourage communication without having laws that turn speech platforms into mandatory reporting. I understand the intent. The intent is good. But if you create them, and it's easy to look back in hindsight and say, if that person had been reported, everything would have been fine. But there's also millions of cases where if everybody had an obligation to report, where they could be, say, fined. In this case, you could be fined for not fulfilling your duty if somebody decides that is the mechanism. Then the only solution is to stop speech altogether. We agree that real threats must be addressed quickly, and they can be. We have emergency exceptions, and we have warrant processes. In this case, they took a little longer. Could they have been faster? I don't know. They can certainly be faster now. Had a conversation earlier about somebody that received a death threat, pulls up the app, finds the person in minutes. The identity is known in minutes. That was then. This is now. So we want real threats to be addressed quickly. But if we create if we create an obligation, again, we are risking a lot more. Because the only way to handle that is to have false positives. You're going to have false positives no matter what, but if you create a mandate, if you create a dictate that must be done, or you have failed in your duty, you have failed in your obligation, then you will have many more false positives. And those false positives have ramifications. We all know of swatting. So we want these real threats to be addressed quickly, and they can be. We have emergency exceptions, and we have warrant processes. Can they be faster? Perhaps they should be. Maybe that's a process that we need to work at internally and say, well, if somebody turns in a credible threat, this is how they would do it. It would be evaluated, there would be a warrant, and then we can go at it more quickly. But to make a social media company a mandatory reporter, what we shouldn't do is replace those guardrails with a system of compelled reporting based on vague standards. Public safety and constitutional rights are not in conflict. But this bill could put them in a collision course. That's my fear. That's not the intent of the bill. I'm confident.
Representative, you're welcome to speak about what your intent is, but not the intent of others, please.
Okay. I'm concerned about a bill that requires, and maybe the amendment took this out a little bit, but I'm concerned. I like the upgrading this to more people. But if this is or becomes a platform used to monitor content, I'm concerned. If it imposes mandatory timeline compliance, I'm concerned. If it requires mandatory 24/7 surveillance, access or staffing, I'm concerned. I'm concerned if we ask a platform to monitor, to review, or surveil user content. Would that be helpful? Yeah, we have AI. The AI can certainly go through everybody's platform looking for content that might be considered an imminent threat. Is it foolproof? Maybe. Maybe not. What happens if we have user content or communications that's just all reported to law enforcement? Because it's an obligation, it's a duty. Not something where it's encouraged and it's protected And if you do this in good faith, you have the cover instead of being then attacked as something else, because we've seen that too. We've seen the see something, say something, and then when somebody says something, they say, that's something you weren't supposed to say, and now you're in trouble. But they had a duty, they had an obligation, but they didn't have the cover. I don't think we should create a duty to monitor or investigate activity. We can encourage it there if there's a concern, but a duty is an entirely different level. I think a covered platform may, in good faith, certainly. If it receives a threat and they think that it rises to the level of law enforcement, that they disclose that information to law enforcement. That makes sense. But to make it a duty, to make it an obligation, I think you're going to be inundated, not protected. Because if the government creates a duty to report based on an imminent threat, then what happens if the government decides to upgrade what it should report? And that's part of the slippery slope. Maybe right now you have a duty to report specifically an articulable facts, events. But what if that is upgraded to offenses to the state? Questioning of the state. We see that happening in other countries, a duty to report. This is where these things start. Not intentionally, they just do. A covered platform that makes a disclosure pursuant to subsection of this section could be just immune from civil liability. Provide that protection. Make it voluntary, provide the protection. Provide an avenue for good faith. But requiring a platform to monitor content, now that gets into the whole data centers. Now we're going to have just that gets into other problems. Creating a duty creates a liability. Then the person has to weigh it. What if they fail in their duty? Now they have a liability. They had that responsibility, they failed. That's where you're going to get, I think you're going to get a lot of false positives. Because nobody knew what it was, or a duty to investigate. How do you know if you have a suspicion and then you have a duty to investigate? Then what do? You can't just wave it off. You can't just say, I don't think that was really, I might not be protected, I might not. So these are my concerns. And of course, we want to make sure that the information is only in response to lawful processes, meaning a warrant. How public is this data? We have a right, our founders created a right that was actually, they created that right against themselves, because when that right took effect, they were already, that was part of the Constitution. The war had already been won. That we have the right to be secure in our person, property, and effects. Does that mean we want to protect dangerous activity? No. It just means we have to balance this discussion We have to balance it, how the procedure works, what it is, not just here's a bill. Here's the stories, sign on. I think lawful processes are important. Not to protect so much, but to protect society. Does that provide some protection? Does that provide some cover? Perhaps, but is that a cover that we want to, is that a cover that we are willing to lose for everybody? When we talk about whether we're pro-law enforcement, sometimes it comes up. A country like China, they can arrest somebody for spitting on the sidewalk. Is that the society we want to live in? It's certainly safer. But we have to ask, because there are no solutions, there's only compromises. We can only, if we surrender our liberty for safety, we'll end up with neither. Maybe something like, if the law enforcement agency receives information pursuant to this section, they could seek judicial approval within 48 hours of obtaining that information. Yeah, let's deal with the actual problem, but let's not proverbially throw the baby out with the bathwater. Covered platform could establish a mechanism to receive lawful process or emergency disclosure requests. That makes sense. That's doing due diligence, but it's not turning our communications processes that becomes data, because if you have, well, it's already data, but more so if you have what would be the artificial intelligence if you're scouring your media 24/7, linking it, comparing it, judging it. You can ask them to make reasonable efforts to respond in a timely manner, but to require continuous staffing, compliance with specific response times. Now we're getting into dangerous territory. What we don't want is we don't want to delegate law enforcement authority, essentially, to a private entity, inadvertently or intentionally. We don't want a private entity to act as an agent of law enforcement. We need to be especially diligent not to write legislation that we feel is the solution, but we need to make certain that our laws, that our proposals are in accordance with the United States Constitution, not as just some roadblock, but as a tried and true, proven method of preserving the liberty of the citizens of the United States and Colorado. We're already dangerously close to losing all of these protections. We need to be very careful about those things that push us over, because once over that ledge, it's very difficult or impossible to come back. So again, anytime we have a bill like this, I am very concerned about crossing a line that should not be crossed. Because that line is usually a point from which you cannot return. So whether it's the First Amendment in speech, whether it's due process, whether it's the Fourth Amendment, and whether you're going to be secure in your person, privacy, property, and effects, whatever it's going to be, we need to be very vigilant about approaching such a line. So I'll be reading the bill much more carefully now. I appreciate the sponsor's amendments. I don't think we've addressed those issues, so for now, I'll be a no.
Is there any further discussion on House Bill 1255? Representative Story.
Thank you, Madam Chair. Just for brief clarification, this policy and Amendment L005 in particular only applies to posts that are generally open to the public. So a user is utilizing their First Amendment rights to post on a public platform. The platform specifies limits in their own policies which would result in an adverse action by the platform against a user's post. That adverse action is what would result in the platform noticing local law enforcement because they believed, the platform believed, there was a specific and imminent threat. The post was available to the public, and that these criteria are all met before the platform reaches out to local law enforcement, to then local law enforcement to decide whether to follow through with a search warrant process. So just wanted to be clear about that. And members, I urge an aye vote on this bill. It's about protecting communities from unbelievable trauma and PTSD, from incidents that don't have to happen, and saving lives. And I urge an aye vote.
Is there any further discussion? Seeing none, the question before us is the passage of House Bill 1255 as amended. All those in favor say aye. Aye. All opposed, no. House Bill 1255 as amended is passed. Madam Majority Leader.
Thank you, Madam Chair. I move the committee rise and report.
Seeing no objection, the committee will rise and report.
The House will come back to order. Mr. Shebel, please read the report of the Committee of the Whole.
Madam Speaker, your Committee of the Whole begs leave to part as under consideration the following attached bills, being the second reading thereof, and makes the following recommendations thereon. House Bills 1004, 1014 is amended, 1059 is amended, 1065 is amended, 1111 is amended, 1117 is amended, 1221 is amended, 1222 is amended, 1223 is amended, 1255 is amended, 1289 is amended, 1328 is amended, 1423 passed on second reading, ordered, engrossed, and placed on the calendar for third reading, final passage. Senate Bills 141, 142 is amended, 150 is amended, 151 passed on second reading, ordered, revised, and placed on the calendar for third reading and final passage.
Thank you, Mr. Shebel. Appreciate the applause. Members, Representative Wilford. Members, you have heard the motion. We do have amendments at the desk. Mr. Shebel, please read the Johnson Amendment to the Committee of the Whole report.
Representative Johnson moved to amend the part of the Committee of the Whole to reverse the action taken by the committee in not adopting the following Richardson Amendment L57 to House Bill 1289 to show that said amendment passed, that House Bill 1289 is amended passed.
Representative Johnson.
Thank you, Madam Speaker. I move the Johnson Amendment to the Committee of the Whole and ask that it be properly displayed.
One moment. It is properly displayed. Please proceed.
Thank you, Madam Speaker. Colleagues, what this amendment does is it leaves the it leaves the motor and special fuel loss in transit allowance to 2%. In the bill, it cuts it to 1%, and this will be detrimental. We are asking to keep it at 2% because the Colorado's motor and special fuel excise taxes allow distributors a 2% loss in transit and unloading deduction from taxable gallons to account for unavoidable evaporation and handling losses. This is something that occurs naturally, and we should allow for the industry to adapt to that. House Bill 26-1289 reduces this allowance from 2% to 1% for tax periods beginning on or after January 1st of 2027. What does this mean? Well, it means we're going to see probably increases at the gas pump for the people of Colorado. In an effort to save the state money, by reducing this, they're going to have to make up for these costs somewhere because of the losses. Where are those costs going to come from? Instead of the $4 or $5 in some areas across the state, it could be $6 or $7 or even more dollars per gallon. That is going to hurt Coloradans. The state auditor's evaluation notes the loss in transit allowance was set to reflect typical evaporation and handling losses and is meeting its purpose at 2%. Lowering it to 1% assumes distributors can eliminate physical losses that are largely inherent to transporting liquid fluid. Liquids evaporate. That happens. Distributors cannot, mitigate that. What I'm asking is a yes on this amendment to allow for us to stay where we are so Coloradans don't have to pay the price.
Seeing no further Representative Garcia.
Thank you, Madam Speaker. Members, I just ask that you vote no on this amendment, and let's just preserve the careful calculations that are in 1289.
Thank you. Seeing no further discussion, the motion before us is the adoption of the Johnson Amendment to the Committee of the Whole report. Mr. Shebel, please open the machine and members proceed to vote. Representative Leader, how do you vote?
No.
Representative Leader votes no. Representative Stewart, how do you vote?
No.
Representative Stewart votes no. Representative Martinez, how do you vote?
No.
Representative Martinez votes no. Representative Goldstein, how do you vote? Representative Goldstein, you're on mute.
No.
Representative Goldstein votes no. Representative Kelty, how do you vote?
No. Or yes.
Representative Kelty votes yes. Representative Sukla, how do you vote? Representative Sukla, I didn't hear you. How do you vote?
Yes, ma'am.
Representative Sukla votes yes. Clifford, Foray, Lindsay, Morrow, McCormick, Valdez, Weinberg. Please excuse Clifford, Foray, Lindsay, Morrow, McCormick, Valdez, and Weinberg. Please close the machine. With 19 aye, 36 no, and 10 excuse, the amendment is lost. Mr. Schiebel, please read the first Marshall Amendment to the Committee of the Whole report.
Representative Marshall moves to amend the report of the Committee of the Whole to receive action taken by the committee in not adopting the following Marshall Amendment L45 to House Bill 1289 to show that said amendment passed, that House Bill 1289 is amended passed.
Representative Goldstein, would you please mute yourself? Thank you. Representative Marshall.
I move the first Marshall Amendment to House Bill 1289 and ask for it be displayed.
I'll have you move it to the report of the Committee of the Whole.
I move the first Marshall Amendment to the Committee of the Whole report and ask for it to be displayed.
Yes, thank you. It is properly displayed. Please proceed.
Colleagues, I had to take a quick look at that because misplaced the two amendments somewhere along the line, so I had to see which one was up there. I wasn't planning on running this amendment, but after I walked off the floor, I actually had a couple Democratic aides come up and talk to me and said they listened to it and were hearing it. They couldn't hear it very well because there was so much noise going on. I know there wasn't much people listening in the chamber at the time. But they listened and they heard. This is to strike out the electric vehicle tax credit. And the reason we're bringing it is not because we don't want to reduce emissions, not because we don't believe in climate change. We're doing it because it's extremely poor tax policy. The Congressional Research Service, the nonpartisan Congressional Research Service, put out very good reports showing 67 to 77% of the people getting those EV credits would buy the vehicle anyway. So the inframarginal buyer we're not getting bang for our buck at all. They predicted that there would be about a 27% drop off in EV sales, and I had a very strong supporter argue with me, a supporter of the EV credits, argue that, oh, but they've totally collapsed. I was like, where's the citation? We got the citation, it wasn't there. We went to a graph from an EV group, and the drop off was 27%. Exactly what the Congressional Research Service was predicting. And that's with a $7,500 tax credit. We're trying to double it to $2,000, so the impact is going to be way, way less. And then the Congressional Research Service, who has access to all the IRS tax data, gave good data, and you can look this up, the Congressional Research Service, Economic Analysis of Electric Vehicle Tax Credits. Just Google it. The distribution of those tax credits, 50% go to the top 5% of incomes, 50%. Only 3% of those tax credits go to the bottom 60%. This is the one tax provision that we're doing in the entire Colorado Code that benefits my district immensely, but my constituents don't want it. It's not the right thing to do just because it is an extremely inefficient program, very wasteful for upper income people, and it's not doing the job the tax is supposed to. So please support the amendment. Thank you.
Representative Brown.
Thank you, Madam Speaker. Colleagues, I ask for a no vote. As I mentioned during debate on second reading, EV sales are down. What we're trying to do is to increase the EV credit, not to the full amount that was existed in the federal requirement or the federal policy prior, but we are trying to mitigate those losses. EVs are important, and especially now, with gas prices, as I mentioned, in my district near my home at $4.59, It is much cheaper to power an EV than it is to fill it up with gasoline these days. So this is good policy for the climate. It's good policy for people's pocketbooks. And it is low to moderate income households who are benefiting this because almost a third of EV buyers have household incomes less than $1,000. We ask for a no vote.
Representative DeGraff.
Talk about very different information. But I just thought I'd reaffirm for everybody here that, looks like at least most of the gangs here, that the subsidies on these EV toys for the rich are probably in the lines of $50,000 per vehicle. The manufacturers have been more or less eager to get rid of them. I mean, when they started making them, they said, well, there's no business case to make for creating them because they don't actually save energy, they don't actually reduce pollution, they just put it someplace else reliant on slave labor and eco-raping manufacturing. So $40,000 to $50,000 per vehicle is displaced onto other vehicles or tax credits. And when you're looking at the cost of filling up your tank at $4 per gallon, yep, that's a lot. The cost to fill an EV is the equivalent of $17 or more dollars, probably closer to $18 now, which means that your neighbors are just paying for it. So the EV toys for the rich are being paid for by the citizens of Colorado, and then you're filling up your tank is being paid for by your neighbors. That's what I call a parasite.
Seeing no further discussion, the motion before us is the adoption of the first Marshall Amendment to the Committee of the Whole report. Mr. Schiebel, please open the machine and members proceed to vote. Those online, please turn on your cameras and then turn them off when I have called your name. Representative Stewart, how do you vote?
No.
Representative Stewart votes no. Representative Leader, how do you vote?
No.
Representative Leader votes no. Representative Martinez, how do you vote?
No.
Representative Martinez votes no. Representative Lindsay, how do you vote? You're on mute.
No.
Representative Lindsay votes no. Representative Sukla, how do you vote?
Yes, ma'am.
Representative Sukla votes yes. Representative Kelty, how do you vote?
Yes.
Representative Kelty votes yes. Representative Goldstein, how do you vote?
No.
Representative Goldstein votes no.
Good evening.
Please close the machine. With 21 aye, 34 no, 10 excused, the amendment is lost. Mr. Schiebel, please read the second Marshall Amendment to the Committee of the Whole report.
Representative Marshall moved to amend the part of the Committee of the Whole to reverse action taken by the committee not adopting the following Marshall Amendment L65 to House Bill 1289 to show that said amendment passed, that House Bill 1289 is amended passed.
Representative Marshall.
I move the second Marshall Amendment to the Committee of the Whole report and ask for it to be displayed.
Please proceed.
Members, this was another one where I was not had planning on running it on the Committee of the Whole report, but had some other colleagues bring it to my attention that it is a huge statement for what we're doing here in this Capitol when we are cutting everybody else, devastatingly cutting everyone else. And we will have to do it in the next session too. Unless things radically change, we are going to be facing the same situation. So in that context of just allowing us and all the state elected officials to have all pay raises from 6% for this body up to 45% for the Attorney General, when we are slashing everyone else in the state, that's poor, poor leadership. I asked, and hopefully we'll get a late bill request to do it the right way, to just delay the pay increase 1 year. But we can't be certain of that. So the best way we can show that we are with our constituents and willing to accept a small bit of the pain that a lot of them are experiencing and will experience, is to vote yes on this amendment. Thank you.
Representative Luck.
Thank you, Madam Speaker. Truth be told, when this amendment came forward, I really thought it was a tongue-in-cheek amendment to point out the hypocrisy of some of the tax policy and conversations in this building. And so when I supported it in those two veins. That being said, I have been thinking about this a little bit more, and it is an interesting question. Two things related to Tabor. First is, as relates to having different tax rates for people. One could argue.
Representative Luck, we will go into a brief recess. The House will come back to order. Representative Luck, I apologize. You are still on your first 10 minutes, first time to speak. You have 9 minutes, 21 seconds remaining.
Thank you, Madam Speaker. Who knew? Tax policy. And yeah. All right, where was I? I'm not really sure. I guess what I was trying to articulate was that while I initially supported this with a bit of tongue-in-cheek in light of the overarching conversation, I have given thought to the underlying arguments against this. The first argument being that Tabor doesn't allow for different income tax rates for different people, that there is this flat rate. But the reality is our tax credits, tax expenditures, all of that structure is actually allows for different income tax rates. Because ultimately, if you can check different boxes on that form for different tax credits, you are paying a different amount than other people who maybe make the exact same salary as you, but can't. For instance, because I have a little one, even though we all make the same amount in this building, assuming we all just had this one job, which that's not a fair assumption, but let's just say for sake of argument it is, then I am paying a different rate than someone who can't check the box for that the child credit. So in any case, then that particular argument falls flat vis-a-vis this particular amendment because it really is one and the same. The second argument is that any tax increase has to go to the voters, the people, the taxpayers, the people who will be impacted by it. Well, fancy that. We are the people that are going to be impacted by that. So assuming that this were to pass by more than 4, or 5, right? If the differential is more than 5, let's say it's 40 to 25, then presumably, because we're calculating in the governor and lieutenant governor and secretary of state and what have you, presumably the vote count is more than half in support of this, such that we sent it to the people who would be impacted, i.e. us. And we agree that indeed this is the right way forward. And if there is that differential, then, well, the taxpayers, the people who would be subject to this, have spoken. So I just wanted to put that on the record in light of those two particular arguments for food for thought.
Representative Soper.
Thank you, Madam Speaker. Members, I actually object to this amendment even being here at all, and would ask that the sponsor might consider withdrawing that. And that's on the basis of the fact that it pits two things against each other. One is it's asking members to basically vote for a pay raise. On the other hand, it's saying, do you want to violate the Taxpayer Bill of Rights? Both are lose-lose propositions and ones that we shouldn't be placed into asking. The other problem with this amendment is any member who's likely to come back next year should really take a 21C because this will directly impact their compensation for next year. And depending on how you vote, that raises major ethical questions. And that's why this particular amendment is inappropriate. It should not be put to the test of the membership of the House of Representatives because we created a mechanism, whether you liked it or not, for an independent committee task force to review compensation and to make recommendations. I happen to disagree with that, but that was the process laid out to take all questions of compensation out of the hands of this body. And this amendment, it brings it right back to the House of Representatives for us to have to vote on compensation. And if you don't want to vote on the compensation, now you're looking at violating the Taxpayer Bill of Rights. Both are propositions that put every single member of this chamber into a lose-lose situation, which is why I would humbly ask that the sponsor of this amendment withdraw this amendment. Thank you.
Minority Leader Caldwell.
Thank you, Mr. Speaker Pro Tem. For all the reasons that my colleague just laid out, I'm going to request to be excused on this, and I imagine maybe some of my colleagues will too. There was a task force set up that reviewed and established legislator pay, not something that we voted on as far as increasing our pay raise. And it's something that if I vote one way, it violates a principle, but if I vote the other way, I feel it's a violation of the Taxpayers' Bill of Rights. So if this amendment does go forward, as my colleague said, I would ask that the sponsor of this amendment withdraw it, but I will request to be excused for this vote. Thank you.
Further discussion? Representative Caldwell will be excused from the vote on this amendment. Further discussion, Representative Zokai.
Mr. Speaker, Pro Tem, I would like to request a 21C as well.
Representative Zokai will be excused according to Rule 21C. Representative Johnson.
Per the rule of conflict, Mr. Speaker Pro Tem, I ask to be excused.
Representative Johnson will be excused per Rule 21C. Mr. Assistant Minority Leader.
Per 21C, I ask to be excused from this vote.
Representative Winter will be excused per Rule 21C. Representative Camacho.
In the fairness and consistency, I request a 21C on this vote.
Representative Camacho will be excused per Rule 21C. One, folks, members. Representative Marshall. Representative Marshall, would you like to speak? Representative Marshall. Representative Marshall. This is your second time to speak on the amendment.
Thank you. Due to the great number of profiles and courage, I'm going to have to withdraw this amendment. And I do withdraw the amendment.
Seeing no objection, the amendment is withdrawn.
The motion before us. Representative Taggart, the amendment has been withdrawn. We are now moving on to the motion before the body. Thank you. The motion before the body is the adoption of the Committee of the Whole report. Mr. Schiebel, please open the machine, and members proceed to vote. Members who are participating remotely, please turn your cameras on and turn it off when you have voted. Representative Stewart, how do you vote?
Yes.
Representative Stewart votes yes. Representative Leader, how do you vote?
Yes.
Representative Leader votes yes. Representative Kelty, how do you vote?
No.
Representative Kelty votes no. Representative Martinez, how do you vote?
Yes.
Representative Martinez votes yes. Representative Sukla, how do you vote?
No, ma'am.
Representative Sukla votes no. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Goldstein, how do you vote?
Yes.
Representative Goldstein votes yes. Representative Wynn, how do you vote? Oh, there you are, Representative Wynn. Two places at once. Representative Brooks, we see that you are here. Mr. Schiebel, Morrow voted yes. She is excused on the wall. Please close the machine. Oops, sorry. Please close the machine. With 38 aye, 19 no, and 8 excused, the report of the Committee of the Whole is adopted. Madam Majority Leader.
Thank you, Madam Speaker. I move to lay over the balance of the calendar till later today.
Seeing no objection, the balance of the calendar will be laid over until later today. Mr. Schiebel, reports of committees of reference.
Committee on Business Affairs and Labor, after consideration of the merits, the committee recommends the following: House Bill 1424 be amended as follows, and also amended referred to the Committee of the Whole with favorable recommendation.
Printing report.
The chief clerk reports the
Printing
following
report
bills.
will be printed in the journal. Signing of bills, resolutions, memorials.
The speaker has signed.
Signing of bills, resolutions, memorials will be printed in the journal. Delivery of bills to the governor.
The chief clerk of the
Delivery
House
of bills to the governor will be printed in the journal. Message from the Senate.
Madam Speaker, the
Message
Senate
from the
has
Senate
passed.
will be printed in the journal. Message from the reviser.
We herewith transmit.
Message from the reviser will be printed in the journal. Introduction of bills.
House Bill 1430 by Representatives Basenecker and Sirota, also Senators Lindstedt and Amabile, concerning adjustments to transportation funding.
House Bill 1430 will be assigned to the Committee on Transportation, Housing, and Local Government.
Senate Bill 134 by Senators Lindstedt and Judah, also Representatives Duran and McCluskey, concerning the imposition of fees by payment card networks.
Senate Bill 134 will be assigned to the Committee on Finance.
Senate Bill 138 by Senators Doherty and Mullick, also Representative Stuart Kay, concerning measures to reduce the administrative burden on the healthcare system.
Senate Bill 138 will be assigned to the Committee on Health and Human Services.
Senate Bill 165 by Senators Robertson Peltonar, also Representatives McCormick and Soper, concerning measures to support species conservation and in connection therewith authorizing an appropriation from the Species Conservation Trust Fund.
Senate Bill 165 will be assigned to the Committee on Agriculture, Water, and Natural Resources.
Senate Bill 172 by Senators Hendrickson and Kipp, also Representatives Basenecker and Pascal, concerning the Front Range Passenger Rail District.
Senate Bill 172 will be assigned to the Committee on Transportation, Housing, and Local Government. Announcements and introductions. I have an announcement. Oh, I'll let you go first, Representative Brown.
Thank you, Madam Speaker. House Appropriations Committee will be meeting in the Old State Library upon 5 minutes upon adjournment. We will hear one bill. It will be Senate Bill 149. Senate Bill 005 will be laid over until Monday. On Monday, we will be meeting at 8:30 in the morning. We will hear 5 bills: Senate Bill 5, Senate Bill 1016, House Bill 1016, House Bill 1272, House Bill 1428, and House Bill 1326. So see you in 5 minutes upon adjournment, committee members.
I have an announcement. Representative Gilchrist will replace Representative McCormick on House Appropriations for today's upon adjournment hearing only. Madam Majority Leader.
Thank you, Madam Speaker. Members, we are breaking so appropriations can meet, so please don't go very far. Madam Speaker, I move the House stand in recess until later today.
The House will stand in recess until later today.